break until that glitch is resolved. I will let you know as
It looks like it's up. Wait, it looks like it's running.
Okay, I'm going to wait till the committee clerk gets back to her desk so she can confirm that on her end. Soupy, if you can hear me, or we're good?
Yes. If you don't mind holding, because one of my screens says no and one of them says yes, so I need to double check.
You let me know when you're ready to proceed.
I'll be happy.
I received a message from a person who's attending saying that they are attending and it is live now.
Right. I saw that in the chat, but I just need to confirm it on our clerk's end as well. Just ask for your patience to all those who can hear at this or on YouTube or are a panelist or in the attendee room until the committee clerk verifies that we can move forward. Thank you for your patience. It seems that the goddess of technology has smiled down upon us and we may begin again. Again, my name is Tom Harnett. I will be chairing this morning's meeting where we have a series of public hearings. For our first public hearing, we are using American Sign Language English interpreters. I will explain that process after doing committee introductions. And I will begin the committee introductions again in the order that people appear on my screen, starting with my co-chair, Senator Carney.
Thank you very much, Chair Harnett. My name is Ann Carney. I'm a state senator. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And I will be in and out of the Judiciary Committee meeting today, as I have bill hearings in other committees as well. Thank you.
Thank you, Senator Carney. Representative Moriarty.
Morning all, I am Steve Moriarty, representing House District 45, which is Cumberland and part of Gray.
Thank you, Representative. Representative Poirier.
Thank you, Mr. Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you, Representative. Senator Keim.
Morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County and two communities in Androscoggin.
Thank you, Senator. Representative Libby.
Thank you, Mr. Chair. My name is Laurel Libby, and I represent District 64, which is part of Auburn and all of Minot.
Thank you, Representative. Representative Babbage.
Thank you, Mr. Chairman. Good morning. My name is Christopher Babbage. I am privileged to represent House District 8, which is most of the town of Kennebunk.
Thank you, Representative. Representative Thorne.
Thank you, Mr. Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in fabulous Penobscot County.
Thank you, Representative. Representative Sheehan.
Thanks, Mr. Chair, and welcome everyone. My name is Erin Sheehan, and I am proud to represent Biddeford's House District 12.
Thank you, Representative. Representative Evangelos.
Thank you, Mr. Chair. Welcome, everyone. Representative Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you, Representative. Representative Newell.
Thank you, Mr. Chair. Good morning, everyone. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Thank you, Representative. And Representative Reckett.
Yes, my name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thank you. And on our first bill today, which I will introduce in a second, or introduce the sponsor, LD 1336, we are using the services of 2 American Sign Language English interpreters, Mary Jane and Margaret, and we welcome them to the committee. A couple of things that I want to highlight, and I will ask them to chime in if I am not making myself, if I'm not explaining things fully. Their job is a difficult one. We need to ensure that all of the public that are participating in today's hearing are able to fully participate, particularly when people are reading testimony. If you could slow down your reading and take a breath every now and then, so that the interpreters can do their job. And when speaking, I would ask the same thing, that we take a breath and realize that somebody is trying to interpret everything that we say. We have few people signed up to testify today, so I am not going to be using the 3-minute clock because I think it will make things go much more smoothly. And with that, before I begin, are there any questions from committee members about how we will be proceeding with the use of the interpreters? Seeing none, I will now open the public hearing on LD 1336, an act to discontinue the use of the terms handicap, handicapped, and hearing impaired in state laws, rules, and official documents. I will first call on the sponsor, then I will call on people testifying in support of the bill, and those opposed, and then those who are neither for nor against. And with that, I welcome to the Judiciary Committee, Representative Ziegler. Representative, nice to see you this morning. And please begin your presentation as soon as you're ready.
Good morning. And I'm going to ask the question that we always ask when we come out of that tunnel. Is everything copacetic with the sound?
Absolutely. The sound is perfect and your bow tie is radiant. So you can proceed.
I'm taking a few minutes to take that in.
Okay.
And feel better about myself. Thank you, Representative Harnett. Good morning, Senator Carney, Representative Harnett, and distinguished members of the Committee on Judiciary. My name is Stanley Page Ziegler, and I represent House District 96, consisting of the towns of Belmont, Liberty, Lincolnville, Montville, Morrow, Palermo, and Searsmont. I am here today to introduce LD 1336, an act to discontinue the use of the terms handicap, handicapped, and hearing impaired in state laws, rules, and official documents. As legislators, we know the importance of language. To enlist your support for this bill, I have to be very careful what words I choose to use. Words are power. They can build up or they can tear down. As legislators, we craft bills which have consequences on individual lives. How we define those individuals can reflect how they may be seen in society. What words we use have impact. If we don't have input from the groups that are impacted from the statutes we develop, then we are making assumptions about those individuals, which have consequences on individuals' lives. How we define those individuals and how they may be seen in society, what words we use have impact. If we don't have, I'm sorry, what happened is that there was some noise in the other room, and I went back to the previous paragraph. So if you will accept my apologies, I will go to the paragraph that I should be on. We are making assumptions about those individuals. This may not be done with any malice, but it can be done without consultation or consideration. I've been on the Commission for the Deaf, Hard of Hearing, and Late Deaf for 4 years now, and I was approached by individuals to sponsor this bill through my time with the Commission. I lost part of my hearing late in life. I have to compensate, but that does not make me any less than others. However, I came to this condition late in life and have not from an early age had to deal with the terms that may imply I am not equal as a human being. The deaf community in Maine is a very proud and a very active community, and they deserve our respect. We can give them that respect by removing those specific terms that they feel do not define them. This bill does not force anyone who wants to still use the language to define themselves as handicapped or hearing impaired from being able to do that. Again, I apologize for getting lost in my presentation, but actually it was my hearing aids that clicked in. So obviously there are some technical problems with trying to compensate for my inability to hear well. Thank you for your time and consideration. There will be people coming behind me, and there will be testimony to read in regards to this.
Thank you very much, Representative Ziegler, for bringing this important bill forward. And as we do live in a world of words, the words that we choose are very important. And I agree that words can be very powerful and sometimes hurtful, even if no insult or hurt is intended. I will now ask if there are any questions from committee members for the bill's sponsor, Representative Ziegler, and I will begin with Representative Moriarty.
Thank you, Mr. Chair, and good morning, Representative Ziegler. If I don't know who's scheduled to speak following your presentation, so if my question needs to be passed on to someone else, don't hesitate to do that. The question may reflect some insensitivity on my part or some lack of awareness, but here it is. When the bill speaks about vision, it uses the term blind or visually impaired. When the bill speaks about speech, it uses the term speech impaired. However, when it refers to hearing, it uses the term hard of hearing and deletes the word impaired. What is the significance of the change, and why aren't we using consistent terminology?
Thank you, Representative Moriarty. And when this bill was presented to me in regards to and from the Commission on the Deaf and Hard of Hearing, and so they were oriented towards basically hearing impaired. And we started with that. And then there was input that they wanted to reduce the terms handicapped. And I'll let the people coming behind me discuss that, but there was no input from other communities at this point, as I understand it. And that's why it's specific to that.
So what is the distinction with respect to hearing loss?
That should be answered by the people who have come to me with this bill.
Okay, thank you.
Thank you, Representative Moriarty. Are there additional questions for the bill's sponsor from members of the committee? Seeing none, again, Representative Ziegler, nice to see you, and thank you for bringing this bill before the committee. I don't know your schedule for today, but you are welcome to remain as a panelist for the remainder of this public hearing.
Thank you. I'm voting in both ENR and EUT, so I really need to move over to those other committees, and thank you for allowing me to present this bill.
You're very welcome. I will now turn to persons who have registered to testify in favor of LD 1336, beginning with Carrie Pierce. If Carrie, she has already been moved over as a panelist. Carrie Pierce, when you are ready to testify, if you could unmute your microphone and activate your video, and then begin to testify as soon as you feel comfortable. Right now, your microphone.
Yes,
okay.
I won't need a microphone.
Oh. Okay, you can begin your testimony as soon as you are ready.
Thank you so much. My name is Carrie Pierce. Can you see me? Yes.
I can.
I live in Belfast. I'm a deaf individual. I'm an instructor of American Sign Language in the University of Maine system. I grew up with the word hearing impaired, and I will say that that had an influence on me, a negative influence, because it infers that something was broken about me that needed to be fixed. The comments that were just recently made around the word impaired for speech impaired and visually impaired. I will say that the deaf community has a very vibrant cultural aspect, a language aspect, and that folks who are visually impaired or speech impaired do not recognize themselves and identify themselves as members of a community with a cultural identity, which is very distinct from the deaf community. When I work with my students, I work very hard to instill in them an understanding that members of the deaf community are proud members of a community, that we embrace a culture that is distinct from the larger community culture, that we use American Sign Language proudly and do not view ourselves as broken individuals. I think that changing this language will do much to show that mutual respect for individuals and to respect the wishes of a community. And the idea, this would be helpful to me in terms of how I've been raised as well. It's hard for me to see the interpreter, so I'm a little bit feeling a little awkward with this. I can see Margaret, but she's teeny tiny. And that's all I've come here to say today, but I'm certainly welcome to answer any questions from committee members.
Thank you very much, Ms. Pierce, for being here with the committee this morning and for providing your testimony today. I am now going to ask committee members if they have any questions for you. Are there any questions from committee members for Ms. Pierce? Representative Moriarty.
Thank you, Mr. Chair. So Ms. Pierce, just to clarify, your point is that that those with loss of hearing view themselves as part of a community, but the same is not true for those who have difficulties with vision or speech. And if that is the point, do you know that that is so with respect to those other groups of people?
I think that the most important thing is for people to ask those members of those communities and people who identify themselves as having a visual impairment. All that I can do today is speak on behalf of my community. I can't speak on behalf of those who have a visual impairment or a speech impairment, but I can very strongly speak on behalf of my community as to our feelings about that term.
So was any effort made to reach out to the other communities in the drafting of this bill?
I am making an assumption in answering that we haven't yet done a full inquiry with that community, but I cannot answer for sure.
Thank you then.
Thank you, Representative Moriarty. I do note that we have a person testifying from Disability Rights Maine later in the hearing. That might be an appropriate question to address to that representative as well.
Good.
Are there other questions of committee members for Ms. Pierce? Seeing none, again, Ms. Pierce, I thank you very much for your time today. We appreciate you being here. You're welcome. I will now turn to our next witness, and I have that person listed as Satara Sheikh. If she could be moved over. Committee clerk, if she is in the attendee room.
And I believe that Mr. Thomas Minch has been moved up. This is the interpreter speaking.
Right, I see that. I'm trying to go on a list that I have, but as we have Mr. Minch, I will welcome Thomas Minch to the Judiciary Committee. When you are ready to proceed, if you could activate your video.
And yes, indeed. I'm here. Good morning, everyone. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Thomas Minch. I am an advocate for Disability Rights Maine. DRM, as it is known, is Maine's protection and advocacy agency for people with disabilities. Our mission is to ensure autonomy, inclusion, equality, and access for people with disabilities in Maine. I appreciate the opportunity to provide testimony in support of LD 1336, which proposes to discontinue using the terms handicapped, and hearing impaired in all state laws, rules, and documents. The terms handicapped, and hearing impaired are outdated and oppressive. They focus on the limitations of people with disabilities and deaf, hard of hearing individuals. The passage of the Civil Rights Act of 1964 gave inspiration to people with disabilities. By the 1970s, society began to realize that terms like cripple, lame, and gimp were negative. Rather than focus on the individual, those terms referred to deficits and limitations. In time, the word handicap was replaced with disability. In referring to people with disabilities, it is preferable to use language that focuses on the person rather than on the disability. We should refer to all people in terms of what they can do, not what they cannot do. Therefore, the use of the terms handicapped, able-bodied, physically challenged, and differently abled are discouraged. The Americans with Disabilities Act has already enacted the use of the word disability in replacement of handicap more than 30 years ago now. It is time for the rest of us to follow suit. It will take a conscious effort, but the change is necessary. As a deaf individual who comes from a deaf family, the term hearing impaired is outdated and a way to collectively label people with any level of hearing loss. It does not account for cultural identity. The term hearing impaired is a negative one. Again, it focuses on what people cannot do. It establishes the standard as hearing. Anything different is seen as substandard, hindered, damaged. Many individuals who are deaf or hard of hearing prefer the terms deaf and hard of hearing because they are considered to be more positive than the term hearing impaired, which again implies that a person is less than whole. In 2018, I was part of a similar legislative effort in New Hampshire. That bill, HB 1785, passed the House and Senate with no opposition and was signed into law by Governor Sununu on June 18, 2018. I hope that Maine will be the second New England state to recognize that the terms handicap, handicapped, and hearing impaired are outdated and oppressive. Disability Rights Maine respectfully asks the committee to vote ought to pass on LD 1336 and adopt a language that is inclusive and recognizes the individuals and not their disability. Thank you so much for your time and attention.
Thank you very much, Mr. Minch, for coming before the Judiciary Committee today and providing your testimony and sharing your story and the power of words as they are directed at you. We greatly appreciate your input. Are there questions from committee members for Mr. Minch? Representative Moriarty.
Thank you, Mr. Chair. Mr. Minch, I completely agree with you on the deletion of the terms handicap and handicapped from various statutes. But I wonder if you can tell me if those with vision problems and those with speech problems were included in the effort to modify these statutes, because in the case of both vision and speech, the term impaired remains. That's my question.
Thank you so much, Representative Moriarty, for that question. I agree that, well, let me start with saying that the Commission for the Deaf, Hard of Hearing, and Late Deafened started action on looking towards drafting this bill and getting this bill heard by this committee and by the full legislature. As Ms. Pierce mentioned, often those terms are used, hearing impaired, handicapped, and handicapped are seen as outdated in society. If we talk about impaired, speech impaired, and visual someone with visual impairment, they will have their own choices around identity and around whether or not they prefer to use those terms for themselves. So we did feel that it was best to focus at this moment in time on handicap, handicapped, and hearing impaired.
Okay, thank you.
And the just to reiterate, we did not include in our discussions members of the community. Go ahead, Manager.
I was not involved in that process initially when the conversations were happening within the group.
So the groups were simply not involved. The visual and the speech groups were not involved.
I'm sorry.
And this is Mr. Minch again. I believe that the best individuals to ask would be individuals who are members of the Commission for the Deaf, Hard of Hearing, and Late Deafened, since they were taking the pulse and getting a sense from the larger community as to the purpose of this bill.
Thank you.
Thank you, Representative Moriarty. Representative Thorne.
Thank you.
Thank you, Mr. Chair. And I'll kind of follow along in the footsteps of Representative Moriarty in saying that, forgive me for being naive about this, but the term handicap, in other words, it's okay if we use it in the term of golfing, but not to describe an individual. And the same with impaired. If someone is driving while impaired, is that something that we're being offensive by saying that and not knowing it? Or is that just something that is unique to the hearing, hard of hearing and deaf?
Thank you for that question, Representative Thorne. It is very different in the game of golf. That is an appropriate term that they use within the culture of golf. However, when it comes to individuals and how they identify themselves, I consider myself to be deaf. I do not consider myself to be hearing impaired by any means because I'm functioning as equal to anyone else. I just don't hear. I drive, I walk, I do many, many things in my everyday life. However, the terminology is very limiting when we talk about impaired. In our culture, the folks in our culture and community can do many, many things. Now, however, when you're talking about driving impaired, that's a completely different meaning. So when we talk about individuals, then we really need to take into consideration how one identifies themselves, especially when they affiliate with a cultural group. So that has a very different connotation.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Babbage.
Thank you very much, Mr. Chairman, and thank you for this discussion. It's an education for me, and I'm sure for many others, so I appreciate this. The question of impairment is intriguing because I'm understanding what you're saying, but I'm also trying to understand the community in which we're addressing. Perhaps you could help me with the definition of deaf. And my question is there a hearing impaired community, to use the term that you don't care for, but a community whose hearing warrants consideration by others, for instance, that is not part of the cultural sign language community, or is there one voice in all of this? Thank you for answering.
Thank you, Representative Babbage. That's a wonderful question. As I said earlier, I identify myself as a deaf individual. I was born to a deaf family. My parents are deaf. My brother is deaf, and we are a culturally proud deaf family. The term deaf has two different meanings. There is lowercase d deaf, and then there's uppercase d deaf. Lowercase d deaf are individuals who may have lost their hearing later in life. They may be hard of hearing and have some residual hearing and don't identify necessarily with the culturally deaf group. They may or may not use sign language. However, those who are capital D or culturally D deaf are those that are part of that cultural minority group. They share the same language, values, culture, and community. So there are different terminology. There's different terminology within the deaf community. Now, I realize there's many other communities that may have the term impaired. However, when we talk about the deaf community and deaf culture, we are a proud group of deaf individuals who identify ourselves as those who are equal to anyone else. We happen to be part of a cultural minority group. And the term impaired gives a negative connotation, and it has sort of a pejorative view of us individuals who are deaf, who consider ourselves to be proud deaf individuals. And that becomes limiting in many, many ways by virtue of just the perspective of who we are as individuals. The term hearing impaired may have worked back in the 40s, 50s, and 60s when oppression was alive and well. However, given the new day and age, we are really looking to start to change how we use language and how we view individuals who are part of cultural minority groups and a part of the larger society in general.
Thank you for that. Thank you.
Thank you, Representative Babbage. Are there additional questions for Mr. Minch from committee members? Seeing none, again, Mr. Minch, the committee thanks you very much for taking the time out of your day to testify on this subject. We appreciate your input and you sharing your personal story. Thank you, sir.
Thank you. It's a pleasure to be here. Thank all of you for having me.
Seeing no additional questions, I will move to our next person registered to testify, and that is Satara Sheikh, who will be moved over as a panelist in just a second. She was in the attendee room. And Supi, I am not seeing her moved over. Am I missing something? She was just there. Okay, we are having some problems finding Ms. Sheikh, but I have also learned that we have a member of our committee who would like to testify in favor of LD 1336. So I would recognize Representative Galgay-Reckitt.
Thank you. First of all, I apologize for not noticing this bill in time to prepare written testimony. But as the discussion has unfolded, I am compelled to mention one of the most incredibly changing, a really life-changing sort of experiences I had the privilege to have was when I was appointed by Governor King years ago as a member of the Baxter Compensation Authority. And so I spent several years helping to adjudicate the claims of the sexual abuse and physical abuse victims at Baxter School for the Deaf. But what happened to me in that experience was what I want to share today. And that was how I developed my own personal understanding and interactions with the community which has been speaking today. One of the things that happened is that I dealt with interpreters a lot. because all of the interactions were signed, or they were, I forget what the piece is called when it gets projected on the wall or something, but basically several different ways that communication happened amongst, there were 5 of us on the commission and 4 of us were here, could hear. And so it took a while for all of us to try to adjust, both to really embed ourselves in the whole concept of people with disabilities, and as opposed to people, deaf people, or whatever you want to call it, as an impairment, was not who those people were, or that we were. I had the opportunity to take courses in sign. I took several semesters. I wish I could remember what I learned, but I haven't practiced, and so I'm not able at this point. But what I do remember is that every 3rd class we had was focused on on deaf culture and how it operated and how it fed the community and how it had changed over time and what we could do to respect that community. And I think that what we need to do is to bring that, what I'm trying to do for myself, is to bring that into this discussion, because it's really important that we let the communities we're referring to identify, to name themselves, to identify as is important to them, because that's really who should own the identity of deaf people, is deaf people, and how they want to be referred to is their prerogative to say, not mine. And I've been, I think that I've had some experiences in my work life where not only did we work with one interpreter, but we worked with 2, because the person we were talking to was spoke Spanish, and all of the sign is not the same, and so we had to have people who would interpret the Spanish signer to the ASL signer so that we could then have the conversation. It's incredibly complex, but important. And you have to learn to talk slower. And there's some of us in this world who have a hard time with that. I'm not talking slow enough now, probably. But, and you have to interrupt your conversation so that there's time for interpreters to function. But I also, lastly, I just want to say that, as I mentioned earlier, one of the most transformative experiences in my life was serving on that commission, for which I'm extraordinarily grateful of the opportunity. But I also want to say that I have learned to admire and respect the interpreter community, who I think is just extraordinary in this state. And I think that we should be very proud that there are people who've stepped to the plate and done this. And I think, again, my major focus of my testimony is we need to listen to the communities involved and do what is right for them in their minds, because that's really all that counts. Thank you.
Thank you very much, Representative Reckitt. Questions from the committee, Representative Babbage.
Thank you, Mr. Chairman. I just want to follow my comments and Representative Reckitt's very on point communication. When I referred to hearing impaired in my question, I was really not trying to be disrespectful. I was trying to identify that there would be different measurements of hearing, and I was trying to find out if the community could speak as one voice, because there is the sign language community and then those that may not have learned sign language and may have different degrees of, I'll use the word impairment as a measurement. But I also want to express my apology for not being considerate in speaking slowly enough in my questioning. I mean, this kind of awareness is exactly what is the education needed to be considerate. And so I wanted to know there's certainly no malice in my ignorance in that regard. So thank you.
Thank you, Representative Babich.
If I could respond briefly, I think that we have to learn to forgive ourselves when we foul up. I mean, the point is to try to get it in the lane that the persons with whatever disability we're talking about want to name themselves. And do I do it perfectly? I've probably screwed up 12 times in my testimony because I didn't write anything down and I could have considered whether I had the words right. But, you know, I know too that at least in the deaf community with whom I've had interaction, that if they know you're trying to do what is respectful and appropriate, then they're quite forgiving and willing to instruct you in the error of your ways in a kind manner. I certainly have been instructed in the error of my ways over the years, and it's just, it has helped me grow as a person and as a community member. So I'm grateful for that.
Thank you. Are there additional questions from committee members? Seeing none, thank you very much, Representative Reckett, for your testimony. I will now turn to the attendee room to ask if there are any persons in the attendee room who wish to testify in support of LD 1336. If so, please raise your attendee hand. I do see a hand up, Soupy, but now it's gone. Is there anyone in the attendee room who wishes to testify? I see, I welcome Karen Hopkins to the Judiciary Committee. Nice to see you, Ms. Hopkins. You may begin your testimony as soon as you are comfortable.
Hey, hello, everybody. Good morning. Thank you for having us, Representative Harnett, Representative Carney, and esteemed members of this committee. My name is Karen Hopkins, and I am the Executive Director of the Maine Educational Center for the Deaf and Hard of Hearing, Governor Baxter School for the Deaf. I am in full support of LD 1336. I am a deaf adult who grew up in Northern Maine, never having met another deaf individual until the age of 18, when I stepped foot on the campus of Gallaudet University, where my world opened up. As a child, I did think of myself as impaired and handicapped. And when I met other deaf individuals, I realized there was an entire community available to me and other deaf and hard of hearing children and adults. I am also an individual with a visual impairment, and I can explain why I said that word afterwards. And I am a survivor of a significant traumatic brain injury. As I speak to you today, I represent these three communities, but most importantly, I am here to represent the hundreds of deaf and hard of hearing children throughout the state of Maine. MECDHH GBSD is Maine's leading deaf education agency, and we serve children birth through age 22 throughout our beautiful state. If you saw these children at home with their families, in their daycares, playing and learning at preschool on Mackworth Island, participating in mainstream classes in various schools throughout the state, participating in deaf education classrooms in our site-based program at Governor Baxter School for the Deaf, in our programs throughout the state, you would see children. You would see children that look and act very much like the children in your communities, in your homes, and children you are connected to. These children are dancing to dance recitals, participating in athletic teams, and being involved in theater and musical activities. These children are strong, they are resilient, and they are typical children that may not be able to hear. They are not handicapped, and they are not impaired in any way. These children are deaf or hard of hearing and are engaged in every aspect of their life. This bill that you are hearing today is to change the way that we as a state write about these children and adults who are deaf or hard of hearing and may have disabilities. The proposed wording presents these individuals in a positive manner, in a way that honors their identity, and our culture. The words handicapped or impaired are offensive to this community and offer a negative view of individuals and what they can accomplish. The deaf and hard of hearing individuals who have joined me here today do not think of themselves as handicapped or impaired. We think of ourselves as deaf or hard of hearing and are proud of our identity. When I was recovering from my traumatic brain injury, the word handicapped was used time and time again. At that time in my life, I was unable to walk, I was unable to talk, and I was unable to use my entire right side. The word handicap put limits on my recovery. After much thought and processing, I realized that that word was challenging me and it was pushing me down. I was feeling I didn't have the strength to recover. I turned around and chose to think of myself as an individual who at the time was disabled, but one whose full goal was to become able again. As executive director of MECDH GBSD, I am able. I represent the many able children and adults in our state and respectfully request that you support this bill and change the way that our state laws and documents depict individuals with disability. Thank you for your time and for your consideration. That was my written testimony, but I want to add a little bit more information about.
Ms. Hopkins, we're not running a clock today, but
Okay.
I do have to be sensitive to time.
Certainly.
So if you could summarize what you have to say and wrap up, please.
Certainly. Just know that there's been questions about the term visual impairment. And as an individual who cannot see well, I see triple and sometimes quadruple. I am impaired in my vision. I am not impaired in my hearing. The deaf and hard of hearing community is something that takes that impairment away. I have full access through the use of technology and interpreters in a way that I don't have with glasses and surgery. My vision cannot be corrected. Thank you.
Thank you very much for bringing your testimony before the committee today and sharing your personal story as well. Are there members of the committee with questions for Ms. Hopkins? Representative Libby?
Thank you, Mr. Chair, and thank you for being here today, Ms. Hopkins. My question is for Ms. Hopkins, but any other folks who have testified today. I apologize, I was at State and Local Government Committee for some time, so this may have already been addressed. It's always helpful to have written testimony submitted to be able to review that. So any folks that testified and would be able to submit their testimony in writing would be very helpful to refer back to. And thank you for being here today.
Thank you, Representative Libby. Are there other questions from committee members for Ms. Hopkins? Seeing none, again, thank you very much for all the work you do in addition to being here today to testify before us. I will now look to the attendee room to see if there are any other persons in attendance who wish to testify in support of LD 1336. Seeing no hands raised, I would ask if there are any persons in attendance who wish to speak in opposition to LD 1336 to please raise your electronic hand. Seeing none, I would ask if there are any persons in attendance who would like to speak neither for nor against LD 1336 to raise your electronic hand. And seeing none, before closing the committee, I would just point out to everyone involved that there has been a great deal of written testimony submitted on this bill. For some reason, there have been some technological problems. I am not seeing it where I usually get testimony, but it should appear eventually. And now, having heard from all persons present who wish to provide testimony on this bill. I now close the public hearing on LD 1336. I thank all persons who came before the committee, and I want to give particular thanks to our two interpreters, Mary Jane and Margaret. Thank you for helping us make this the best hearing possible. Greatly appreciate it. I am now going to turn to our next, well, I'm sorry, I should wait for the interpreters to finish. And are the interpreters?
Representative, we're all set. Typically we would, if we were in person, we would see that people had left. So if you wouldn't mind if I just check and see if there are any attendees who are staying.
Oh, okay, you may ask that, and you're free to stay if there are.
And my colleague is just asking if folks could put in the chat box if they would like us to stay on and continue interpreting for the next bill. And if not, we will depart.
Thank you. Thank you very much to both of you for your service today.
Thank you.
And I will now open the public hearing on LD 1270. And I will remind all those who are testifying other than the bill sponsor, who I'll introduce in a second, that I will be running the 3-minute clock moving forward for everybody other than the sponsor who's testifying. So with that, I will open the public hearing on LD 1270, an act to establish resentencing units in the Attorney General's office and all Maine prosecutorial districts. And I welcome our judiciary colleague, Representative Evangelos.
Thank you, Chair Harnett, and good morning, Senator Carney, Representative Harnett, and other distinguished members of the Judiciary Committee. I am Representative Jeffrey Evangelos from Friendship, and I represent House District 91. I am speaking today in support of LD 1270, an act to establish resentencing units in the Attorney General's office and all Maine prosecutorial districts. As the summary indicates, this bill requires the Attorney General and every district attorney to maintain a resentencing unit to review ongoing sentences of cases they prosecuted, to determine whether the sentences should be reduced or terminated in the interests of fairness and justice. The resentencing units are to review sentences that are disproportionate based upon the crime committed, especially for incarcerated people over 50 years of age or who committed their offense as a minor, sentences of at least 5 years when the release is 12 months away or less, sentences for felony murder when the person did not commit the killing or intend to kill, sentences for people with terminal or debilitating illnesses, sentences in which illegalities or irregularities may have occurred, and any other sentences that resentencing unit determines should be reviewed in the interest of fairness and justice. The resentencing unit makes a recommendation to the Attorney General or District Attorney, who may accept, reject, or modify the recommendations, and importantly, may file a petition for resentencing reviews at any time during the duration of the sentence to request the court for a reduction or termination of the sentence. And that emphasis is mine. Below, I will use a few examples to explain the vast sentencing inconsistencies that have occurred in Maine recently. This was a topic of conversation between judicial nominee Sarah Churchill and myself during her confirmation hearing for District Court Judge on February 9th, 2021. First, before America's era of mass incarceration took hold in the early 1970s, when Maine adopted the current criminal code on May 1st, 1976. The number of individuals in prison was less than 200,000 nationwide. Today, it stands at 1.4 million people, and more than 200,000 people are serving life sentences. 1 out of 7 people in prison. More people are sentenced to life in prison in America today than were people in prison serving any sentence in 1970. That's an incredible statistic from the Sentencing Project, a report February 17th of 2021. As Jan Collins told us 2 weeks ago during the parole bill hearing, Maine's incarcerated population has grown 400% since the adoption of the Maine Criminal Code on May 1st, 1976. Let's look at 3 examples that underscore the need for resentencing reform. On August 31st, 2020, Mark Cardilli, 25 years old, was initially charged with murder in the death of Ishak Muse, 22-year-old. Superior Court Justice Nancy Mills presided over a bench trial in December and ultimately found Cardilli guilty on the lesser charge of manslaughter. She also decided his sentence during an emotional hearing at the Cumberland County Courthouse in Portland on Monday. The total sentence is 11 years, but the judge suspended 3.5 years with a net sentence of 7.5 years. Now, another case on January 20th, 2020, a judge sentenced a Portland man Monday to serve 6.5 years in prison for a fatal shooting in Bayside in 2018. Tyrese Collins, now 20, pleaded guilty to manslaughter in September. The full sentence was 10 years, but Superior Court Justice Thomas Warren suspended a portion during a hearing Monday, January 20th, at the Cumberland County Courthouse. In contrast, on February 23rd, 2010, the same Justice Thomas Warren sentenced Brandon Brown to 27 years in prison, 10 years suspended, in a case where the victim was seriously injured but did not die. Brown's sentence was net 17 years, 3 times the sentences received in the Collins and Cardilli cases where the victims did die. On February 9th, 2021, during her judicial confirmation hearing, I asked District Court nominee Sarah Churchill how it was possible that Justice Warren imposed a 6.5-year sentence in the Collins manslaughter case where the victim perished, and a 17-year sentence in the Brown case where the victim lived. Both defendants were approximately 20 years old. Both expressed remorse. Justice Warren explaining his sentence of Collins as Mr. Collins' right to have a chance at rehabilitation and his potential for rehabilitation. That's a quote. In Brown's case, despite his remorse, Justice Warren took none of those factors into consideration. In reference to Brandon Brown's potential, Brandon is now enrolled in the doctorate program at George Mason University, the first resident of a Maine prison to achieve this historic achievement. When I asked now District Court Judge Sarah Churchill how this disparate outcome was possible, she said, and I quote, "It was the result of human error," underscoring the need for this bill. Now I want to examine the case of Daniel Fortune. Fortune's case was the first case in Maine in which the state's harshest penalty, life in prison, was imposed for a crime that the victim survived. Press Herald, April 4th, 2017. On October 12th, 2011, during a Supreme Court argument, Fortune's appellate attorney before the Supreme Court, Arnold Clark of Waterville, argued that, quote, "Just recently, there have been sentencing in a couple of double homicide cases in Maine where life sentences were not imposed." Clark was not Fortune's original trial attorney. Clark went on to say, and I quote, "In this case, nobody died, and that's a big difference legally." Fortune was offered a plea deal of 30 years in prison. He refused it. Upon his entering a plea to the charges not yet tried, he continued, quote, "I was willing to admit to what I did, but would not admit to what I did not do." He admitted at the Rule 11 proceedings where he pled to theft and other charges. On May 10th, 2010, Daniel Fortune was convicted of 2 counts of aggravated attempted murder. He wasn't sentenced to the 30 years offered. He was sentenced to 2 life sentences concurrent with no parole available, despite testifying he hurt nobody that night. Clearly, he suffered what I call the innocence penalty. He was offered 30 years, refused because he maintained his innocence of the attempted murder charge, and suffered the penalty imposed for pleading innocent, and suffered the consequences, receiving 2 life sentences for a crime where nobody died. Fortune, who is Black, testified that he was a native of Haiti and was aware that there were more Black people living in urban southern Maine than in Kennebec County. He asked for a change of venue because of the pre-trial publicity surrounding this case in Kennebec County. He suggested to counsel that the trial be changed to Cumberland, Androscoggin, or York County, where the chance of a racially mixed jury pool existed. But the trial justice, Michaela Murphy, inexplicably decided that the trial would be transferred to Somerset County, making some reference to the fact that it should be an adjoining county to Kennebec. Kennebec County also borders Androscoggin County, which according to the Census Bureau had a population of African Americans of about 5%. In contrast, Somerset County had an African American population of 0.5%. The chances that Daniel Fortune's case would be heard by an impartial jury of his peers, a constitutional guarantee, in Somerset County was 0. And that's exactly how many African Americans were in the jury pool in his case. None. After Daniel Fortune's conviction and sentencing to 2 life terms in prison, this highly disturbing comment outlining the sheer prejudice that Fortune faced came from one of the prosecutors after sentence was pronounced on June 24th, 2010. And I quote, District Attorney Everett Fowle said it was rare for the prosecution to get a life sentence. Aside from colonial times, there's never been a life sentence imposed in Maine for a non-homicide, he said. I quote, it's a great day for justice in this country, he said. A change in the state's criminal code in 2001 made the crime of aggravated attempted murder punishable by life in prison if the judge decided it was warranted. I want to remind this committee that sentences identical to Daniel Fortune's were imposed during colonial times when African American slavery and indentured servitude were legal in New England. To have a Maine prosecutor publicly brag about this 19th century outcome is nobody's idea of justice. In answer to testimony opposing this bill on constitutional grounds, this bill is clearly constitutional because it requires the Attorney General to file a petition for resentencing reviews at any time during the duration of the sentence. And I emphasize, to request the court for a reduction or termination of the sentence. Since the courts represent a separate branch of government with judicial powers guaranteed in our Constitution, the power to alter judicial outcomes is already reserved for the courts. Hence, arguments that this bill is unconstitutional because it interferes with the governor's commutation powers fall flat. In closing, I want to challenge the continued obstructive testimony coming from the administrative offices of the courts when it comes to criminal justice reforms. Since the 16th century, Lady Justice has often been depicted wearing a blindfold. The blindfold represents impartiality, the ideal that justice should be applied without regard to wealth, power, race, or other status. Maine's administrative office of the court often weighs in with testimony that impedes fairness in judicial outcomes, whether it be their lame excuse of lack of resources or outright opposition to reforms. Let me get this straight. Maine has the money to arrest people, the resources to prosecute them, the resources to convict them, and to incarcerate them at the cost of $50,000 per year while incarcerated. But when it comes to adjudicating an injustice, we hold a rummage sale. This, I proffer, is clearly unconstitutional, a violation of the Sixth Amendment guarantees the right of a fair trial or hearing, and a violation of the 14th Amendment Equal Protection Clause depriving the right of due process of law. When the courts offer testimony that is clearly hostile to a fair and just outcome, they no longer can possibly serve as the impartial arbiter that Lady Justice represents. I hope Justice Mead is listening. Thank you for your consideration, and I'm happy to answer your questions.
Thank you very much, Representative Evangelos, for bringing the bill forward. Are there any questions from members of the committee for the bill sponsor? Representative Moriarty. You're on mute, Representative Moriarty.
Sorry, I had to take a quick call. Thank you. Representative Evangelos, later today, we're going to be taking up a bill, I believe, that you sponsored to establish conviction integrity units. How would you distinguish those units from the proposed resentencing units in Bill 1270?
Well, they're only distinguished, I mean, they are a similar concept, and both bills empower the Attorney General and or prosecutory districts to review cases. In the case of this bill, it's reviewing injustices that may have occurred when judges made mistakes or abused their judicial discretion in imposing unjust sentences. The other bill revolves around malicious or unjust prosecutions and doesn't look at the sentences actually. But Representative Moriarty, we have 18-year-old boys who have been sentenced to 50 years in prison. And in Daniel's case, he got life and nobody died. Race and prejudice played such a role in that case. And it's disturbing. And that prosecutor's comments are highly disturbing. Thank you for asking the question.
Okay, thank you.
Thank you, Representative Moriarty. Representative Galgay-Reckitt.
Hi, Representative Evangelos, do you have a concept of what it would take to have a sentencing unit, a resentencing unit? Are you talking about one person and a aide or something, or in each of the prosecutorial districts? Or are you thinking that there would be some compilation of counties?
It's a good question, and I
grasp of the magnitude.
That's a good question, Lois. Thank you. And I've been giving it a lot of thought since Representative Moriarty raised his questions about the conviction integrity unit. And it's possible that these units can be combined in the interest of fiscal restraint. I know on the other bill, the prosecutors voiced support. I haven't had time to read the testimony. I've been so busy, but that's coming in on this one today. But it appeared that the prosecutors are with me in spirit on the conviction integrity, but because of resources, they recommended it be housed in the Attorney General's office. And in the interest of getting it done and our finances, this could be consolidated into that same office. The only caveat to that is there has to be a wall of separation, and like an Inspector General's office to carry this out. It cannot be linked to the homicide division of the Attorney General's office. It has to be people who are running these independent analyses cannot be connected to the people who prosecuted, obviously, or to any part of the judicial system that sanctioned a sentence that was unjustified. So we have to have an independent office housed probably in the Attorney General's office, and we'll work that out in work session. And it's possible we can combine, I think that's what you're driving at, these two offices in one, but it has to be independent. Otherwise it won't work. We've seen that with the police shootings. We don't have independent review of police shootings, and we know the result, 170 to 0. So I would be happy to have it housed in the Attorney General's office as long as the language was structured that it be independent of any of the divisions that prosecute those crimes.
Thank you.
Thank you, Representative Reckitt. Representative Libby, you had a hand up. Do you no longer needing to ask a question?
For the most part, Representative Evangelos answered my question incidentally while answering the previous question. Thank you very much, Mr. Chair.
Thank you, Representative Libby. Representative Thorne.
Thank you, Mr. Chair. Representative Evangelos, you had mentioned in your testimony, referenced a Black individual that wanted to have his case heard in Cumberland County because the odds of him receiving a jury of his peers, i.e., I took it for you to mean that the potential for other Black individuals to be on that jury were higher than the other counties. Is that correct?
Representative Thorne, thank you. Based on census data, I think it's quite obvious that an African American is entitled to have a jury pool, at least a jury pool, if not the selection, but at least the jury pool that is multiracial. The chances of that occurring in Somerset County were zero. And the judge had an opportunity, even though she maintained she wanted it to be an adjoining county. Androscoggin County adjoins Kennebec. I don't understand Kennebec County being selected. I think that was, that was a done deal. I mean, that right there, he doesn't get a fair trial.
But in this bill, you're saying that this would facilitate perhaps another trial in Cumberland County to satisfy the defendant's wish for the possibility of a jury of their peers?
No, sir. It wouldn't be another trial. This is pre-trial motion activity before the trial starts. The motion is made that because of pre-trial publicity and the chances of seating a multiracial jury, we ask that a change of venue be granted. Androscoggin County was available if the judge was going to hold it to an adjoining county. The basis of Mr. Fortune's request was on the basis of race. The justice.
But this bill has to do with resentencing, right? Not pre-trial.
Correct, but the point is that he got 2 life sentences for the first time in the history of our Maine when a homicide wasn't involved. And he asked for a change in venue to a multiracial county, and he got a county that hardly had any African Americans in it, when another county was available to assure a fair trial. But it's not a second trial, sir. It's the same trial. But why I raise that, because it resulted in a conviction and a sentence for 2 life sentences. As I said, the first time in the history of the state of Maine that a person who hadn't killed anybody got life in prison.
I'm still confused, but that's okay. I'm just wondering when this bill would take effect. After the judge named the trial county, this would give him another time, or I'm getting lost in the word resentencing about the bill.
Resentencing, the provision of the resentencing allows if the bill is adopted, would allow the Attorney General's office to review unjust sentences and to adjudicate a fair outcome by submitting a post-conviction motion in the courts. I raised the 3 previous cases in my testimony and the Fortune case to outline the need for this, because we've had some disparate sentences. There's not going to be another trial. It's done.
Okay.
Yeah.
Thank you.
It's just like the conviction integrity unit, sir. It avails the prosecution, who is sworn under the Maine Bar Code to uphold fairness and the integrity of the process. And in the rare occasions that it doesn't work, it would allow those authorities to indicate and undertake an independent review and make a recommendation for fairness.
So you're talking about something different than this bill actually does.
No, I'm not talking
No.
exactly what this bill does.
I think we're getting a little beyond the public hearing, and these might be.
The bill is a resentencing project bill that would be
Work
housed in the
No,
prosecution.
I'm sorry, Mr. Chair. I'm just trying to understand the bill from the sponsor. That's all I'm trying to do. I'll leave it alone. Thank you.
Thank you, Representative Thorne. Representative Galgay-Reckett, is your hand still up from the last time? Thank you. Representative Moriarty.
Thank you, Mr. Chair. Representative Evangelos, just to clarify, this bill before us right now requires that a trial has already been held, a finding of guilty has already been made, and a sentence has already been imposed. Is that
a good
correct summary?
That is correct.
All right, good, thanks.
Thank you, Representative Moriarty. Are there additional questions from committee members for the bill sponsor, Representative Evangelos? Seeing none, thank you for bringing the bill forward, Representative Evangelos. I will now turn to persons who have registered to testify on LD 1270, starting with Jan Collins, who's testifying in favor, and to all persons coming to testify. Now, I will be running a 3-minute clock. You will see me hold it up when you have 10 seconds left, and I will be holding people to the 3 minutes, or we will never get through these bills. Welcome back to the Judiciary Committee. Ms. Collins, and please begin your testimony when you're comfortable.
Greetings, Senator Carney, honorable members of the Judiciary Committee. My name is Jan Collins. I'm Assistant Director of Maine Prisoner Advocacy Coalition, and I am here to support LD 1270, an act to establish resentencing units. Thank you to Representative Evangelos for bringing this bill forward. He's done an excellent job of giving you specific examples of where this bill is needed. And I would also ask you to go back to the parole testimony and see the testimony of Dan Fortune to emphasize that. I'm going to talk more generally. The doctrine of finality refers to the notion that a legal judgment should not be revisited at any time. This idea, popular in the late 70s and 80s in Maine, has fallen into disfavor and is being successfully challenged around the country. Finality can be applied to crimes, sentencing, and offenders. Looking at each of these, beginning with crime, it is easy to see that it fails in all three categories. What the law and society consider a crime changes. Vagrancy, debt, spitting on a sidewalk, committing adultery, being a person of color in a whites-only establishment, escaping from slavery, and smoking marijuana have all been considered crimes at some time. In some cases, crimes punishable by death. In Maine, at least, they are no longer crimes. Likewise, sentences for crimes change. What was a reasonable punishment in one era, the stocks, lashings, branding, public executions, are no longer considered humane. Despite efforts to improve the situation, disparities in punishment also remain and are easily identified. And Representative Evangelos has done much of that. The third category, offenders, has the greatest capacity for change, for rehabilitation. We know that because we see it in ourselves. I am not who I was 30 years ago, or even yesterday. Finality has held the wrongfully convicted in prison while the guilty remain in our community. It has not served the individual, the community, or society, and it has undermined rehabilitation. The possibility of resentencing both encourages and boosts rehabilitation. It offers us the opportunity to pair sentences with our evolved understanding of just punishment. The government and taxpayers are saved the cost to house, feed, clothe, and provide medical care for those who do not belong in prison. I have a loved one, my son, who is incarcerated at the Maine State Prison. I am also someone who has been the victim of assault and who has lost a grandchild to domestic violence. I feel strongly that rehabilitation is essential to my personal safety and the safety of my community. 95% of those who are currently incarcerated will return to our communities. We must create a criminal justice system whose complete and total focus is rehabilitation.
Ms. Collins, I need you, I've let you go over the 3-minute timeline. I need you to wrap up as quickly as possible, please.
Thank you so much. 1 sentence left. In closing, according to the model penal code, it would be an error of arrogance and contrary to history to believe that the criminal codes and sentencing laws of our era have been perfected and reflect our timeless values. Thank you.
Thank you very much, Ms. Collins. So always good to see you in front of the Judiciary Committee. We appreciate your time and testimony. Are there questions from committee members for Ms. Collins? Seeing none, again, thank you very much for your time and testimony.
Thank you so much.
I will now turn to the attendee room to see if there are any other persons who have not registered that wish to testify in support of LD 1270. And I see Phil, and I hope I got the name correct, Phil Notice. If the committee clerk could move Mr. Notice over. And Mr. Notice, as soon as you are ready to begin, unmute your microphone, activate your video, and begin your testimony as soon as you're comfortable. And I will start the 3-minute timer. And you'll see it up when there's 10 seconds left.
Okay, sir, thank you. You can start the timer. Honorable members, it's a pleasure to be here. I know I won't be able to say everything I want to say within 3 minutes. I'd like to know if I can submit what the deadline is for submissions in writing.
You may submit your testimony after the hearing, sir.
First of all, thank you. I'd like to say quickly, I'm a criminal defense lawyer, been practicing about 32 years, and I want to talk about 2 post-conviction cases that I've had. I represented someone who received 7 years. I represented not as a trial attorney, but as a post-conviction attorney. And we were able to establish relief. This person had participated in all the programs, education, therapy at the in the Department of Corrections, and we brought it back based on error. In post-conviction, you have to have an error to bring back the case, and we were able to reduce sentence by a couple of years and put him on probation. And that was by agreement of the prosecutor. In another case, a client was offered, this was over a decade ago, 5 years, went to trial, rejected. I wasn't the trial attorney. The judge gave him 18 years. I picked up the post-conviction. That person actually got a college degree. We were able to bring it back and we reduced sentence by 6 years. I think I support this bill, and I think its intent, it's got good intent, but I have some concerns about the language where it says a sentence is unjust and unfair. Now, when we do these Huey analysis, what I do is I can FOIA all the burglaries that have ever been sentenced in the entire state of Maine and show them to a judge and say, well, look, this is the average and we're under here or over there. But, you know, the judges don't have to really accept those as in, in determining unfair or unjust. I'd like to see the word rehabilitation in this bill as well. Like if a person is serving 12 years and they're rehabilitated at 6 years, then they're in there 6 years too long and they're just being housed. My other concern also is State v. Hunter. And I'm not bringing this up as something to defeat the bill. I'd like to see the bill. I believe that's an old case in '82, and Justice Mills argued that in front of the law court, where the department, DOC, would recommend early release where people have been rehabilitated, but the law court had decided that's an interference with the commutation powers. So in the AG also, I don't find that neutral. I mean, having a unit in the AG's office, they prosecute murders. 1 minute, 7 seconds, okay.
10 seconds.
I don't want to run over. I respect the time limit. I will follow up with some written comments. And thank you very much.
Thank you very much, Attorney Notice. Are there questions from committee members for Mr. Notice? Seeing none, thank you very much for taking the time to testify today. We look forward to receiving your written testimony, which will be reviewed by all committee members.
Thank you, sir.
I will now check in the attendee room again to see if there are any persons wishing to testify in favor of LD 1270. Seeing none, I will now turn to those testifying in opposition. The only person that we had registered to do so was Mr. Pelletier from CLAC, and I do not see him in the attendee room. I will give him time to get here, but in the interim, I will ask if there are any other persons in the attendee room who wish to testify in opposition to LD 1270. If so, please raise your electronic hand. And seeing none, I will now turn to persons registered to testify neither for nor against. And in that capacity, I have Ann Jordan for the Maine Judicial Branch. If Ms. Jordan could be moved over, and of course she has by our super efficient committee clerk. Ms. Jordan, welcome back to the Judiciary Committee. When you are ready to go, please begin your testimony, and I will start the clock and put it up again when you have 10 seconds remaining.
Thank you. Good morning, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Ann Jordan, and I'm the Manager of Criminal Process and Specialty Dockets for the Maine Judicial Branch. I appear today on behalf of the branch, and although the branch does not oppose the idea that sentences can or should be reviewed, we have serious questions and grave reservations about the methods for such review that this bill appears to propose. Our comments are in large part of our previous comments on LD 1273, an act to establish conviction integrity units. First, the bill creates two bases for claims for post-conviction reviews under Chapter 305-A of Title 15. That is the post-conviction review portion of our statutes. It adds in unfair or unjust, but it does not define in the law what that means, and it would make it difficult to apply. The addition of these two new phases also creates a significant and dramatic change in the existing post-conviction law, which now exists as a remedy for illegal restraint and other impediments specified in Section 2124 that have occurred as the direct or indirect result of an illegal criminal judgment or post-sentencing proceeding. Previous legislators have enacted 17A 1501 with its 9 purposes of sentencing and enacted 17A 1602 with its 3-part process, commonly known as the Huey analysis, to guide judges as they impose sentences imposed on persons convicted of a crime. Any sentence that is imposed in contravention of the laws or procedures, a sentence that is later determined to be unlawful or unlawfully imposed, or imposed as a result of an error, can all now be vacated through existing processes in the trial court and on appeal at the law court. We also have the post-conviction review process in Chapter 305 and 306 that provides for these provisions. As you know, the bill as drafted has 6 specific criteria that could result in the reduction or termination of a sentence. Those are set forth in my testimony. As currently drafted, the bill contains no limits on when or how often such petitions could be brought, and it gives no indication as to how or whether victims of the crimes are to be given a voice in the process. It also does not tell us what the burden of proof on the moving party should be. The second issue that arises is the ambiguity as who can file it. Well, the proposed new section 1861 contemplates only a DA or AG may file the petition. The actual language of the amended section 2125 would allow a person who satisfies the prerequisites of section 2124 in the post-conviction review statutes to file a petition. Then the question becomes, what do we do? Finally, we raise a question as to whether Article 5, Section 11 of the Maine Constitution that grants the powers of commutation to the governor. I'm available to answer any questions the parties may have or the members may have. Thank you.
Thank you very much, Ms. Jordan. Are there questions from committee members for Ms. Jordan? Representative Moriarty.
Thank you, Mr. Chair. Good morning, Ms. Jordan. Good to see you again.
Nice to see you again too, Representative Moriarty.
we have a criminal justice system in which crimes are differentiated largely based upon, or rather on the basis of the maximum possible penalty for that particular crime. Is that a fair, although broad?
A minimum to a maximum possible penalty, yes.
Okay. So within the department, are there efforts to ensure consistency of sentences among judges for the specifically defined types of crimes? You've heard Representative Evangelos talk about radical discrepancies or disparities. Does that come to the attention of the department? Is there an effort to sort of get folks on the same page, so to speak?
So I'm clear, when you're referring to the department, you're referring to the judicial branch, not the
Yes.
Department of Attorney General or anybody. Okay, yes.
Yes, your branch, yes.
As part of their judicial training, yes, that's part of it. The Judicial College has regular training on sentencing and sentencing matters. In fact, I participated in putting together one of the trainings a couple of years ago on domestic violence crimes, where we brought in national experts on sentencing and what should be done. And there was intensive training and a roundtable between the judges as part of that matter. Law clerks are also available to the judges to conduct research on various sentences, depending upon the nature and the type of crime and the individual's criminal history background. Additionally, courts can request in serious cases a pretrial sentence investigation, which also provides additional information that goes along with the information provided both by defense counsel and the prosecutor, and the sentences made by victims of the crimes, statements made by victims of the crime at the time of sentencing. But that information is available to them, and the court has to look at all 9 factors in the sentencing statute and conduct the Huey analysis. And there is some pretty extensive discussions and recollections as to various sentences that are imposed under the Huey analysis.
I have a very quick follow-up. As part of my continuing legal education, can a judge on his or her own motion re-examine a sentence that judge has imposed if the judge concludes it was inappropriate?
There are rules that allow a judge, Rule 32, or the main rules of Uniform Criminal Procedure, sentencing and judgment, and Rule 35, correction or reduction of a sentence allows a judge to do so. And on Rule 35, on the correction or reduction of a sentence, I can read you the language if the committee would like us to, or would you just like to stick to the reference?
Well, just to know that there is an authority and a reference is all I needed at this point.
Yeah, and to be clear, a court has that authority under Rule 35 to reduce the sentence before commencement of execution or after commencement of execution. But I will say, in interest of transparency, it has to occur within 1 year of the imposition of the sentence.
Okay. All right. That's very helpful. Thank you then.
You're very welcome.
Thank you, Representative Moriarty. Are there additional questions for Ms. Jordan from committee members? Seeing none, thank you very much for bringing your testimony forward to the Judiciary Committee today. We greatly appreciate your time and input.
Thank you.
Okay, that exhausts people that I've had registered to testify that are here in attendance. But I will go through the attendee room once more and ask if there are any persons here wishing to testify in favor of LD 1270. If so, please raise your electronic hand. Seeing none, I would ask if there are any persons present that wish to testify in opposition to LD 1270 to raise your electronic hand. And finally, seeing none, I would ask if there are any persons testifying neither for nor against LD 1270, please raise your electronic hand. And seeing none, and having heard testimony from all those present and wishing to testify, I now close the public hearing on LD 1270. Thank you to the bill's sponsor, and to all those persons who testified. I will now turn to our next public hearing. I would first check to see if Senator Carney is back. And seeing that she is not, I am going to skip LD 1578 for the moment and open the public hearing on LD 545. LD 545 is an act to combat sexual exploitation of minors in Maine. And I welcome the bill's sponsor, Representative Andrews of Paris. Welcome back to the Judiciary Committee, sir. And please.
Thank you. Good morning, everybody.
Thank you. You may proceed. Sorry.
Senator Carney, Representative Hartnett, and honorable members of the Judiciary Committee. My name is John Andrews, and I represent the towns of Buckfield, Hebron, and Paris that make up District 73 in the foothills of Western Maine. I am here to testify in favor of my bill, LD 545, an act to combat the sexual exploitation of minors in Maine. About a year ago, I accompanied my wife to a medical conference in Arizona. I had set up a couple of meetings at the Goldwater Institute out there and decided to tag along. While eating breakfast at the hotel, I grabbed a copy of USA Today, and right on the front page was an article that mentioned Maine, and it was not in a good light. The piece highlighted that our state and another were the only ones in the whole country with a grade of D or lower when it comes to human trafficking. The grade came from Shared Hope International, who is a very well-respected organization, whose mission statement reads, Shared Hope International strives to prevent the conditions that foster sex trafficking, restore victims of sex slavery, and bring justice to vulnerable women and children. We envision a world passionately opposed to sex trafficking and a community committed to restoring survivors to lives of purpose, value, choice, one life at a time. I was alarmed and very dismayed after reading that article. Shortly thereafter, I fired off an email to Shared Hope, asking what I could do to help improve our grade through policy and potential legislation. Conversation started there and continued over the following months. I was happy to learn that Shared Hope had worked with people on both sides of the aisle, like Senator Amy Volk and Senator Bill Diamond in Augusta in the past, and they were happy to help me now as I prepared for the 130th. LD 545 is an important and necessary bill because it seeks to cut down on the demand side of the supply and demand aspect of human trafficking and exploitation of minors in Maine. We need to penalize the predators, and the penalties need to send a message that these wicked acts will not be tolerated in our state. LD 545 will strengthen the criminal justice system's response to child sex trafficking and increase the criminal penalty for engaging in prostitution or attempting to engage in prostitution with a person less than 18 years of age or a person believed by the actor to be less than 18 years of age. The bill, once enacted, will act as a deterrent through more jail time for anyone who engages in these horrific acts. Furthermore, the legislation will change the definition of aggravating factor to include the promotion of prostitution, patronizing prostitution of a minor, sexual exploitation of a minor, sex trafficking, and aggravated sex trafficking, regardless of whether the actor has a familial relationship to the child or not. LD 545 also adds to what the Department of Health and Human Services can do to help coordinate and provide care and services specialized to the needs of child victims of sexual exploitation. This specialization is much needed to help survivors reclaim their lives and become healthy, functional, and productive adults. We need to do everything we can to help these children escape the evil that they have encountered so early on in their lives. Maine must do better, and we can. We need to get serious about combating this scourge of humanity in our state. Dirigo means I lead, and Maine is not leading with our policies towards trafficking and exploitation. We can change our path. This bill and several others like it are an excellent opportunity to change our course to protect our most vulnerable and to punish the wolves among us. This bill with its emergency preamble must receive a unanimous auto pass and go under the hammer as soon as possible. All of us, regardless of political affiliation or ideology, have an opportunity to help those who need it in our state, and we must take it. Thank you for your time and commitment to public service. And I would also add that Sarah Bednison from Shared Hope is not testifying in person, but she did provide testimony. And I think it would be great if you guys could read that at your discretion. Thank you.
Thank you very much, Representative Andrews, and thank you for bringing this bill forward to the Judiciary Committee. Are there committee members with questions for the bill sponsor, Representative Andrews? Seeing none, again, thank you for bringing this bill forward. You're welcome as the bill sponsor to remain as a panelist unless you have other demands on your time for the rest of the public hearing.
Thank you very much.
You're welcome, sir. I will now turn to persons who have registered to testify in support of LD 545, and I would ask the committee clerk, she has moved over, DA Jonathan Sarbeck. Welcome, District Attorney. It's nice to see you back again. Please, when you're ready, begin your testimony, and as you know, I will start at 3-minute clock.
Good afternoon, Representative Harnett, members of the Judiciary Committee. Thank you for having me back. I'm Jonathan Sarbeck. I'm the District Attorney here in Cumberland County. I am here on behalf or in support of LD 545. You're going to see me a couple times today with regards to a lot of these bills. A little bit of my background as a prosecutor is that when I originally came back to Maine from Massachusetts as being a prosecutor, I heard the term human trafficking basically for the first time outside of a Hollywood movie. And I heard it in the context of a case that was happening in Portland, Maine. And from that, we've now become very aware in law enforcement about human trafficking and that it is in fact happening in the state of Maine and, as we know, all throughout the country. Now, we're very lucky in the state of Maine because we have a very robust survivor community. I'm sure you're going to hear from some of them today with regards to their stories about human trafficking and what they've experienced. And when it really comes down to it, when people are compelled into human trafficking, they experience modern day slavery to the point where they are no longer in control of their bodies. They're no longer in control of what they want to do. They're no longer in control of themselves as human beings. So when I see legislation that increases the penalties for those people who traffic other human beings that basically profit off the misery of somebody else, I am in support of that increase in any sort of penalty that recognizes and holds accountable those individuals who are doing that to other people in our community. And a lot of times they are the most marginalized individuals who are victims of human trafficking. Usually people who have gone through trauma that none of us would ever want to experience or have anybody experience. So I'm here in support of LD 545, which specifically enhances the penalties for these aggravating factors that go into increase the penalties for aggravated sex trafficking, especially for minors. When you hear from survivors, you know that a lot of them experience this sort of child abuse or even trafficking at a very young age. There's a FBI statistic that I recently was told that the average age of people who fall into trafficking is 12 years old. So I think that anything that we can do as a community to hold people more accountable when it comes to the penalties that are included with sex trafficking, we should try to do, especially if it's to hold people accountable who do this to some of our most vulnerable individuals. So I appreciate your time, and I'd be happy to answer your questions. And again, you're going to see me a couple times today. So
thank you very much, District Attorney Sarbeck. We always appreciate seeing you in front of the Judiciary Committee. Are there questions from committee members? And I did not see the order that they went up, but I'll start with Senator Keim, then go to Representative Evangelos, then Representative Babbage. Senator Keim.
Thank you, Mr. Chair. Thank you for being here, DA Sarbeck. I had two questions for you. One is why would Maine fall into a category? Just help me understand what makes Maine unique in being rated a grade D. And the second question I have is, how would you prosecute someone? How do you know what age you would believe someone to be? So that the part of the bill that confuses me is that saying if someone believes they're under the age of 18. So if you could just answer those two for me, that'd be helpful.
Well, I think there's a number of factors that go into why Maine has been graded a D with regards to sex trafficking, but I think a lot of it is because of the sentencing. Right now, aggravated sex trafficking in the state of Maine is a Class B felony, meaning that the maximum penalty that we can get in the court system is 10 years. And that's for somebody who is a trafficker who is compelling another individual to engage in prostitution. Just for frame of reference, on the federal side, the mandatory minimum for aggravated sex trafficking, meaning by force, fraud, or coercion, is 10 years. So state of maximum on a Class B is 10 years. Federally, the minimum mandatory is 10 years. And so I think that is one of the factors that goes into Maine receiving a D with regards to our laws. The other question that you asked was, can you remind me about that, Senator Khan?
Yeah, sorry. Just how would you as a prosecutor assume that someone knew that a person was under 18?
Yeah, so the idea behind that law, I believe, and I think there's a couple pieces of legislation that specifically address this in our statutes, is that as the law is written right now, basically law enforcement, or there would actually have to be a minor, somebody under the age of 18 who is involved in prostitution in order for it to be a felony. Not in a way that law enforcement can actually conduct investigations in which they are sort of posing as a person under the age of 18 and then having that individual. And we've had cases even recently in which law enforcement had basically posed as a person under the 18, and we had people who were soliciting this individual who knowingly thought that this person was 15 years old. However, we could not prosecute that as a felony because we did not have an actual 15-year-old who was there. And like I said, there is, I think, a number of legislative fixes coming up, but it's something that I think all of the prosecutors think that we need a tool that will actually address the individuals out there in our community who do exist, who would be willing to pay for sex with somebody under the age of 18.
That's helpful. Thank you so much.
Thank you.
Thank you very much, Senator Keim. Representative Evangelos.
Thank you, Mr. Chair. Just a quick question. Hello again, DA Sarbuck. Thank you.
Nice to see you, sir.
Thank you very much, sir. I'm just reading the bill and the summary, and I just want to make sure that I'm not confused and that, well, this is a hypothetical, but, you know, obviously real world, but I just want to make sure that the unfortunate woman who was, you know, caught up in these circumstances, the bill's not targeting her, is it?
What do you mean, sir? As in prosecute?
Well, the increased penalties and the targeting of the bill is for people engaged in trafficking, but a person who is, you know, got to be careful how you say these things, but a person who is a prostitute due to unfortunate circumstances, but is not trafficking other than their own self. The bill is not targeting that person, is it?
I don't believe so, and I believe the last legislative session, I don't actually know if it became law, but we decriminalized prostitution for anybody under the age of 18.
Yeah, that's what I was driving at. I don't want to be increasing penalties on people that are
no, and I don't believe that that's what the bill says, but I'll go on record right now to say that I'm not in support of having that be criminalized at this point for under the age of 18.
Thanks a lot.
Thank you.
Thank you, Representative Evangelos. Representative Babich.
Thank you, Mr. Chairman. Good morning, good afternoon, DA Sarbuck.
Good afternoon.
I wanted to follow, actually, the question I had was similar to Representative Evangelos, but in the process, when you have multiple people involved in a crime at different levels, in the process, you do, or, you know, I'm asking, do you inform a person of potentialities should they not cooperate?
I don't really, you mean that if an individual in a crime, that if the prosecutors could charge somebody with something?
If they are involved, I don't know, in any, you know, your job is to find truth and to prosecute guilty people. And in that pursuit, I'm asking if people who are arrested and involved would be informed that should they not cooperate, things will go more harshly for them. I mean, is that part of the process or not?
It could be, sir. I mean, I can't tell you every investigation that would happen, but we wouldn't be able to tell anybody about a potentialities of a crime that they have committed unless there actually was something that they had committed. We can use our discretion. We can use it if it's an ongoing investigation, but I'm kind of missing I might be missing what you're trying to ask, and I apologize.
Well, I mean, you know, there are a number of examples. I can think of big cases nationally where law enforcement has put the squeeze on a particular party in order for them to turn on other, and I'll use the word co-conspirator, even though that may or may not be accurate in the description of what happens. And obviously, if they do cooperate and they do provide evidence against the person you know, targeted in the process, then it works. If it does not, then the charge against that person would, you know, possibly or likely or certain historically has been pursued. So I'm trying to, just like Representative Evangelos here, try to understand potential consequences of a harsher penalty, and if that would be used in the process in the same way. Is that a potentiality? You know.
Well, I think with regards to, yes, if somebody is willing to cooperate in an investigation with the idea of trying to get the individual who's actually more at fault for doing something or more responsible, or the actual moving party, then the idea is to, we always try to get the person who's most responsible. And if somebody wants to cooperate, then, hey, you know what, we might not be going forward with charges, or we might recommend a sentence in a different way. I can tell you, though, for people who are engaging in aggravated sex trafficking, those are the people we're after. Those are the individuals who we want to see behind bars because of the exploitation that they do to other people. So I don't think that it's something that we want to enhance on individuals who are being trafficked to try to get them to cooperate. We don't want to try to coerce cooperation out of with the penalty of, this is, if you don't do this, you're going to get this penalty. I mean, I can tell you that I've seen a shift in law enforcement where we view people who are engaged in prostitution not as criminals, but as victims. Now that we have spoken to so many victims and so many survivors of sex trafficking to know the trauma that they've gone through, it's a big change that I've seen in law enforcement, especially in Cumberland County, when it comes down to it. So we don't want to coerce anybody to have to basically go about and help out in an investigation, because, and as a prosecutor as well, any promise, reward, or inducement that we have to, or that we give, we have to make sure that the person who is the target of that investigation, if we do prosecute them, that they know about, because that could be seen as potential Brady information with regards to whoever is prosecuted at the end. So I hope that answers your question.
Well, I think so. I mean, I guess one of the cases I was thinking about was an FBI person talking about, at the time of the Rosenberg case back in the 50s, they didn't have anything at all in Ethel Rosenberg, but they charged them both in the hopes of shaming the husband to confessing and exonerating his wife, or in the hopes that perhaps his wife might claim innocence and be willing to, you know, but it didn't work. They both went to the chair, I know there's evidence later that I don't know if it was incriminating about Ethel specifically, but supposedly was more incriminating about Julius, but that's irrelevant. My point was, at the time, there was a tactic used in order to try to get progress in the case. And I'm trying to figure out the relevance of the penalty in this case, and if it could inadvertently be detrimental to a person who may have been coerced to be part of something, but may not deserve that advanced penalty. That was where I was going with that.
Yeah, I think that how I view this bill is that this is actually going for the people who are the perpetrators of the trafficking, not the victims of the trafficking. And obviously, if there is information that, yes, somebody might have trafficked somebody else, but that person only trafficked because somebody else was coercing them to traffic, then it's something to take into consideration. But at the same time, that doesn't exonerate another person from doing something else. I mean, we're kind of approaching this in a vacuum, but every case we have to take on a case-by-case basis and look at all the facts that we can know. But at the same time, to me, the people who are there exploiting other people and really just those are the people that I think.
Yeah, thank you for that. Mr. Chairman, I was trying to distinguish intent and implementation. Thank you.
We can't hear you, Mr. Chair.
Thank you. What I was saying was we need to limit ourselves to questions on this bill and not necessarily long lost history. Representative Libby.
Thank you, Mr. Chair, and thank you for being here, DA Sarbeck. One question is, you mentioned that the state maximum is 10 years, federal minimum is 10 years. But how often are judges sentencing, would you say, closer to the maximum or the state minimum in these cases?
Well, the state minimum is basically a straight probationary sentence. The maximum would be 10. I did not pull data to tell you about what the maximum or what the average sentence have been here. I have seen an aggravated trafficking case which brought about a 5-year sentence. But quite frankly, when we work very close with the U.S. Attorney's Office. The U.S. Attorney's Office has been designated one of their, I think it's 5 in the country, ACT teams with the specific designation to go after human trafficking. And so we work very closely with our federal partners. And quite frankly, if we see a case where that might rise to the level of an aggravated sex trafficking, and we work with our federal partners, one, because they have great investigative tools with the FBI and Homeland Security investigations. But another is that they might take that case and work it on the federal level in order to get that trafficker off the street for that mandatory minimum 10 years.
Thank you. One more question, Mr. Chair.
You may go ahead.
Thank you. In reading Clack's written testimony, they had recommended that this should be Class C rather than Class B. What are your thoughts?
I mean, I think to make that jump from a D to a B is something that is kind of unusual in a way. At the same time, I think that's sort of a policy decision for you to all make. But any sort of felony conviction that we can get on somebody would be a tool that we can use as prosecutors and helpful in how we go about holding those individuals accountable who do this egregious act.
Thank you very much.
Thank you.
Thank you. Thank you, Representative Libby. Representative Moriarty, you had a hand up and I see it's gone. Are you?
The question was just answered.
Thank you very much. Are there additional questions for District Attorney Sarbeck? Seeing none, thank you very much for your time and testimony today. I will now turn to the next person registered to testify in support of this bill, Elizabeth Ward Saxel. Welcome back to the committee, Ms. Ward Saxel. And as soon as you're comfortable, begin, and you know the drill with the clock. So.
Thank you. Senator Carney, Representative Harnett, and distinguished members of the committee. My name is Elizabeth Ward Saxel, and I'm submitting testimony today on behalf of the Maine Coalition Against Sexual Assault, as well as we oversee the Maine Sex Trafficking and Exploitation Network. We're here in favor of LD 545 with some amendments I note below. I know a lot of this conversation has been focused on the trafficker, but Section 1, as we read it, addresses situations related to the buyer, where the buyer thinks the child trafficked is a minor. However, current law already addresses this situation, as it does trafficking for victims under 18. But I'll note it's a little hard to find this part of the statute because it's not with the other trafficking provisions in Chapter 35, but instead is in Chapter 11 under solicitation of a child to engage in prostitution. With regard to the next sections of the bill, we strongly support expanding the scope of child protective services to include investigation and case management of youth who are experiencing sex trafficking. It will provide a path to intervention and services for trafficked kids where there are currently major systemic barriers. However, this provision has already been heard and worked by the Health and Human Services Committee in the Department Bill LD 837. I believe that bill received a unanimous ought to pass as amended. In my written testimony, I also address Section 5 through 8, which relate to CPS's role in responding to the commercial sexual exploitation of children, or CSEC. But I'd like to highlight that OCFS is currently finalizing an excellent policy regarding response to an investigation of CSEC. Sections 9 to 11 would add a requirement that entities administered, licensed, or funded by DHHS or DOC that provide care or services for children have a mechanism to screen and respond to CSEC. While we appreciate the intention to build a stronger response statewide to CSEC, we imagine these providers do not currently have the ability to coordinate the complex services required for these victims and would require significant training and resources to acquire this specialized expertise. You might instead consider this section to be amended to start with only requiring the screening process, which alone would still require training, but would be much more feasible from our perspective. Section 12 would expand Children's Advocacy Center CAC duties. The CACs are actually funded and overseen through our agency and currently play a central role in the response to CSEC through coordinating forensic interviews and service referrals for suspected victims. These cases are extremely complex and the service coordination is likewise challenging. The Cumberland County CAC is the only CAC that has a dedicated CSEC coordinator, and we are piecing together funding in 6-month increments just to get through this fiscal year. However, all of Maine's CACs work with CPS and law enforcement to coordinate forensic interviews and referrals for this population. However, the provision of, all right, I will leave it there.
Thank you, Ms. Saxel. And I would just remind witnesses, I put it up when you have 10 seconds to go.
Oh, shoot, I blew it.
No, that's okay.
Oh, all right.
If you want to wrap up in a sentence.
That would be great. Thank you so much for your leeway. I was having trouble reading it in my car on my computer. However, the provision of services other than those previously noted is delivered through sexual assault support centers, mental health providers, and other specialized professionals. It would take a fairly large fiscal note to support additional specialized services provision in the state or elsewhere. I also just want to mention that it was an absolute pleasure working with Representative Andrews on this bill. I really appreciate his attention on this, and we'd love to participate in the work session if at all possible. I'm also ready to answer some of the questions that were posed previously if people want me to do that.
Thank you. Are there questions from committee members for Ms. Ward Saxel? Seeing none, thank you very much for your time, and I imagine we will see you at the work session.
Thank you very much.
And with that, I will turn to the next person that I have registered testifying in support of LD 545. And I would ask the committee clerk to move Penny Morell into the panelist room. And I see that we have been joined by Penny Morell. When you are ready to testify, just activate your microphone. Your microphone is active, but activate your video and begin testifying. And I will start the 3-minute clock and remind you that I'll hold it up when you have 10 seconds left.
There we go. Can you see me?
Not yet. Your camera is not activated.
Oh, it says virtual background.
Okay, well, we're just seeing your name, but in the interest of time, I'll see if the committee clerk can activate your video, but you may proceed with your testimony.
Okay, thank you. Senator Carney, Representative Harnett, and members of the Judiciary Committee, thank you for the opportunity to appear before you today. I'm Penny Morell, State Director of Concerned Women for America of Maine, speaking for Concerned Women for America, LAC. Excuse me. Concerned Women for America is the largest public policy women's organization in the nation with hundreds of thousands of members across the country. CWA of Maine supports LD 545, an act to combat the sexual exploitation of minors in Maine. Sex trafficking is a problem in Maine. We learned of it from termed out Representative Heather Siraki with her legislation she introduced while in office and the exhaustive investigatory work she did to make this body aware of the problem. Her bills failed to pass. There we go. Her bills failed to pass, but this bill today resurrects the knowledge of the need to protect these innocent children. We must have a penalty in law that discourages this behavior of sexual exploitation of minors, including prostitution and sex trafficking. DHHS needs guidelines to care for victims of this behavior. This bill provides those needs. I'm very disappointed to learn that the Maine Association of Criminal Defense Lawyers has come out against this bill and its reasoning. Their testimony is already on the website. CWA of Maine strongly disagrees with their logic. I ask this committee to vote LD 545 ought to pass. Thank you, and I'd be glad to answer any questions.
Thank you very much, Ms. Morell. We appreciate you coming before the committee and offering your testimony today. Are there questions from committee members for Ms. Morell? Or is it Ms. Morrell? Am I getting it wrong?
Morell, thank you.
Okay.
You got it right the first time.
Okay, thank you. Are there questions from committee members? Seeing none, again, thank you for taking the time to testify and for submitting your testimony in writing as well.
Thank you so much. Have a great day.
You as well. I'm going to turn to the attendee room and ask if there are any other persons who wish to testify in favor of LD 545. If so, please raise your electronic hand. Seeing none, we did have one person registered to testify against LD 545, Walter McKee of MacDill, but I do not see him in the attendee room. So I will ask if there are any other persons in the attendee room who wish to testify in opposition to LD 545. If so, please raise your electronic hand. Seeing none, I will turn now to persons who registered to testify neither for nor against. We had one person in that category, John Pelletier from the Criminal Law Advisory Commission, but I do not see Mr. Pelletier in attendance. So I would ask if there are any other persons who wish to testify neither for nor against LD 545. And seeing none, I would advise committee members, as you always do, that we have a lot of written testimony on this bill, including the two persons who I referenced that had testified to register to testify, but who are not available apparently at this time. So having heard and received testimony from those present today, I will now close the public hearing on LD 545. And I am going to check again to see if Representative Carr is back to introduce a bill for Senator Sanborn. And I do not see her back, so I will turn. We're going to take up our next bill, and then we will need to break to give committee members and committee staff some time to leave their chairs. So I will now open the public hearing on LD 813, which is an act. Actually, before I do that, the committee has been joined by Representative Hagan, who I failed to acknowledge earlier. Representative Hagan, you could just introduce yourself to the persons attending.
Thank you, Mr. Chair. I am David Hagan. I proudly represent House District 101, Hamden and Newburgh.
Thank you. And again, we're hearing LD 813, an act to increase the penalty for engaging in the sex trafficking of children. And I welcome to the Judiciary Committee the bill sponsor, Senator Diamond. You may proceed, sir.
Thank you very much, Representative Harnett, Senator Carney. My name is Bill Diamond. I represent Senate District 26, and it's a pleasure to appear before the distinguished members of Judiciary Committee. I am presenting LD 813, an act to increase the penalty for engaging in the sex trafficking of children. And this bill elevates from Class B to Class A the crime of aggravated sex trafficking if the person being trafficked is 14 years of age or younger. First, let me quickly say that I want to acknowledge that after working on child sexual abuse issues and legislation for several years, I'm very aware that there are no easy answers to these serious problems, and that increasing penalties for crimes overall is not always a successful deterrent to the specific crime. And I appreciate that. And I understand there may be unintended consequences when we go to such a remedy. However, I want to alert you, if you don't know, that we have a very concerning trend in our state, and in fact, in many states around the country, of the escalation of child sexual abuse among youngest children, and the young children production of child pornography, sex trafficking, trading and selling of these images in peer-to-peer groups around the world. If you don't know, in this tendency of peer-to-peer is people who have they gather for like interests, and in this case, they like to watch child pornography, and they may have special interests with that. They are a major contributor to this billion-dollar industry, and their sharing is something that's even another level of the distribution. ICACs around the country, and the Internet Crimes Against Children law enforcement groups in several states are reporting the higher use of very young children in pornography online sites. The head of Maine's computer crime unit recently stated that Maine is seeing more and more that the children being used as main attractions in these films, that is, being sexually assaulted in various ways for the sexual gratification of others, are very young. To the point, we were told, that infants 3 to 5 months now are becoming some of the more highest priced attractions, thus obviously producing more money for the producers. The children being sexually assaulted in the films and other images are only as valuable as the amount of money people will pay to watch. So if the buyers want to pay large sums of money to watch children being sexually assaulted, then that's what they'll get. Sex trafficking is no different. What is becoming the biggest seller are the younger children. Thus, these children are more valuable because of the buyer's demands. Recently, I talked with a local municipal officer whose primary assignment was undercover to locate and arrest, if possible, people who are trying to buy time for hands-on sexual gratification with young children. The easiest way to make those arrangements is through sex trafficking organizations, as we know. And according to him, the availability of connecting with a sex trafficker is not only quite easy in the state of Maine, but the availability to get access to these youngest kids, youngest victims, is especially easy in rural and less populated areas of the state. Because of the alarming trend to use young children in the forms of sexual assault, especially for those who will pay top dollar for the hands-on sexual experiences, this may indeed be the time to consider increasing the penalty for sex trafficking for children 14 years and younger. In fact, the committee may want to consider lowering the threshold, if that helps to distinguish, considering the greatest concern at the moment are protecting the very youngest children from this heinous practice that is growing every day. And for some reason, the attraction to the very, very young is something that'll keep you up at night. And my sense is we need to do something as soon as we can. We need to get the attention of these traffickers. Maximum of 10 years for filming a 5-month-old baby being sexually assaulted is not nearly enough. And I would ask for the committee's guidance on how you see we should proceed as long as we do proceed. Thank you, Mr. Chairman and members of the committee. I appreciate your time.
Thank you very much, Senator Diamond, for bringing this bill forward to the Judiciary Committee today. Are there questions for the bill sponsor, Senator Diamond? Senator Keim.
Thank you, Mr. Chair, and thank you, Senator Diamond, for bringing this. It's horrific. I only have one question, and that is I was wondering if the availability of the young children in rural Maine is likely because of drugs. Is it that they're selling their children for drug money? Is that, I mean, I'm baffled at why children are available.
I can't answer that, but there are probably others who could. I could answer part of that in that part of the reason for the rural proliferation of rural areas is because lack of maybe a more proficient or at least available law enforcement. There seems to be more availability to get the victims in and get them out. And now with the tendency to want the youngest of young, that for some reason seems to be the place where they can get their most production.
Thank you.
Thank you, Senator Keim. Representative Moriarty.
Thank you, Mr. Chair. Senator Diamond, are you aware of any data in Maine regarding the number of prosecutions and convictions for this crime currently?
I know the Computer Crime Unit, as you probably are aware of that organization in the state of Maine, which deals with primarily child pornography and trying to arrest these people, identify and arrest them. And I suspect that they would have some of that data, and I suspect truly that the DAs around the state would have even more availability to that information.
Okay, thanks.
Thank you, Representative Moriarty. Are there additional questions from committee members for the bill sponsor, Senator Diamond? Seeing none, thank you very much, Senator Diamond, for bringing this bill forward today. You are welcome to stay as a panelist for the rest of the public hearing if you have nothing else to do, but we all are pulled in many directions these days.
Thank you. I have a lot to do, but I would like to stay. Thank you.
Absolutely, you're more than welcome. I will now turn to persons that have registered to testify on LD 813, and I will begin by welcoming back District Attorney Sarbeck. And as the committee clerk moves the district attorney over, I'll take a deep breath.
I warned you all that you're going to see me.
We thought you were kidding.
I apologize for that.
Apparently not.
But thank you again for having me back. I am still District Attorney Jonathan Sarbeck here in Cumberland County, and I'm here in support of LD 813. Not to belabor the points that I made before, but one of the big things that we see with regards to enhanced penalties and where they're appropriate would be in situations such as Senator Diamond's bill. With regards to our most marginalized individuals, children, I should say, under the age of 14, enhancing the penalty from that Class B felony to a Class A felony, to me, really addresses the trauma that is induced by a person or by a perpetrator of this on a victim. Unfortunately, we know that adverse childhood experiences with trauma can be life-altering, coming roads, and certainly exploitation such as this would definitely fall under that category. As I mentioned, from a circumstances of comparing and contrasting sentencing laws, the federal sentence would be a 10-year mandatory minimum on a situation like this, and in Maine, when it's a Class B felony, it's a 10-year maximum, and there's no mandatory minimum on it. So I just want to bring that up to the committee so that they take that in consideration when it comes to the enhanced penalty that is in this LD. And that's why, as District Attorney in Cumberland County, I support LD 813, and thank Senator Diamond for bringing it to our attention. With regards to, and just in case I'm going to get the question, with regards to data on these types of aggravated sex trafficking charges, I would have to look into that information. I don't have it now. I can tell you though, over the last year, because of the pandemic, we have seen a decrease with investigations and crimes. And it's not to say that it's because crime is not going on. It's just when it comes to getting reported. As I'm sure you've all heard on this committee, that domestic violence crimes haven't seen a huge increase or spike during the pandemic. However, when you talk to advocates like Through These Doors in Cumberland County, calls to their hotlines are up 40%. And so that to me demonstrates why, or that a correlation between something not being prosecuted doesn't actually mean that it's not happening. We definitely know that when it comes to child abuse or neglect cases, oftentimes that it's very rare that you would actually get a parent or a guardian who would contact law enforcement and say, hello, I'm abusing or neglecting my child. Those reports would come in from other places, such as coaches, guidance counselors, social workers. And when you have kids who are doing remote learning, unfortunately, there aren't as many eyes getting on these children that might need that help. So I wouldn't correlate if cases aren't being prosecuted with it's not happening. But to me, the enhancement on this from a Class B to a Class A on that age range really does really go along and correlate with the damage that's done by someone who commits this offense. So I'd be happy to answer any questions.
Thank you very much, District Attorney Sarbeck. Are there questions from committee members for the Cumberland County District Attorney? Senator Keim.
Thank you. DA Sarbeck, I'm wondering, does this or any of the bills today that we're hearing, do they include the issue of child pornography? Would that be included in this?
Under the promotion of prostitution, I think that would, I'm looking at the statute right now. I think under, I don't know, well, if you're creating child pornography by basically trafficking your own child, then absolutely it would. But I believe that there are separate bills when it comes to child pornography that would be addressed under a different statute. I believe this does only go to the aggravated or the definition of promotion or promotes prostitution.
Okay, thank you.
Thank you, Senator Keim. Are there additional questions for District Attorney Sarbeck? Seeing none, thank you again for testifying. We're going to see you again, which will be later this afternoon.
Yes, thank you, sir.
Okay.
Thank you, everybody.
I would now turn to the attendee room to see if there are any persons wishing to testify in support of LD 813. If so, please raise your electronic hand. And seeing none, I will turn to persons interested in testifying against LD 813. We had one person registered. I do not see him in the attendee room, but I know there are multiple bills being heard in multiple committees today. He may be unavailable, but I will provide the opportunity. Are there any persons in the attendee room who wish to testify in opposition to LD 813? Seeing none, I will now turn to those wishing to testify neither for nor against. We did have one person registered, but again, I do not see him in the attendee room. But I will ask if there are any persons in the attendee room who wish to testify neither for nor against LD 813 to please raise your electronic hand. And again, seeing none and having received testimony from all those present wishing to testify, I now close the public hearing on LD 813. I thank the sponsor for bringing the bill forward and thank District Attorney Sarbeck for spending all of his morning with us. We are going to take a break, but we have two bills left. One has quite a few people to testify. I'm going to put that off until after the break. but we do have a bill that we could manage in a short period of time, and that is LD 1578, which is, sorry, an act to permit remote access for public proceedings. And our colleague, Senator Sanborn, is tied up in another committee, but my co-chair, Senator Carney, is here to introduce the bill on that. So I thought we would do that before we break. Senator Carney.
Thank you very much, Chair Harnett and members of the committee. LD 1578, Senator Sanborn's bill, really is quite similar to a lot of other bills that we have on remote proceedings, bills that we'll be doing work sessions on this afternoon. And she requested that I very briefly present the bill and then ask the committee to move into work session and vote ought not to pass, since again, this duplicates other legislation we have, and we'll have an opportunity to act on the policy issues raised by this legislation this afternoon in connection with those other bills.
Thank you, Senator Carney. I would entertain a motion to move into work session. Motion made by Representative Evangelos, seconded by Representative Moriarty. Up. I have been told that we do have people who have signed up to speak on this bill, and given that it is a public hearing, I have to provide that opportunity, and then we will take up the motion to go into work session. So with that, I will begin by people testifying in favor and recognize Victoria Wallach of the Maine School Management Association. If Ms. Wallach could be moved over to the panelists' status, I would appreciate that, Committee Clerk. Ms. Wallach, whenever you are ready, if you could unmute your microphone and activate your video and begin your testimony, and I will begin the 3-minute clock. Ms. Wallach, we need you to unmute your microphone and to activate your video, if you can hear me. Committee Clerk Soupy, is that something you can do from your end as a?
I'm trying, it's not working. She may not be there. She might just be.
No luck. Well, as we try to work out that in the interest of time, I will ask if there are any other persons in the attendee room who wish to testify in support of LD 1578 to please raise your electronic hand. Seeing none, I would ask if there are any persons who wish to testify in opposition, and I see we had one person registered to testify, Mr. Kaczynski, but he is unavailable. So it looks like we have Ms. Wallach back. So Ms. Wallach, welcome back to the Judiciary Committee. If when you are ready, if you could begin your testimony, and I believe you probably heard that this bill will be going to work session with an request or ought not to pass, if that influences the length of your testimony.
Yes, it does. We supported this. I am assuming it's going ought not to pass because there are similar bills, or?
That is correct.
Right. And we supported the other bill, LD, I believe it was 32. So I appreciate that information. We support the concept, and we also supported 32. Thank you.
Thank you very much, Ms. Wallach, and bonus points for wrapping it up so quickly. I didn't even get to start the clock. Again, I will check if there are any persons in the attendee room who wish to speak in support of LD 1578. To please raise your electronic hand. Seeing none, I know that we had one person registered to testify in opposition to LD 1578, and I would welcome to the panel John Kaczynski. Mr. Kaczynski, nice to see you again. If you could please begin your testimony whenever you are ready, and you'll have a 3-minute limit, but I would remind you that this will be moving to work session with a belief that it will be moved ought not to pass.
Representative Harnett, other esteemed members of the Judiciary Committee, I'll try to be briefer than my friend Vicky Wallach. We oppose this bill and we support LD 32 as amended. Thank you for your time.
Thank you very much, Mr. Kaczynski. We'll have to go back to the videotape to see who was indeed faster, but we'll let you know as soon as the results are in. I will now ask, just to check the attendee room, if there's any person wishing to testify in any capacity on LD 1578, to please raise your electronic hand. Seeing none, I will go back that we had a motion to go immediately into work session by Representative Evangelos, and I believe it was seconded by Representative Moriarty. Was that correct? Okay. And I would ask if we could do this with our electronic hands. All those in favor of going into immediate work session, please raise your electronic hand. I am seeing lots of hands. I'm going to ask you all to lower your hand, and just to see if there's any person who is opposed to us going into work session. And seeing none, we will go into work session on LD 1578, and I would entertain an ought not to pass motion. Representative Evangelos, you move ought not to pass on LD 1578?
Yes, I do, sir. And it was Kozinski in a photo finish.
It was. Thank you very much. We have a motion made by Representative Evangelos, seconded by Representative Sheehan. I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty. Oh, I apologize.
Yes.
I was a yes too. I'm sorry. I was on mute.
I'll recall. My apologies for stepping on you. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I will call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Thorne. Representative Thorne is absent. Mr. Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent.
Thank you very much, Committee Clerk Panett. We have moved ought not to pass on LD 1578. And before breaking, Representative Poirier, is your hand up for a question?
Nope, I must have not hit it or hit it twice. Sorry.
No, I know the feeling. Okay, we have one more public hearing to do. I need to give committee members a break and also the committee staff. We will pick back up at 1:30 with the public hearing, and then we have 16 work sessions to work our way through after that. So enjoy your next almost 45 minutes. Thank you.
Okay.
A reminder to shut off video and mute your microphones.
Oh my God. Okay.
Oh, good for you. Good afternoon. We are waiting for members to join. We promised to get back at 1:30. And I'm just going to get 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We have 10 members. So I think I have to wait for Soupy to get back to her office. I'm not sure if we're broadcasting right now. Just check that.
Yeah, I think we are still streaming.
All right, then I will begin by opening a public hearing on, well, first of all, welcome back. I hope people had a restful break, if that's possible these days, but you had some break. I will now open the public hearing on LD 1455, which is an act to support survivors of sex trafficking and exploitation. And I would ask our committee clerk to bring over the bill sponsor, Representative Talbot Ross, to introduce that bill. I'm just going to mute first. And I see that we do have the bill sponsor, Representative Talbot Ross, in the panelist room. Welcome back to the Judiciary Committee, Representative Talbot Ross. And whenever you are ready, please begin your introduction of LD 1455, an act to support survivors of sex trafficking and exploitation. Nice to see you again.
Thank you very much. Nice to see all of you as well. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Rachel Talbot Ross. I represent House District 40, which comprises the neighborhoods on the peninsula of Portland. Thank you for the opportunity to present LD 1455, an act to support survivors of sex trafficking and exploitation. Survival. When you speak of survivors of sex trafficking or individuals who are actively engaging in prostitution, the one word that you will hear the most on why that individual is in what they call the life is survival. They need to survive, and they have no other way. Unfortunately, the information that has been shared by individuals in the life is that the vast majority have experienced a range of traumatic events, including child abuse, sexual assault, substance use disorder, poverty, food insecurity, housing insecurity, racism, and mental health issues that have led them to this place. Due to these experiences, they are more susceptible to falling victim to traffickers who use them to make a profit at their expense, both physically and psychologically. Even after being trafficked, many end up in such dire circumstances that they know of no other way to survive. This is an existence that nobody would wish on their loved one or anyone else. LD 1455 amends the current law that prohibits engaging in prostitution in two ways that are reflective of the change in the mindset to view people engaged in prostitution as victims as opposed to criminals. The first change is to make the affirmative defense, which places the burden on the defendant to prove by a preponderance of the evidence, into a straight defense, thus requiring the prosecutor to prove that the person is not actively trafficked, is not being actively trafficked, as described in section 852, subsection 2. As logic describes, a person cannot consciously or voluntarily make a choice if they are not in control of themselves. The person in control is the one making the decisions. It should be on the prosecutor to demonstrate that this person is not engaging in prostitution due to being compelled to do so, as opposed to the individual who's being compelled. The second change is to create a new defense to engaging in prostitution, which we believe demonstrates why most individuals are in the life: survival. The stories that have been rehashed by numerous survivors as to why they engaged in prostitution. They speak of being involved in a life to stay warm and safe and have a place to live, access to food, avoiding withdrawal from drugs due to severe substance use disorder, threatens their lives, such as siblings or parents or children in their families being sent back onto the street to experience more rape, beatings, and possible death. By allowing a defense that accounts for a defense of bodily injury, so serious economic hardship or another threat to the person or another person, we recognize that those individuals who are engaging in prostitution to survive and why they are stuck in the life. I'd be happy to answer any questions. I thank you for your attention. I do want to note that there are folks who are here that want to testify in their own voice about their experiences. So if you have any questions about specifics about this life and all of the ways in which we have relegated a number of people in our community to only having that as a pathway for survival, I would like for you to hear it from their own voice. And I hope that you can keep an open heart and mind and ears as they describe extremely painful and traumatic life experiences. But those questions should be asked for them to answer in their own lived voice, their own experiences. Thank you.
Thank you very much, Representative Talbot Ross, for bringing this very important bill forward to the Judiciary Committee. Are there questions from committee members for the bill sponsor, Representative Talbot Ross? Seeing none, again, I thank you very much for your time and testimony today.
Thank you.
And I will now begin calling on persons who have registered to testify in support of LD 1455. And I will remind all persons that we do have a 3-minute clock for testimony from anyone other than the sponsor. When there are 10 seconds left, I will hold up my telephone, and that's an indication that it's time for you to wrap up. So I will begin by welcoming to the Judiciary Committee, Dee Clark. And Dee, it will be nice to see you again. When you are ready, if you could unmute your microphone and activate your video, and you begin speaking when you are comfortable, and I will start the clock at that time. Welcome to the Judiciary Committee, Ms. Clark.
Thank you. I'm just pulling up my testimony. Good afternoon, distinguished committee, Representative Harnett, and as our chairperson here.
Yes, my co-chair, Senator Carney, is here as well.
Thank you for having me. I'm here to support LD 1455, an act to support survivors of sex trafficking. I'm Dee Clark. I'm the executive director of Survivors Speak USA, a Maine-based nonprofit addressing all things prostitution since 2014. Not all survivors who interact with Survivors Speak have apartments, family supports, or a path out of the life. Survivors Speak tries to help with that and help create a path out. It does happen. Not one survivor I have met want to be in that life. They do it because they have been left with nothing else. There is no appropriate outreach to them. Since COVID, including us, Survivors Speak, has stopped our active outreach to the survivors there. But the survivors did not stop meeting basic needs, so they didn't stop engaging in prostitution. The affirmative defense as written is exclusive and difficult to use. It is exclusive for a sex trafficked survivor. For the survivor to access an affirmative defense, the survivor must prove they're being trafficked as the way it sits now. Often survivors are afraid to admit they are being trafficked in fear of the trafficker's retaliation. And some survivors have children with their trafficker. By removing the word affirmative, it will lift the burden of proof off the shoulders of the survivor, leaving it to the prosecutor to prove. The other important change that's major in the state of Maine is in the second part of removing the affirmative defense. Removing affirmative also helps a person who's engaging in prostitution to prevent serious economic hardships. Right now, someone who's engaged in prostitution strictly for survival isn't seen as a victim of trafficking. So rather as court or wherever, they're not seen as worthy of affirmative defense. Most survivors I met during the years of doing anti-trafficking work are stuck there. Many are homeless and have no means to basic needs, a bathroom, a meal, a safe place to sleep, and many have substance use disorder. It is so oppressive to be that marginalized and alone, and the only way to survive is to exchange sex for resources and sexploitation. Passing LD 1455, survivors of prostitution who are not being trafficked will be able to access a defense based on their dire plight of poverty and dependency on substances. Passing LD 1455 will still support traffic victims. It will not hinder their defense. It just makes it a defense for those suffering in sexploitation, survival sex. Thank you so much for your time.
Thank you very much, Ms. Clark, and thank you very much for testifying on this bill in front of the committee today. Appreciate your time and input. Are there questions from committee members for Ms. Clark? Seeing none, again, thank you very much for being here today with us. I will now turn to our next person registered to testify, and that is Desti Homan-Sprague. Ms. Homan-Sprague, welcome to the Judiciary Committee. And as soon as you are ready, begin your testimony. And as I indicated, we have a 3-minute clock. I'll show you the clock when there's 10 seconds left. So welcome.
Hello, good afternoon, Senator Carney, Representative Harnett, and members of the committee. I'm happy to join you here today on behalf of the Maine Women's Lobby. For over 40 years, the lobby has advocated for policy which increases the health, wellness, safety, and economic security of Maine women and girls, with a focus on the most marginalized populations and communities. We're here today in support of LD 1455 and also in support of Ms. Clark and Survivor Speak, who we have been long partners and allies with. I want to thank Representative Talbot Ross for sponsoring this important legislation. In addition to being here on behalf of the lobby, I just want to flag that I come from 11 years at the Maine Coalition Against Sexual Assault, and in that role, I staffed the Attorney General's Human Trafficking Work Group and the statewide sex trafficking provider network for a number of years. So I have a lot of familiarity with these issues. I'm really excited to be here today on this proposal. It may seem straightforward, but it's really the result of years of work on this section of the criminal code focused on an effort to reduce the harm of criminalizing commercial sex for these individuals. I want to take a minute just to provide some context for commercial sex work from a statistical perspective. We know that there's a clear connection between the experience of trauma or violence and engaging in commercial sex, that the majority of people doing it have experienced violence, gender-based violence, and childhood sexual abuse. We also know there's a clear connection between economic marginalization and commercial sex. Not all people engaged in commercial sex have traffickers, pimps, or exploiters, but they may have at some point, and we know folks move back and forth on the continuum there. Regardless, the vast majority of folks are people of color, members of the LGBTQ community, especially trans people, and overall people who experience higher rates of poverty, unemployment, and houselessness. So we know that there's a direct connection between experiencing marginalization and essentially being either forced, coerced, or finding themselves in a situation where this is the only way to survive. When our economy and cultural norms exclude or ignore some populations, the street economy is a path to survival. The criminalization of these activities disproportionately affects the most marginalized populations. We see over and over again, and in Maine, the people who are being arrested and charged for these crimes tend to be young people, queer and trans people, Black and brown folks. Criminalization also results in lifelong stigmatization that makes people less safe. This bill does not dramatically overhaul the system, and I'm happy to talk about some of the technical details, but I'll leave it to DA Sarbeck to do that. What it does is moves us toward reducing the harm of criminalization and ensures that we recognize that all of these folks are deserving of safety and dignity and not punishment. I thank you for your time on this issue. I'm happy to talk further, and I hope to join you at the work session.
Thank you very much for your testimony, Ms. Homan-Sprague. Are there questions from committee members? Seeing none, again, we thank you very much for your time and testimony, which I know it has been submitted in written form for committee members' review. We look forward to seeing you at an upcoming work session. And I will now turn to Elizabeth Ward. I'm sorry, I'm going to back up. It looks like we have a question from Representative Newell for Destiny Homan-Sprague. Representative Newell.
Thank you, Mr. Chair. No, my question is for you, sir.
Oh.
I was just reviewing the testimony, and I was just wondering if Ms. D. Clark will be providing a copy of her written testimony, or can you please direct me where I could find that?
I did not find it in the portal that I used to look for testimony, but I just received a message from Ms. Clark that yes, she will provide it in writing.
Thank you.
Thank you, Representative Newell, for raising that point. So at this point, still in her car, I recognize Elizabeth Ward Saxel and welcome you back to the Judiciary Committee.
I just got my second shot. I'm in the parking lot here in Bangor, the cross.
Ms. Ward Saxel, you're breaking up a bit.
The timing worked out just perfectly. Thank you so much for that. I am Elizabeth Ward Saxel. I'm here on behalf of Maine Sexual Assault Support Centers, who often provide.
Whoops. I believe we just lost Ms. Ward Saxel. So as she tries to return, I would ask the committee clerk to bring in our next person to testify, District Attorney Sarbeck. And after his testimony, we will see if we can find Ms. Ward Saxel again. Welcome back, District Attorney. Please begin your testimony as soon as you're ready to go.
Thank you, Representative Harnett, Senator Carney, members of the judiciary. I am Jonathan Sarbeck, the District Attorney in Cumberland County. I'm here in support of LD 1455. I was very honored to be asked to help Representative Talbot Ross, along with D. Clark, Tiara Ross, and Destiny Homan-Sprague craft this legislation in recognition of what we see, unfortunately, every day when it comes to this charge of engaging in prostitution. And it's very much what Representative Talbot Ross spoke about when she introduced this bill was survival. I can say, I'm happy to say that there, like I testified earlier, but there has been a shift in law enforcement, very much seeing individuals who are engaged in this life as victims as opposed to criminals. At the same time, I know that Cumberland County it might not happen like that in other parts of the state. And it doesn't always happen in Cumberland County either. And so what I think this legislation does is that it recognizes the very aspect of what we see and what we hear from victims and survivors of sex trafficking is why that they're engaged in prostitution. There's been many times that law enforcement has done investigations looking for traffickers and end up speaking to people who are engaged in prostitution. And even if that individual at that time is not actively being trafficked, the reason that they are engaging in prostitution is very much that they don't have any other means to get the basic needs that they have, whether it be shelter, whether or not be food, but also if they have a substance use disorder, it's something that's they're using in order to get that money to ward off basically becoming ill from withdrawal. So it really does recognize what those needs are. And as a defense, and I think as a prosecutor, yes, it would be more difficult to go forward with this charge, but at the same time, it does not negate the fact that we would be able to prosecute. This is not a decriminalization or a legalization. It really is just a recognition of many people who are engaged in prostitution and a means for that person to basically defend themselves or have the burden on the prosecutor to prove that that person's not doing that. So I think that, and this is wholeheartedly why I would like this committee to vote ought to pass in your support of LD 1455, and I'd be happy to answer any questions.
Thank you very much, District Attorney Sarbeck. Are there questions from committee members? Representative Evangelos.
Thank you, Mr. Chair. Hello again, District Attorney. It's just a
Good
comment.
afternoon.
It'll only take a second. But I just wanted to tell Mr. Sarbeck how impressed I am with his body of work with this committee this year, right across the board. And thank you for that.
Thank you, sir. And thank you to everybody on the committee for all you're doing. I'm impressed by everything I see from this committee because I know it's very hard work that you all do. So thank you.
Thank you, Representative Evangelos. Thank you, District Attorney Sarbeck. Are there additional questions for District Attorney Sarbeck? Seeing none, does this mean you are free to leave us today?
I am, and I appreciate the committee's time and Representative Talbot Ross for having me speak earlier. So thank you very much.
We appreciate your input. I will now wait for, I believe, Lucia Lombardi to be moved over as a panelist. And Lucia, as soon as you are ready to begin your testimony, just unmute your microphone and turn on your video and begin to speak when you feel comfortable. Right now, we are still seeing that you're, apparently Ms. Lombardi had to leave for a medical appointment with her son. And D. Clark, you have her testimony to read? If that is the case, if Ms. Clark could be moved over, Supi?
Thank you. We were ready for earlier and then things changed.
Okay.
Anyways, and she had to take her son to his medical appointment and they have to take buses. So I have her testimony and I can read it on her behalf.
Okay, go ahead, ma'am.
Good morning, Senator Carney and Representative Harnett and distinguished committee members. My name is Lucia Lombardi. I support LD 1455, an act to support survivors of trafficking. I am a survivor of prostitution. The last time I was involved with prostitution was to survive, to access food, a place to sleep, and drugs. At that time, when I was arrested, there was no assistance to show I was only there due to extreme poverty. I was in prostitution just to survive. Affirmative defense was not for survivors like me. It still is not helpful as it is written. It is only for sex traffic survivors. During that time in my life, I was an autopilot, barely surviving, exchanging sex to pay for basic needs. Many of us were not there because of a trafficker, but because of survival. We were stuck, and it was the only way to survive. Today I am sober, and I live with my son in Lewiston because I eventually got help from my lawyer who helped me get an apartment and into rehab. The last time I was in prostitution was 2014. I asked you, please pass LD 1455 so it will better be ready to help sex traffic survivors and survivors of sexploitation, survival sex. Thank you.
Thank you very much, Ms. Clark, and please thank Ms. Lombardi for her testimony when you next see her.
I also have Chelsea's and Ruby, Chelsea and Dawn. We thought it was earlier and they left, so.
I understand. Why don't you continue, and I will start the clock on each person's testimony.
How about I take a break and let Amanda, who's also a survivor, read hers, and Tiara, who's also a survivor, who are on the list.
Okay, you can do that, but right now I have Quinn Gormley who's going next, but if Soupy, if you could move in the two.
We can wait.
Women referenced. No, I'll start with Quinn. Quinn, welcome to the Judiciary Committee. As soon as you are ready to begin your testimony, you know the drill. You've already unmuted yourself and activated the video. Proceed when you're comfortable.
Thank you. Can you hear me okay?
Hear you just fine. Nice to see you again.
You too. Senator Carney, Representative Harnett, and members of the Judiciary Committee, my name is Quinn Gormley. I use she, her pronouns, and I join you today on behalf of the Maine Transgender Network. We're here today to express our enthusiastic support for LD 1455, an act to support survivors of sex trafficking and exploitation. Transgender people participate in survival sex and sex work at disproportionate rates. According to our most recent survey data, about 13% of transgender Mainers are actively participating in some form of survivor sex, which is higher than even the national average for transgender Americans and significantly higher than the average for Mainers. The burden of this work is not shared equally across our community. A variety of factors leave certain trans people at uniquely high risk for exploitation. First among them, here in Maine, are homelessness and youth. Young trans people, especially young trans women and trans people of color, experience homelessness at concerningly high rates and often struggle to find stability, consistent income, and basic resources such as food and gender-affirming medical care. Young, homeless, and struggling, and often isolated from traditional family support systems, as well as belonging to a population uniquely prone to stereotyping and fetishization, trans youth make prime targets for trafficking and exploitation, that they are treated as criminals when they need help. I know from my personal experience how terrifying it is to need help and not know if you can get it. At one point, when I was younger, I had no other means of income, and an older man offered me money and housing in exchange for favors, and I got hurt. I was raped, I was strangled, and I had to fight for my life. And when I did escape, I didn't seek out medical attention or call the police for help, because despite being injured and victimized, I was terrified the police or DA would see me as the criminal and charge me, and that the possibilities for my life would narrow even further. Most people exposed to survival sex are not criminals. They're not victims of exploitation. They are victims of exploitation and socioeconomic coercion. If prosecutors want to charge someone with this crime, the burden of proof must be on them to prove exploitation isn't the cause. I urge you to pass LD 1455 and welcome any questions.
Thank you very much for your testimony today, Ms. Gormley. The committee appreciates your taking the time and to share such a personal story with us. Are there questions from committee members for Ms. Gormley? Seeing none, again, thank you for your testimony. I would note that it's also been submitted in written form so that committee members may review it after the conclusion of the public hearing if you hadn't had the chance to do so before. I will next call to the panel. I'm sorry, do I see a hand up? You were high up on my list. Representative Libby.
Thank you, Mr. Chair. I would just like to say that I appreciate the chair giving permission for testimony to be read by someone other than the person who submitted it. I know that has not always been allowed in the recent past. It's always more powerful to hear someone's testimony spoken aloud. So I am glad to see that. And I hope that this is going to be the precedent in our committee moving forward, including in cases where a fellow legislator has asked for someone in this committee to read their testimony aloud when they were called to another committee. Is that going to be the precedent moving forward, Mr. Chair?
It has typically been the precedent that we allow members of the public to read in testimony for other members of the public. It has not been the practice for legislators to read testimony into the public. That's the precedent of the committee, but I'm willing to discuss this moving forward, but I'd rather move on with the hearing right now.
Thank you. I appreciate that. I would like to discuss this further at the best near opportunity.
Thank you, Representative Libby. And I apologize for missing your hand. I've got a lot of people in my list here. I would now ask Tiara Ross to unmute the microphone and her video and begin testifying as soon as you're comfortable.
Good afternoon, Judiciary Committee. My name is Tiara Ross. I live in Portland, Maine with my 10-year-old son. I am also a local business salon owner, the advocacy coordinator for Survivors Speak USA. I am also a survivor of sex trafficking, and I was trafficked for over 13 years. I am here to support Bill LD 1455, an act to support survivors of sex trafficking and exploitation. Being a victim of prostitution, I had many negative interactions with law enforcement. And at my last arrest 5 years ago was the hardest. Law enforcement set me up in a sting operation. There, they called my pimp by his name. I refused to testify because I feared my pimp. So I asked for a lawyer, and law enforcement got mad and took away my child and sent me to jail. When I went to court, my bail conditions were no contact with my trafficker. What's important here to understand that the police and the courts knew that I was being trafficked, but affirmative defense was never an option for me because I would not testify. Affirmative defense does not work because the burden is on the victim, and most victims do not testify on their traffickers because we are terrified. Getting rid of affirmative will allow the victim to be in freedom, and the burden will be on the prosecutor instead. I wish there was a law like this when I was in the life and getting arrested. I've been arrested 7 times while being trafficked. I suffer from depression and PTSD from all the constant trauma in my life trying to survive. Having a criminal record held me back from living a normal life, getting a good job or home. For over a decade, I lived in motels, cars. I had 1 meal a day, if any. I walked around many dark streets and alleys from 9 at night to 9 in the morning. I've been beaten by my traffickers, sex buyers, and raped numerous times and had weapons pulled on me. I did not think I would be alive today. Even getting my son back was also a struggle because of my criminal record. It was awfully close that he was going to get adopted and I was never going to see him again. By adding an amendment to Section 853, subsection 5 is also important. The burden will not be on me to testify. Therefore, the defense will be on the prosecutor to understand that this was the only way for me to survive due to economic hardship, and I would have a clear record. I was recognized as being a traffic victim, but never treated as such, only being treated like a criminal. I never got justice. Today, I hope you all realize the importance of Bill LD 1455. Please pass LD 1455 to support and help survivors of prostitution. Thank you.
Thank you very much, Ms. Ross, for taking the time out of your day to present your testimony. Are there questions from committee members for Ms. Ross? Representative Evangelos.
Thank you, Mr. Chair. Hi, Tiara. That was very powerful testimony, and I wanted to thank you for it. I just wanted to make sure I heard something right.
Okay.
That the police knew you were a victim
Yes.
of trafficking, and they set up a sting
Yes.
against you rather than trying to help you?
Yes.
Thank you.
Are there additional questions from committee members for Ms. Ross? Seeing none, I will now turn to Elizabeth Ward Saxel. Hopefully we have a better connection than the last time. And if you do start breaking up, Ms. Ward Saxel, you can try shutting off your video and just using your audio.
Well, now trying to join you from the Dice Arts parking lot. We'll see if this is better. I am Elizabeth Ward Saxel and submitting testimony today on behalf of the Maine Coalition Against Sexual Assault, whose providers provide services and support for victims of sex trafficking. Many thanks to Assistant Leader Talbot Ross for her work on this issue. If someone is compelled into commercial sex by force, fraud, or coercion, both Maine and federal law recognize that person as a victim of human trafficking, and as a result should not be prosecuted for the crime they are forced to commit. That's why the affirmative defense currently exists. This bill simply addresses the how of avoiding prosecution for trafficked people. In order to use the current affirmative defense, attorneys representing trafficked person have to know about the affirmative defense and to know to be screening for trafficking in the clients they serve. Due to the inherent economic nature of this crime, for many survivors, these attorneys are court appointed and may not, based on their experience or sheer capacity, be aware of the defense or be adept at screening. Likewise, trafficked people may not know this defense exists. It's easier to train all prosecutors to screen for trafficking and use the defense when prosecution charges arise than it is to train all defense attorneys. And the onus should be on us as the state to lessen the impact of trauma in whatever way we can. Also, an affirmative defense is proven in court, which means that the trafficked person needs to go through a potentially traumatic proceeding in order to be cleared of prostitution charges. This can be psychologically damaging. To avoid this and the risk that their defense not be successful, they may be more likely to accept a deferred disposition or a plea deal, leaving them with potentially criminal penalties and or a permanent criminal record. Changing it to a defense lessens the pressure on these defendants. The second component of this bill would add a new affirmative defense to prostitution crimes if the person can prove they did so to prevent bodily harm, serious economic hardship, serious injury, or another threat to the person or another person. While sex trafficking victims are compelled through force, fraud, or coercion by the trafficker, sexual exploitation victims may be coerced by their economic situation. Sex exploitation survivors experience many similar hardships to people experiencing sex trafficking: trauma, physical violence, dire economic consequences, and much more. It is so critical that the code recognize serious economic hardship as a potentially coercive factor so we can better support people who have experienced sex exploitation. Currently, there is no protection from prosecution for people experiencing sex exploitation and not sex trafficking. We know that sexual exploitation is a major issue in Maine, and we must do a better job responding to these survivors. Thank you, and I'd be happy to answer any questions the committee may have. And thank you for your patience with me with my bad signal.
Thank you very much, Ms. Ward Saxel. Are there members of the committee with questions for Ms. Ward Saxel? I just want to make sure I'm seeing everybody. Seeing none, thank you very much for being here today. And I hope you have no negative reactions to your vaccine. And I will now, I want to, upon further thought, Ms. Clark, given the length of our work session scheduled today and the fact that the testimony you were going to read has been submitted in the record, I am not going to have it read live because we simply have too many bills to work this afternoon. But it will be reviewed by members of the committee, and I will look to the attendee room to see if there are any other persons present in the attendee room who wish to speak in favor of LD 1455. If so, please raise your electronic hand.
Thank you, Representative Harnett.
Oh, thank you, Ms. Clark. I hope you understand. I would ask that Kate Knox be moved over as a panelist. And that will take a couple of seconds. And as soon as she appears, Welcome, Ms. Knox, back to the Judiciary Committee. Whenever you are ready to go, I will start the clock when you begin testifying. Thank you for being here.
Thank you for having me. Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. My name is Kate Knox. I'm a resident of Portland, and I'm testifying on behalf of my client today, Equality Maine, and their partners at GLAD. Equality Maine and GLAD support LD 1455. Sex trafficking is a crime typically hidden within communities and societies due to the stigma associated with being LGBTQ. LGBTQ sex trafficking is even less likely to be reported to local authorities. The horror of trafficking, as you've heard today, often starts with children. Crimes committed against child trafficking victims, threats, extortion, theft of property, documents, false imprisonment, result in an immeasurable amount of short and long-term physical, mental, and emotional harm. Minors are targeted more frequently because they are easy to manipulate and unable to protect themselves. LGBTQ minors who are homeless are at the highest risk for sex trafficking and sexual exploitation. According to the U.S. National Coalition for the Homeless, homeless LGBTQ youth are much more vulnerable to sexual exploitation and trafficking than other homeless youth. For instance, only 20% of homeless youth are LGBTQ in the US, and 58.7% of them are exploited through sexual prostitution. This is a much higher rate than the 33.4% of non-LGBTQ homeless youth that are at risk of exploitation on the street. Unfortunately, current law criminalizes not just traffickers, but also victims. And when law enforcement comes into the picture, the marginalization of LGBTQ people can lead to profound consequences. In some cases, victims are ignored because sexual violence against males is often not taken seriously. Many boys and young men don't report their ordeals, and those who do find an absence of services available for them. In other cases, victims are targeted. Transgender women, particularly trans women of color, as you've heard, are more likely to be arrested on sex work charges than any other demographic. LD 1455 is a critical bill because it will strengthen the tools that victims have to defend themselves. You've heard about the changes in sections 1 and 2, and so I won't go into that detail. It's in our written testimony. But taken together, the changes proposed in this bill would give those who have been trafficked and exploited and then ignored and targeted by the authorities a more fair opportunity to defend themselves. And after everything they've been through, they deserve that. We respectfully ask that you vote ought to pass. And thank you. I'd be happy to answer any questions.
Thank you very much. Thank you very much, Ms. Knox, and thank you for providing your written testimony as well. We appreciate your time and input. Are there questions from committee members for Ms. Knox? Seeing none, again, thank you very much for your time today.
Thank you.
Appreciate it. That is all that I believe that I had registered to sign up to testify, but I do want to give a chance. If there's anybody in the attendee room who wishes to speak in support of LD 1455, please raise your electronic hand. And seeing none, if there's any person in the attendee room who wishes to speak in opposition to LD 1455, please raise your electronic hand. And again, seeing none, if there are any persons in the attendee room wishing to speak neither for nor against LD 1455, please raise your electronic hand. And Soupy, I am not seeing anybody. Are you?
I am not, Mr. Chair.
Thank you very much for confirming that. Well, I want to thank again the bill sponsor for bringing forward LD 1455 to the Judiciary Committee. And I appreciate all persons who came to testify. And having received testimony of those present and wishing to testify today, now close the public hearing on LD 1455.
Thank you.
Thank you all. And with that, I will turn the virtual gavel over to my co-chair, Senator Carney.
Thank you very much, Representative Harnett. And now we're going to change gears a little bit and begin a very long series of work sessions on bills. We will begin with opening the work session on LD 1273. And just so that members of the public are aware, we do have 17 work sessions, I believe, today. And so we're going to be really focused in our work. A work session is not a repeat of the public hearing on a bill. And so we'll typically only hear from our analyst, perhaps the bill sponsors, and then very limited opportunities to bring in others to weigh in on the bills, because again, we just do not have, we've done public hearings on all of these bills, and we just don't simply have the hours in the day to do a review of a repeat, excuse me, of the public hearing. And so with that, we'll open up the work session on LD 1273. That's an act to establish conviction integrity units in Maine. And our legislative analyst, Peggy Reinsch, has joined us and is going to give us a kind of a top line analysis. My tongue is all tied up this afternoon, analysis of the bill. Thank you, Peggy.
Great, thank you. As you said, this is an act to establish conviction integrity units in Maine. And the idea is to create a unit, as the bill is drafted, in each prosecutorial district as well as in the Attorney General's office to determine whether there is evidence of innocence, a constitutional violation, or prosecutorial misconduct, or when the facts and circumstances require a review in the interest of fairness and justice. And the testimony was that, and actually states across the country are creating conviction integrity units. And I believe we have, somebody had provided us with some best practices from Massachusetts. There was some discussion at the public hearing about maybe Maine, with its population and its size of its district attorney's offices, that maybe would make more sense fiscally and actually procedurally to have one conviction integrity unit that would cover the whole state. It would cover all the district attorney's offices as well as the Attorney General's office. For those prosecutions. But if you do that, it would have to be definitely separated from any of the prosecutorial criminal division in the Attorney General's office. I see Representative Evangelos has his hand raised, and I don't know if I should stop now or keep going.
Okay, let's, yeah, Representative Evangelos, go ahead.
Thank you. I don't want to interrupt the analysis, but I do want to speed the day up. Peggy just indicated that the Attorney General and the had weighed in, and so had the prosecutors, and they both were supportive of this idea. And in the analysis, the Attorney General said that there should be one conviction integrity unit housed in his office, and that it would be appropriate to ensure the firewall of independence that I've always insisted on. Therefore, I want to take him up on his offer. I'm going to ask him if he can have Chris Taub possibly help me draft the appropriate language to bring it in as an amendment. Chris Taub no longer has cable TV or the sovereignty issue on his table right now. So, so anyways, I'm going to move to table and bring that amendment in as timely fashion as possible.
Thank you so much, Representative Evangelos. So there's a motion to table. Is there a second on the motion to table? Seconded by Representative Sheehan. And committee members, let's, I think we typically do vote on our tabling motions. What I'll do is I'll call those in favor and have you raise your electronic hands. And then once our committee clerk, Ms. Panett, has recorded all the favors, we will lower our hands and then call those who are opposed, okay? And so let's start with all those in favor of the tabling motion, please raise your electronic hand. And again, just leave it raised, please.
Anybody? I have 10.
I believe so, although the boxes are moving around a little bit. Okay.
Representative Evangelos doesn't have his hand up.
I had it up, but you said it was 10, so I took it down.
Oh.
Yeah, well, let's just, so that we can do this in an efficient way, leave your hands up if you are in favor of the tabling motion until I indicate that we've counted everyone, please. So now it looks like there are 11 in favor.
I have 11 too.
Okay.
11 also, excuse me.
Great. Thank you so much, Ms. Panett. So the motion to table carries. So we will table LD 1273 and the work session on that is concluded, and we'll move on to our next.
Thank you, Madam Chair. That only took 4 minutes, gang, so let's go.
All right. Thank you so much for bringing that up early in our work session, Representative Evangelos. Now we'll open the work session on our next bill, which is 1303, an act to ensure judicial discretion in sentencing. And Peggy, if you would like to give us the analysis, we're ready when you are.
Right. So the purpose of this bill is to actually, you know what? I think this is your second work session on this bill.
It is, I think.
And I believe that Representative Warren wanted to provide an amendment, and we talked a little bit about an amendment last work session, and I think you needed some more time to look at it. The amendment, and I actually don't have it in front of me, so let me see if I can pull that up. The amendment, so the bill was very broad and said no minimum sentences, no mandatory minimum sentences. We're going to write a couple of sections in statute that overrides everything that's in all the statutes. And there were some concerns about that not being clear to everyone what was really happening. And so Representative Warren focused on just mandatory minimum sentences in the criminal code, as well as directing the reviser of statutes to come up with a list of statutes throughout the titles that have mandatory minimum sentences, or sentences where a minimum amount cannot be suspended. And I think that's what we were talking about last time, and I'm not sure where you are now.
And Peggy has the proposed amendment from the sponsor that's dated 4/29. I think it's a 10-page amendment. Has that been distributed to all committee members?
I believe it was distributed at just in time for the last work session.
Okay.
And you didn't have time to look at it really.
Okay. Can you please just take us briefly through that particular amendment?
Right. You have the one dated on the 29th, right?
Yes.
Yes. Okay. So would you like me to screen share that?
Vicky, can I ask? I have a 1-page amendment. I'm not aware of a 10-pager.
I'm sorry, it's not a 10-page. Oh, sorry, that is an old one, I guess.
May I also ask, mine is dated 4/28, the long amendment, with a 4/29 in parentheses underneath. Is that the one we're talking about?
To tell you the truth, I'm not sure which one Representative Warren was interested in you looking at.
Okay, let's do this. Let's just quickly check in with the bill sponsor, and then we will, as a committee, look at the amendment that the sponsor wishes to offer. So let's.
Could I ask Representative Moriarty what the date is on his amendment? Not the one.
It's, it came with a letter from Representative Warren dated April 20. The amendment itself is not dated.
Okay.
It's 3 paragraphs long.
Right. That was her amendment that she presented at the time of the public hearing, and she revised it at the work session. So that amendment actually changes it from that amendment, instead of making them mandatory, the bill made mandatory minimums into mandatory maximums. And so she was fixing that. And since then, she has suggested amending the mandatory minimum sentences only in Title 17A. And so that would be the 10-page amendment, which I believe is posted.
Yeah, it actually is dated 4/28, but on each page at the bottom, it's dated 4/29, so it probably is the same thing.
Right. And I need to change my footer because that's the date it's printed.
Oh, I see.
That's fine. I think we're all on the same page now, so to speak. And Representative Warren is not available just now, but perhaps you could just screen share, Peggy, because that way we'll all be looking at the same thing and understand it. Thank you.
Okay. All right, so this is the 10-page amendment. And so the first section is amending, just remember that her purpose is to get rid of mandatory minimum sentences, restore judicial discretion. So this is the crime of stalking. It's in Title 17A, Section 210A, and this is what's being struck out in determining the sentence for a violation. This is actually part of the sentencing analysis, how the three steps the court goes through in order to determine what the sentence is. And this is telling the court that they cannot require that basic term of 2 years or 1 year based on it. I know in talking with the AG's office, they're not sure that this would be determined to be a mandatory minimum sentence, but I think this is how Representative Warren, in working with Mr. Pelletier, we've kind of identified every place where it says here's a mandatory discussion of a term. This is special sentencing provisions for gross sexual assault. And this is the same process that the court has to select a specific term in setting a term of imprisonment. Same thing, the court may not suspend that portion of the maximum term of incarceration based on a prior conviction. So again, giving the court complete discretion, they can suspend. And then this is in the drug crime, 17A 1125. This is a section that applies to the whole chapter of drug crimes, and it imposes a minimum term of imprisonment, which may not be suspended based on the class of crime. So this whole section would be struck from the criminal code. The section about mandatory minimum term of imprisonment for a crime. This is general sentencing, not just drug crimes, but mandatory term of imprisonment for a crime with use of a firearm against an individual. Based on the class of crime, there is a mandatory minimum sentence which may not be suspended, and this would take those out. Mandatory minimum sentence for certain drug crimes. I think that might be it. And then the last piece is, maybe this is what you want to focus on, is directing the reviser of statutes to review all the statutes, find any place where the statute requires the court impose a mandatory term of imprisonment. And it kind of gives a little description, not only does it say mandatory term of imprisonment, it would also include a required minimum term or a term of imprisonment, none of which may not be suspended. So it's trying to get at all the different ways that we talk about that in the statutes. The revisor of statutes would take that report, which would really be a list, and it would be a copy of the text of the statutes, and turn that over to the Criminal Justice Committee. The Criminal Justice Committee would then walk through each section and determine if it makes sense to take out the mandatory term, or change it if they wanted to keep some kind of, something that couldn't be suspended. They would be able to do that. My understanding there are some federal grants that are tied to some mandatory minimum terms, which might be motor vehicle related, but I'm not sure. But this would give the Criminal Justice Committee the opportunity to walk through that and figure out what makes sense on a crime by crime basis.
It looks like Representative Reckitt has her hand raised. I think she has a question for you, Peggy. Go ahead, Representative Reckitt.
Peggy, as I was looking at the summary, it looked like the bill was intended to eliminate mandatory minimums in some sections of the code. This first paragraph in the, oh, maybe it was, no, sorry, maybe it was in the, yeah, no, that's it. So is the intent of the bill to repeal those particular mandatory minimums right now, and then ask the revisor to compile a list of everything else?
Yes, I mean, the original bill was to say the court has discretion in all cases, give us a list and we'll go and amend the statutes after we've given the court this discretion. This bill says, let's amend these particular statutes in the criminal code, give us the list, and we'll go look at all the crimes outside the criminal code that have mandatory minimum.
Thank you.
I'm going to stop sharing again, but let me know.
Okay, and I'm just going to keep calling on committee members, Peggy, because I think there are a number of questions for you. Representative Reckitt, are you all set with your question?
Yes, I am. Thank you.
Thank you. And Representative Moriarty, go ahead.
Madam Chair, I just tried to print this off. My printer apparently doesn't work while the Zoom is in progress. So, Peggy, if it eliminates a mandatory minimum, does it open up the door to sentencing within the full time range provided for that particular classification of crime?
Thanks for the question. The maximum term is always available even with the minimum. So if it's a class D crime, you can get up to 365 days, and there might be a mandatory minimum of 3 days. So even under the current law, the court could sentence somebody to 364 days of imprisonment now. You're not changing that. What you're changing is the requirement that the court give them at least 2 days. So that's going to be gone. They can give them 2 days, they can give them 5 days, they can give them 365 days. Whatever the court in its discretion determines is the appropriate sentence for that crime.
So basically the maximum period of incarceration per classification of crime controls.
It controls now, and it continues to control for the
judge can do anything from probation or 0 all the way up to the maximum.
Under this bill, they could do 0. Without this bill, there are some crimes where they are required to impose some penalty, some term of imprisonment.
Committee members.
Okay, very well.
Peggy, I had a question for you. You referred before to raising a question about some federal grants that are implicated or provide, there's reasons why we couldn't eliminate mandatory minimum.
Yes, and I don't know that firsthand.
Okay. Do we know whether any of the, I think it's the 4
in 17A
5 sections are implicated?
I believe they are not implicated. So no, I don't think those are the ones. I think there are some other, and I'm actually only repeating what people have said that had been working on this. This was actually an issue that the Intergovernmental Pretrial Justice Reform Task Force looked at, and they even put together a list of some of the mandatory minimum crimes outside of the criminal code as well. But it's not an exhaustive list, and they will tell you that. So in 2015, they've started talking about doing this and returning full discretion to the courts. We just haven't gotten to it yet. So this bill, I think Representative Warren was trying to implement those recommendations, which was to get rid of all mandatory minimum, but realizing we haven't specifically identified them all, it's not necessarily a responsible thing to do to get rid of them when you don't know what you're doing. Exactly.
Thank you. Representative Libby?
Thank you. I don't have a question per se, but I do have some comments. It is interesting to me that we are working this bill on a day when we've heard testimony regarding the issues with sex trafficking and exploitation in our state. And I understand the good intentions of the bill sponsor, but I am left wondering why we would be starting with minimum sentences regarding stalking, gross sexual assault. Those two in particular, to me, strike me as issues that should have a great deal of thought to removing a minimum sentence, those two in particular. And I feel like with the workload that we currently have, that this bill is not going to get the due process that it should. And those two pieces, the stalking and the gross sexual assault, is what I really have a problem with in this bill, and that why would we just address those and the couple others, the firearm and the drug crimes, rather than looking at minimums in a much more holistic way, which we might be able to do if we were to slow down and do some sort of resolve. I don't know what that would look like exactly, but I feel like we should do a much more thorough job on this bill and several others like it.
Thank you, Representative Libby. I would actually just like to add that I have concerns as well. I think I would take the opposite approach that you do. I feel like initially we were presented with this holistic approach that didn't give us enough information about the specific statutes and the underlying policy reasons for original enactment of the minimums. And I'm finding that particularly with regard to the stalking, the sexual exploitation, and perhaps even the statutes related to using firearms, I feel like I don't know enough about the underlying policies for imposing the minimums in the first place. And then I'd like to know more about specific policy reasons for getting rid of the minimums now. And I just don't feel like we have that information. Peggy, you just said earlier, it's not good to get rid of something when you don't know what you're doing. And I kind of feel like that's where I am personally on the
So I think, I mean, one of your options is, of course, leave this for somebody else to put together a little bit differently, or you could just do, if you're interested in following up, you could do just the revisers, compilation of the existing statutes and give that to criminal justice. And then they would be able to look at stalking next year and the drug crimes and the use of a firearm and the gross sexual assault. Kind of here's the sentencing process, if that's something you wanted to do. And that way you wouldn't be identifying a particular crime. You'd say, let's look at all these in particular. And maybe there is some reason why certain crimes have mandatory minimums. Maybe there's some correlation between different crimes that you don't see until you get the whole picture.
Thank you. Thanks a lot, Peggy, for those comments. Representative Poirier?
Thank you, Madam Chair. And mine's more of a comment as well. And Madam Chair, you raised the same concern that I had as far as the federal grants that we could lose if we change, and not knowing which parts of the bill may be applicable to that. I would not want to vote in favor of the bill, not knowing what could be affected by the outcome. So I wouldn't be comfortable voting in favor of the bill at this time either.
Thank you, Representative Poirier. Committee members, are there additional comments and discussion regarding the bill? Go ahead, Representative Harnett.
Thank you. I share all of the concerns that have been articulated. One, I want to know about the federal funding. Two, the crimes of stalking and gross sexual abuse jumped out at me. I don't know if the minimums are proper. I don't know why they were selected. I would need to know. I mean, one can take the policy position that there should never be mandatory minimums. I just don't know enough about how we got to where we are, and the reasoning behind that, and the tying it into federal funds, particularly with gun violence. So I don't know enough to pass the bill in this form. I would like to see it studied, and I don't know if the best place to do that is just to keep in section 5, which is the revisor report and legislation on page 10.
Representative Sheehan?
Really, I just wanted to echo what everyone else has already said. I don't know enough, and I also am very concerned about eliminating mandatory minimums in the areas of stalking and gross sexual assault. So that's where I'm at.
Thank you. Other committee members? Representative Reckitt?
Just have a quick question. I looked up the summary of LD 1303 on the legislative website stuff. And it has a piece of what the last House and Senate actions were in the bill. And this one says that on the 30th of March, which seems a long time ago right now, it said it was carried over in the same posture to a subsequent special or regular session of the legislature of the 130th. That can't be accurate, can it?
Go ahead, Peggy.
I could explain. If you remember, that is when you adjourned the first regular session. And so without the joint order to carry it over into the special session, it would have died. So that's a carryover. It's extremely confusing, but that is actually its posture.
Okay, thank you.
Yeah. Committee members, how would people feel about retaining section 5 of the bill, which is the revisor report to criminal justice, with an opportunity for criminal justice to introduce legislation in the second session?
Go
ahead.
The only thing I would want to do is I would want to make sure that they were going to look at the crimes that we are, it appears, not going to eliminate the mandatory minimums on by striking out the rest of the bill. I mean, I would want to know what their recommendations were on those crimes as well. Or is that clear to somebody that's not me?
No, that's a really good point. So the crimes that are currently contained in this, the April 29th amendment, you would want those to also be looped into that study.
Right.
Yeah.
And I think they would be. And I don't think the revisor's office would be doing any analysis. They would just be combing the statutes and producing a list.
Mhm.
And it would be totally up to the Criminal Justice Committee to decide what to do with those statutes.
Okay, thank you.
And then they would report out a committee bill. Is that right, Peggy?
That's my understanding, yes.
Representative Libby?
Thank you, Madam Chair. I don't want to belabor this. I just am trying to figure out why the Criminal Justice and Public Safety Committee would be putting forward legislation on this next year. Why we ever heard this bill in the first, where that jurisdiction is.
Peggy, do you want to answer that? Or
So the Judiciary Committee's jurisdiction and the Criminal Justice Committee's jurisdiction have always overlapped. There used to not be a Criminal Justice Committee, and almost everything was in the Judiciary Committee. So it's kind of been evolving back and forth. And I think this year folks decided that sentencing bills would come to the Judiciary Committee. And so that's why you've been dealing with sentencing. The actual elements of crime bills are mostly in the Criminal Justice Committee. I think you could change that. You could have it come back to the Judiciary Committee and you could look at that. It's how the bill was drafted by the sponsor. The sponsor might not have been clued in at the time that the sentencing bills would be directed to the Judiciary Committee.
So, thank you, Peggy. That would make more sense to me that it would come, with us having started the work, that it would come back to us next year as well. Thank you.
Representative Harnett?
Thank you. And this is just a question for Peggy, and I think you may have already answered it. Criminal Justice had these bills up until the 130th, right?
Mm-hmm.
I believe so. Judiciary gets criminal procedure. So, but this was the first year that we kind of took over some of the sentencing jurisdiction.
Okay. Thank you.
Representative Moriarty?
Thank you, Madam Chair. I think for the reasons that everyone has articulated, the most that we can salvage here is the revisor report. I'm equally uninformed as those who have spoken before me as to the real detail and nuances of the proposed actions stated in the bill. So I'd be inclined to send this to the revisor for basically a compilation of all crimes for which there is an existing mandatory minimum sentence. On the committee assignment issue, the bill, for whatever reason, was referred to us. I assume that unless leadership determines otherwise, it remains ours. I don't mind our co-chairs double checking on that, whether it more appropriately belongs next door. But unless that's changed, I think it inevitably is going to remain ours. That's a rough suggestion that we simply approve Section 5 at this time. I don't know how the format of my motion what the format would be, but we endorse Section 5 and its provisions and perhaps table the rest.
Okay,
I need some guidance with that.
Good food for thought. And Representative Reckitt's hand is up, but also she sits on both committees. So maybe she's uniquely poised to help us understand a little bit more where the report might go.
Yeah, thank you. I recollect that last year on criminal justice, we sat with a huge compilation document about all the mandatory minimums in Fish and Game, driver's license stuff. I mean, it was just scads of it. The chair of that committee, one of the chairs at least of the committee, Representative Warren, has been focused on this issue for a long time. And has been, as you can see, she sponsored this bill, but there's been a lot of discussion about mandatory minimums in the Criminal Justice Committee. And I think that, frankly, the participants have a leg up in the understanding at this point, just because it's been going on there's several of us who've been there for now 5 years, and we've been talking about this for quite a long time. The actuality of a bill came up, I believe, 2 years ago, but was clearly, not taken care of in the time period. And so it ended up again here. So my personal feeling is that criminal justice is a better fit, at least as long as it's only for another year, because then there's a lot of people going to leave that committee, and then we'll have the same problem, no matter where it is, that people won't have already looked at the issue rather dramatically, or looked at the issue more thoroughly. At the present time, however, I think I love the fact that we would do the revisor piece, and I understand that the other crimes would be included in that review. And so it would be fine with me to just pass that section and get rid of the other one. But my recommendation is to send it to criminal justice, but it's really up to everybody.
Yeah, I'm of two minds about it, because sentencing is squarely within the jurisdiction of judiciary. And yet I think the policy reasons underlying the imposition of mandatory minimums, or that part of the statute, is also kind of tied to the specifics of the crime as defined in the criminal code. So I think it's kind of got one foot in either committee.
Yeah. I can't remember, I have to confess, whether or not we dispatched the fish and game stuff last time. If we didn't, and if we didn't take care of the driver's mandatory minimum stuff 2 years ago, and I just don't remember, then we're asking for heaps of trouble over here, because we then have all the fish and game and driver's license offenses here. And I don't know that that's not bigger than we want to deal with, but I should be able to remember whether we did that last time, but I don't. I apologize.
I don't think it was, because it was originally in this bill, I believe.
Yeah.
I see Peggy nodding. All right, so is there, go ahead, Representative Libby.
Thank you. This is a process question, I guess, maybe for Peggy. Is this section 5 something that, the chairs on either committee couldn't simply ask the revisor's office to provide a list? Do we need legislation to move this forward? Or, okay, so it is something that has to be legislated.
No, actually, I was nodding my head. That's a good question.
Okay.
I think that the revisor of statutes has a whole lot, that office has a whole lot on their plate. And if it's not in the statute and they had time to do it, they would do it. That wouldn't be a problem. They have some ongoing projects in addition to update. They're supposed to be doing, going through and making the statutes, taking out the gender specific pronouns, title by title. But anyway, I mean, I don't think you have to include that in the statute. The real benefit of it is to give the committee that this report goes back to the ability to report out a bill, which second regular session, there aren't as many bills let in. So I think that's the major piece there. You could ask the revisor's office to provide that kind of information, and I'm sure they would, providing all their other requirements they were able to fulfill.
Thank you.
Representative Harnett.
Thank you. I just want to echo what Peggy said. I think that's the important part of the bill, is that it gives the authority to whatever committee receives this report, the ability to report out legislation. Otherwise, without the statute, the revisor might not do it. And also the committee that receives it, if they do choose to do it, would have to go through some process to report a bill out. Is that accurate, Peggy?
That's my understanding, yes.
Okay. So, and that would be a concern to me because then we're kicking the can down to the 131st legislature possibly.
Any committee member wish to be heard more on this, or does someone have a motion that they would like to present? Representative Reckitt?
I'd like to move ought to pass as amended, and the amendment is to leave only section 5. And I can't remember who was the report back was to judiciary, right?
No,
criminal justice. So I would leave section 5 the way it was, and just eliminate the first part with the understanding that it would be included in the review.
So the motion is an ought to pass
as amended.
1303 as amended, the amendment being striking the bill and substituting just section 5 on page 10 of the April 29th amendment as the content of the bill. Is that right, Representative Reckitt?
That's right.
Is there a second? Seconded by Representative Harnett. Representative Libby, go ahead.
Thank you. I'd like to request a brief corner caucus.
Yes, that's fine. How much time would you like?
5 minutes.
Thank you. Okay,
Thank
so
you.
we'll all be back at 3:05.
Senator Carney?
Yes.
Just a 20-second question with the break. It'll give me an opportunity. I want to make sure what I'm voting on. What are the provisions, very briefly, of section? I don't have my file with me on this bill. So what are the provisions I'm voting on?
Yeah, I can screen share it if that is better for you. I can also just read it to you if you'd like.
Just even a quick summary, I'm happy.
So section 5 is the revisor report and legislation. And it basically asks the revisor to compile a list of all of the provisions that require the court in sentencing to impose a mandatory term of imprisonment. And it provides a couple of different ways that might appear in the statutes to make sure everything gets swept into that list.
I just want to know about the two things we're voting on that are affecting change. What were they?
And yeah, that's what this would be.
Okay.
So that's what I'm reading. So the thing is the list that the revisor will prepare and give to the Criminal Justice Committee by January 15, 2022. And then authorizing criminal justice and public safety to introduce legislation in the second regular session of the 130th.
Okay. So we're leaving two things in of chapter 5. Are we reducing or increasing something or not?
No, this would just focus on the preparing the list of statutory provisions where there's a mandatory term of imprisonment, and then delivering that list to criminal justice and public safety so that they can do a look at it, consider it, and report out legislation.
I'm sorry to take up your time. I'm good. Thank you for that.
No, that's all right. And again, I can screen share it if you'd like.
Or I can screen share again if you want.
I've got it.
Okay.
Thank you.
Yeah, you're welcome. I think it's always good to review exactly what is before us. I'm glad you asked.
If you don't, you get yelled at home if you don't know what you're voting for. You voted for that.
Did everybody get the amendment that I asked Peggy to send out on my bill?
On 1200.
Yeah.
Committee members, I'll be back in just a moment. I'm not going far. I'll be back in just 2 minutes.
I'm gonna go take a chance and make a cup of coffee. So I'll be right back.
I was looking for 1331. I usually save all my public hearing bills when I print them out. And I'm looking through my book, and I can't find it. Finally, I went online, looked at 1331, and the public hearing was like back in February before I joined.
I'm not even sure that's our bill.
1331?
Yeah, that number does not sound familiar to me, but
Well,
my
I
brain is
looked
not
it
what
up.
it used to be. What
It
is
said-
it?
I looked it up. It's protect student privacy.
Oh, 331.
Yeah. But
Yep,
it
we're
was,
getting to that. You're right,
Yeah,
that was before.
yeah, but that was geez, I had a public hearing back in February.
It did, and we didn't know at the time that there was another bill coming,
Yeah.
and so we waited.
Committee members, is everybody, if you're back at your desks, can you please activate your audio and video? And I think so we've had a motion by, I believe, Representative Reckitt and a second by Representative Harnett to pass 1303 as amended, the amendment being simply section 5 of the draft amendment dated April 29th. And committee, is there any discussion on the motion before we move to a vote? Okay, I am not seeing anybody who wishes to discuss, so I think that Soupy, if you are ready for a vote, I think we're ready.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I call the absentees. Senator Sanborn. Senator Kime. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 7 members voting in the affirmative, 3 in the negative, and 4 members are absent.
Minority report is simply ought not to pass.
Thank you.
Thank you. And with that, the ought to pass as amended motion carries, and we will close the work session on LD 1303 and open the work session. Thank you very much, Ms. Panett, for taking the vote. And we'll move on to the work session on LD 841. And, Peggy, I think when you're ready, we're ready.
Sure. So this is a bill about probation and deferred disposition, and Representative Warren's a sponsor, and it was a pretty far-reaching bill. You have held one work session on it already. It would have said most Class C crimes are eligible for probation, and not only eligible for probation, but that would be the presumed sentencing alternative, would be probation. And if you're going to do something else, you'd have to make a record of it, I think. And it listed several crimes that are Class C crimes. And you had a lot of testimony at the public hearing saying that's not a good idea to do this. And Representative Warren said she'd go back and rethink this, and what she, I think I shared the amendment from her. So what she wanted to do, oh, maybe she didn't, because she didn't, what she would like to do is strike everything in the bill except the last section. And the last section would be, would allow for deferred disposition. So most of the bill addresses probation. The last section on deferred disposition, as printed, it made a certain unlawful possession of a scheduled drug under section 1107A in the criminal code eligible for deferred disposition. Right now, deferred disposition is an option only if somebody pleads guilty to a Class C, Class D, or Class A crime. D, E, or C crime. There are several Class B crimes in dealing with drugs and in Chapter 45. And what her recommendation, Representative Warren wanted to recommend was strike everything from the bill but the last section and amend it to apply to allow any Class B crime under Chapter 45 would be eligible for deferred disposition. And so I did 2 things for you. I think I posted all the Class B crimes in Title 17A, Chapter 45. So you would have that, and I can pull that up and we can screen share that if you want. And I don't know that Representative Warren actually signed off on her amendment, but this is what we had talked about, was changing in section 5 where it says, what's underlined says unlawful possession of a scheduled drug under 1107A, subsection 1, paragraph A. It would say a Class B crime under Chapter 45 or. So it would make those Class B crimes in Chapter 45 eligible for deferred disposition, if that's an agreement that the prosecutor wants to go forward with. Everything else in the bill would go away.
And I note that Representative Warren has actually joined the attendee part of the meeting. So I'm going to bring her over because I know that she would like to weigh in on this. And then committee members, please think a little bit about whether you'd like Peggy to screen share the list of Class B crimes to which this amendment would apply. Representative Harnett, you had your hand raised?
Yeah, do we have this amendment, Peggy?
I have not shared it.
Okay, that's fine.
Partly, I mean, I think Representative Warren and I have missed each other in communications, and I can't share something in writing until I have authorization from a legislator. And if she says share it, Peggy, I'll be happy to. But
I just wanted to make sure I wasn't missing something. So
you're not missing something. I have promised you a list of the Class B crimes in Chapter 45, and I did provide that.
Peggy, you sent the amendment yesterday.
I did.
Yes.
Did you okay it? Okay.
I don't have the list. I have the amendment.
Okay.
It's,
sorry, yesterday was kind of a haze for me.
Well, it was about 5:23 p.m. No, okay. Yes, 5:23 p.m. last night.
Mm-hmm.
The list is on the Judiciary Materials website.
Okay. It is 28 pages long because I wanted to make sure you had the whole list of definitions, which is mind-numbing. Never mind having to use the drugs to get to that state. But there are plenty of Class B crimes. There are several Class B crimes in that list, and I'd be happy to walk you through that list. The first Class B crime doesn't even show up until page 8.
Let's take a pause here and hear from Representative Warren. Welcome, Representative Warren.
Thank you, Madam Chair. My committee just ended, so sorry to miss my other bill, but thank you. So I won't take up a lot of your time. I just want to remind you that this was a larger bill. I heard some concerns and I made it a much smaller bill. Currently, right now, if we're talking about drug crimes, a deferred disposition cannot be offered for these folks with this class of crime. That is literally all that it's done, is attempt to include Class B drug crimes. And this you might think of an example where by the time the charge is adjudicated, the person in the court has already been in recovery, possibly for maybe a few months. And a prosecutor might be like, you know, I know they're getting help, they're working, they've got their children, they're paying their rent. I'm not going to send them away. I'm going to make a deal with them and see if in a year there's no other charge, they're continuing with their treatment, they're working, they're paying their taxes, they're raising their children. I'm going to give them that opportunity. That's the deferred opportunity. So, excuse me, the deferred disposition opportunity. I thank you very much. That's all I wanted to add.
Thank you. And that's a helpful explanation. Appreciate that. Representative Harnett?
Thank you very much, Madam Chair, and thank you, Representative Warren. I assume this addresses the concerns raised by Judith Shaw dealing with financial crimes and other crimes of that ilk.
Yes, thank you for that question. She was very helpful. And as I sort of dug in more to what the original bill was doing, I just felt like, let's just focus on this very extremely small slice, just having to do with drug crimes. So literally that is all. It has nothing to do with what Ms. Shaw brought to us, and she was wonderful and very helpful. So.
Thanks. Committee members, other questions of Peggy? Well, let's do first other questions of the bill sponsor about the amendment. Go ahead, Representative Moriarty.
Thank you, Madam Chair. Representative Warren, I just need to clarify a question with you. am I correct in understanding that the decision of whether or not to offer a deferred disposition is entirely discretionary with a prosecutor?
Absolutely. Thank you. Yes, entirely discretionary with the prosecutor. And as you might imagine, prosecutors and others feel some frustration when they know that what they're forced to do isn't the best thing for either the person or the state of Maine and the taxpayers of the state of Maine. So this does allow discretion. So thank you for that question.
Okay, thank you.
Representative Harnett, did you have another question for the bill sponsor?
It was just answered through Representative Moriarty. Thank you.
All right, thanks. All right, I don't think we have any other questions for you, Representative Warren, so I'm going to send you back to the attendee part of the meeting and ask committee members if they have questions for our analyst.
Thank you.
Did you want me to screen share the amendment? Now that I know I can.
Yes, please. I think that would be really helpful.
So this is what it is. The 2 pages go down to 1 page and just this change. Eligibility for deferred disposition. And not only does the prosecutor have to agree to it, but the court has to sign off on it and the conditions of the deferred disposition as well. So it's actually a court order what the person is required to do for while their disposition is deferred. And then at the end of that time period, it's the court reevaluates.
Thank you, Peggy. I see a couple of hands up. I think Representative Moriarty was first.
Thank you. Peggy, you raised a question a moment ago as to whether or not the amendment had been signed by the sponsor. Is this in a posture to be voted upon?
I have a confidentiality obligation to somebody who asks me for help, a legislator who asks me for help, and I can't share their amendment until they authorize me to share their amendment. So I didn't remember that I had shared it with you yesterday, so I was worried about sharing it without that authorization. But it turns out she authorized me to do it yesterday anyway. That's all.
So it's in the,
it has nothing to do with the substance of the amendment.
Right, but it's in the proper posture.
You know, it's your bill and you can do whatever you want with it. So,
okay. All right.
Yes.
Good, thank you.
Yes. Thank you for asking.
Representative Harnett?
Thank you, Madam Chair. I move ought to pass as amended.
Thank you, Representative Harnett. Is there a second? Seconded by Representative Evangelos. And Representative Libby, go ahead.
Thank you. I just wanted to ask Peggy, in reading through the list of Class B crimes, it seems like there's a pretty extensive amount of trafficking included in that list. Everything you've highlighted all of the Class B crimes. Thank you. That must have been quite a job, Peggy. So thank you. Thank you for doing that. Just in speaking to the bill, I guess in light of what seems pretty extensive trafficking that will still be included in this as a Class B crime, I will be voting ought not to pass on this bill.
And I'm not trying to dissuade you. I would never try to persuade or dissuade anybody. But if I could just back up a little bit about the drug crimes. The drug crimes are usually possession. So somebody has something in their possession. Mm-hmm. Furnishing, which means they're providing it to somebody else, right, but without having any kind of compensation. Or trafficking, which means they are selling it. So they're making money from it. There are kind of presumptions based on the amount you have. Mm-hmm. A usable amount is kind of presumed you're possessing for your own use, whatever it is. And that's a lower level crime usually. It depends on the type of crime. We have these scheduled crimes, Schedule W, Schedule X, and I couldn't talk to you about what they are because they're mesmerizing to me. So then there's possession, and then there's furnishing, which is a little bit more. If you have a little bit more of this drug, it's not presumed that you're going to be selling it, but it's more than you would be using for yourself. And so we think you're going to be sharing it with somebody else. It's an illegal drug. You shouldn't be sharing it with anyone else. That's why you have more than kind of a usable amount. And then trafficking is when you're making money off of it. So if you have this much, then we assume you're selling it.
Right, and I can see those. You did a great job of outlining those with the highlighting in here. I'm specifically focused on the sections, like the section person furnishes 300 or more pills. That's certainly more than any one person could possibly consume. And I think of all of the issues we've seen with folks, whether it's fellow nurses that have fallen into addiction with oxycodone or something like that, I would not be comfortable making furnishing or possessing 300 pills of anything in these categories as not acceptable, because I realize they're having deferred disposition, but I would not want to have that in that category. Thank you.
That's why I think it's important that you had the list to look.
Yes, I appreciate that very much, Peggy.
Representative Harnett?
Thank you very much, Madam Chair. Just so I'm crystal clear here, Peggy, this doesn't require deferred disposition. It places that tool in the toolbox of both the judge and the district attorney. It cannot be demanded by the defendant. It has to be offered by the district attorney and then approved by the judge in a court order. Am I correct on that?
That is correct. And I think what Representative Warren was saying is there are some situations where the defendant is actually in a good place and not letting them go through deferred disposition would make things much worse for them.
Thank you.
Go ahead, Representative Libby, and then Representative Newell.
Thank you. I just am curious, Peggy. So if a prosecutor thought that a situation was unique and that the situation warranted it, could they decrease the level of the crime if it was a Class B and decrease the level so that that person could get deferred disposition? Change the class?
So they'd have to have them plead to a different crime.
They couldn't reduce the charge.
They might be able to reduce the charge. I don't know. I mean, they'd have to have the evidence to be able to do that.
Thank you.
Representative Newell?
Thank you, Madam Chair. I'd just like to follow Representative Libby's line of questions regarding the Class B crimes. I think it's item J is what she was speaking about in the 300 more pills. And I was looking at K and L. L is coming across, if I'm reading this correctly, that this violation is a Class B crime if serious bodily injury occurs from trafficking a drug. Correct?
I'm not sure which section that Representative Libby was looking at, but there are quite a few Class B crimes. And you're right, sometimes if serious bodily harm is involved, it does increase the crime, or if they have prior convictions, it increases the class of crime. But I think Representative Libby was looking at one possession statute.
Okay, I'm on page 10. And I just want to make sure that I'm reading this as some of this is highlighted. So page 10, item K. That would be classified as a Class A crime.
I am not seeing Okay, on my page 10.
It's right above the highlighting.
Wow. So it must have come through different pages.
Okay, so are we only referring to?
I see. Are you saying death of another person is in fact caused?
Yeah.
No, that's-
Yes.
Right. So that you're right. That's a class A crime that would not be eligible under this bill.
Okay, so I'm only paying attention to your highlighted.
Yes.
That reflect. Okay, class B. Okay.
Right. So you're right. Paragraph L would be eligible.
Can I just note to Representative Newell, the K that I was referencing is on page 12.
Okay.
Thank you both. Any other questions, committee members? We have a ought to pass as amended motion. Is there any discussion on the motion? Is the committee ready for the vote? It appears that we are. And Ms. Panett, whenever you're ready, I think we're ready for the vote.
Very much. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Need to hear you.
Yes.
Thank you very much. Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Just to make sure, I just came on a few seconds ago. Is this 8:41?
Yes, that is correct.
And I will vote no.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Madam Chair, I have 8 members voting in the affirmative, 4 members voting in the negative, and 2 members are absent.
Thank you very much, Ms. Panett. And what is the minority report?
Ought not to pass.
Thank you very much. And so the motion carries 8-4 with 2 absences. That closes the work session on LD 841. We will move on to open the work session on LD 957, an act to reform alternative sentencing programs. And I think that we had a work session on this already, I think, and we had asked Senator Maxman to come back to us with some information about other counties because we only heard about Lincoln County. Is that right, Peggy?
I think so. And I also had put together an amendment based on your discussions and the work you did last time.
Thank you. And I'm just looking to see, I don't see, oh, there she is, Senator Maxman. So I'm going to bring her in so that we can check with her about what she learned from other counties, and then we'll do the bill analysis and amendment. Welcome, Senator Maxman. How are you?
I'm doing well, Madam Chair.
I sent on to the clerk 2 or 3 documents technically. One has responses from DAs from 9 of the 16 counties on their alternative sentencing programs and their fees and what they think about this legislation. DA Irving represents Knox, Lincoln, and Waldo counties, and she sent me an example of what a deferred disposition would look like with LD 957 and without. And so I had sent that all into your clerk yesterday. I don't know if it made it through.
Okay. Can you give us kind of a summary of the information you received, please?
I can. An extra point from DA Irving is that if this bill does not pass, then we are in the same position of not being able to get people into the programming. And I think you heard last time that no one is unable to attend the program due to financing in Lincoln, Waldo, and Knox counties. In Kennebec County, DA Maloney says that she uses the program for nearly everyone facing a jail sentence of 2 to 10 days, and it would be beneficial to have the option for them to complete the program without a conviction, because right now they have to secure a conviction to go through the program. It's $175 for 2 days and $450 for 10 days. In Penobscot County, DA Lynch said that the Penobscot County Jail is saving so much money that the cost is easily waived of the program. And Androscoggin, Franklin, and Oxford County, DA Robinson said that there's a program run by the sheriff that's $185 for a 2-day program and $400 for a 7-day program. And in Cumberland County, DA Sarbeck said that they have closed for now their alternative sentencing program, but when they did it, it was $300. And so that's the information from that. And then on the deferred disposition that DA Irving sent me with LD 957, it basically adds an option for someone to complete the program without a conviction, and that option is not on the one as they currently use it now.
And are other counties, do they feel like they cannot offer the option now? Because, let me retract that sentence. Did DAs from other prosecutorial districts indicate that passing LD 957 would allow them to expand their deferred disposition programming, or did they feel like it was a neutral as far as impacting the extent to which they could offer the program?
There was no comments specifically about whether it would expand the program or not, but multiple folks did say that they would like to be able to send folks into the program without a conviction, but they can't right now, and that's what this bill would do. It was a very long email chain with lots of DAs on it, and so I tried to distill all the information for you, but no one mentioned that specifically. I also see that DA Irving is in the attendees room if the committee wanted to hear from her as well.
Okay, thank you very much. Committee members, are there questions for Senator Maxman? Go ahead, Representative Hagan.
Thank you, Madam Chair. So, hi, Senator. Nice to see you. Did I hear you say that that they're doing so well? The county jails are saving so much money on these things that they're willing to waive those fees, the 200 plus or the 400 plus ish dollar amounts for the 2 and 10-day stays?
So I got different answers from different counties, but in Lincoln, Waldo, and Knox, no one is unable to attend due to financing. And specifically in Penobscot County, DA Lynch said, this is a direct quote from her email, "The cost is $75, but because it is saving the Penobscot County Jail so much money, the cost is easily waived."
Okay, could I do one follow-up?
Yes, go ahead.
So in my notes from last time, oftentimes I can't type fast enough, but I thought that it said that somebody had said, maybe you'd know, that if I don't have the $400 or what have you for the 10 days, but I'd really rather not be in jail and do community service, that I'm allowed to make payments of say $20 a week or month until the amount is paid.
I would direct that question towards DA Irving, as I couldn't accurately answer that question for you.
Right now where I got that info, so shot in the dark on that one. Thank you.
Committee members, any other questions for the bill sponsor? Senator Maxman, I'm going to send you back to the attendee list, and Peggy, if you could continue with your analysis, we'd appreciate it.
Right. So I think everybody was agreed what the idea of the bill was to allow somebody who's on deferred disposition. That means they've pleaded guilty. They have an agreement between the DA, the defendant, and the court to carry out, do different things, different requirements. It might be community service, it might be education, it might be paying back some restitution, and during that time of deferred disposition. And at the end of that time, they reassess and they can end up with a conviction of a lower class crime or actually dismiss the charges depending on what it is. The bill itself referred to alternative sentencing, allowing people in deferred disposition to be part of an alternative sentencing program, which you can't be unless you've been convicted. So just our terminology wasn't working. And CLAC pointed that out, and Chief Deputy Maker had some language, and I think we have some refined language. And I realized I just posted it in, and if you refresh, you'll see it, but I can also share the screen. And so it's amending the same sections that are in the bill, but it makes it clear that it's the court imposed deferment requirements can be part of the sheriff's program, because that's who's running these programs, are the sheriffs. If they don't have this authority in statute and somebody gets hurt, or this covers their liability all the way around. If somebody gets hurt for workers' comp, whatever. So I'm going to share this. That's what we're trying to do, is authorize people who have not been sentenced but are in. Oh my gosh, my computer went completely black.
Uh-oh. Can you still hear us?
Your voice is still there, though.
It'll come back in a minute.
I think you're
okay,
on your
good.
way back.
I didn't lose my Zoom. It'll come back. Don't look at my email. Goodness gracious. Okay, I'm going to try again.
Thank you.
That was a stress test, I think. So this was the bill that we're striking out right here. And instead we'll say the court imposed deferment requirements may include a requirement that the person participate for a specified number of days in a program run by a county sheriff that may involve overnight housing, community service work, and education. And I think those were all the things that the different programs are offering around the state, those that have alternative sentencing programs. And this would allow, again, we're talking about the discretion of the prosecutor and the judge signing off, and the defendant actually agreeing to this, to be part of this program that we're not going to call alternative sentencing, but it's going to be a deferment requirement. So it's, yeah.
And is there a similar change in section 2 of the bill, Peggy?
Yes, so in Title 30A, so that's in the sheriff's language. The sheriff may permit certain inmates of that jail, as well as others required to do so pursuant to 17A 1902, subsection 1, which is section 1 of the bill, to participate in public works related projects or an improvement of property owned by. So that's just saying we're going to take these people from deferred disposition and we're going to let them participate in these sheriff's programs.
thank you.
Okay.
Committee members, any questions for Peggy while we still have the screen share going with the specific language? Nope. Okay. Thanks, Peggy.
Right.
And Senator Keim had her hand raised. Go ahead, Senator Keim.
So I've just been in another committee. Is there a motion on the floor?
Not yet.
No.
Okay, I would make a motion not to pass as amended.
Is there a second? Seconded by Representative Harnett. And committee members, is there any discussion? Representative Thorne, you have your hand up?
Thank you, Madam Chair. Just to make sure, the official name of this bill
Right
now is?
I did suggest changing the title as well, which here, you want me to screen share real quick?
Is that part of the amendment?
It is, which I didn't point out, so I appreciate you bringing attention to it. So right now it's called an act to reform alternative sentencing programs. I would suggest you change it to something like an act to authorize expanded deferred disposition requirements. That's
Thank you, Representative Thorne and Peggy.
Authorize expanded disposition programs.
deferred disposition requirements.
Representative Hagan?
Thank you very much, Madam Chair. I would like an answer from whoever we would deem qualified DA on if they can't afford it, are they allowed to make small payments until it is paid?
Okay, I can bring in DA Irving to the panel to answer that question. And I just would, since we are kind of moving toward a vote, I'd like to just have that specific question answered.
Yeah, that's all I have.
Yeah, thank you.
Thank you.
Hi, can you hear me?
We can.
Hi, I thought that I was done, so I was on my way to a meeting and I'm pulling over as we speak. But I understand the question. I just want to make sure that I'm in a safe place while I'm thinking about the answer. So luckily I have hands free to do all of this. All right, so I'm pulled over safely. So my understanding is that the question from Representative Hagan is, if a person is unable to pay for this, can they make a small monthly payment, something along those lines? So the answer is kind of yes, it's kind of nuanced, but the way that deferred dispositions typically work is that we assess a fee based on someone's ability to pay during the course of that deferred disposition. So that could be a 12-month or an 18-month period. And for somebody who's indigent, that fee may be completely waived. And for somebody who's hired their own attorney out of pocket, we might charge up to $50 a month. So those are on a sliding fee scale. And Lincoln County right now, all of those fees that go into Lincoln County from Lincoln County are used right now if somebody needs to offset. So I cover 4 counties. I cover Saginaw, Lincoln, Knox, and Waldo counties. And if anyone is sent to alternative sentencing program from any of those counties and they can't afford it, what we would do is request from, a request would come in through me or through the sheriff's department to waive that cost. And what we would do is the sheriff's department or I or both would just alert the county that those funds were being requested to offset. So we have an MOU in place with Lincoln County. So that's kind of a long answer, but yes, that mechanism is in place. What I would potentially do with the expanded ability, because I see this as really expanding the programming, so we would really be able to have more folks in it. And I think the Lincoln County Sheriff's Department would be looking at having more capacity. And again, Lincoln County runs it and other counties are sent to it. What I would look to do in my counties is get MOUs to offset from each county. Yes.
Okay, I just want to check in with Representative Hagan and see if you've answered his question.
Yep.
So if you don't mind me is Representative Hagan, Do you feel that your question's been answered?
I think that was an outstanding answer. Thank you very
All
much.
right.
Thank
Committee
you.
members, does everybody feel satisfied with that information? Looks like we do. Thank you so much for being safe and providing such great information today.
You're welcome. I don't hear that very often, that I've had an outstanding answer, so I'll take that as a win. Thank you so much.
Take care.
You too.
All right, Representative Reckitt?
Yes, I just wanted to understand, is the only amendment the change in the title? Or did I fall unconscious in the middle somewhere here? I mean,
There's 3 changes. One is the title, and then there's a change each to section 1 and 2 to more accurately describe the program because it's not technically alternative sentencing.
okay, thank you.
And we can, Peggy can screen share the specific language if you'd like to see
No,
it.
it's fine. I just wanted to know the topical.
Okay,
Thank you.
you're welcome. Committee members, are we ready for a vote on the ought to pass as amended motion? Looks like we are. And Ms. Panett, thank you so much for joining us.
You, Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes,
I have to see you. I'm sorry.
sorry. Yes,
Thank you. Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Madam Chair, I have 13 members voting in the affirmative, 0 in the negative, and 1 is absent.
Thank you very much, Ms. Panett. And so the motion ought to pass as amended carries. We'll close the work session on LD 957. And Representative Evangelos, did you wish to speak?
Yes, I wanted to see if Natasha Irving was still with us.
She is not.
Okay.
Hold on a second. Let me just double check. Well, she is.
Oh, she is.
She's listed in the attendee space. I do know she's driving.
Okay. I just wanted to see if she had her baby and see if everything was good.
Okay.
Yeah.
Thank
Sorry to say that out loud.
you to mention that.
We live 5 minutes from each other.
Oh. Okay, committee members. So we'll close the work session on 957 and open the work session on LD 1200. And Peggy, do you want to give us a kind of a top line bill analysis? And I know there's an amendment as well.
Sure. So the analysis is this amends the Business Corporations Act. It's Title 13C of the statutes. I do see that DA Irving has said she did have the baby. And this bill requires, by certain deadlines, each board of directors of a publicly held corporation that's subject to the Maine Business Corporation Act, so it's incorporated in Maine, to include at least one female director. And the Secretary of State is supposed to collect that information and report that information. And after 2023, let's see, after 2023, so in 2024 calendar year, the number of directors on the board, if it's 6 or more, the corporation would have a minimum of 3 female directors. If it's 5, the corporation would have to have a minimum of 2 female directors, and otherwise the corporation has to have a minimum 1 female director. The Secretary of State's office had testified that they don't actually, they're not an enforcement agency, that they would not be looking at this information. So if this is something that you want to go forward with and you want the Secretary of State's office to track, then you would need to have them report it in their annual report. And so Representative Reckitt has worked with the Secretary of State's office, and I did share that amendment with you, and that does those things. It amends what has to be reported in the annual report to include how many female directors they have and whether they're publicly, whether they're a public corporation, which means they're, it's not a private corporation. There are public stockholders, and it changes the deadline. So the Secretary of State's office has a little more time to require this. It had the corporations have a little more time to get on board with this, and then the Secretary of State's office will be able to share that information and report. And I'm trying to pull up that amendment real quick for you so you can also look at it. And I'm happy to share the screen if that's what you would like.
Committee members, do we need, does everybody have access to the amendment, or would you like Peggy to do the screen share? I'm seeing a lot of shaking heads. Doesn't look like folks need the screen share. Okay, are there, Representative Harnett?
Thank you, Madam Chair. A quick question for Peggy. It completely removes an enforcement mechanism, correct?
Yes. Absolutely. Thank you for asking. I forgot that the bill had a fine, a pretty significant fine for non-compliance, and the Secretary of State's office asked that not be included because that's not something that they engage in, and so the amendment strikes that out.
Thank you. Then, Madam Chair, I would move ought to pass as amended on LD 1200.
Thank you, Representative Harnett. Is there a second on the motion? Seconded by Representative Sheehan. Representative Moriarty, you had your hand up. Do you have a question or a comment?
Madam Chair, is there anyone from the Secretary of State's office in the attendee room?
Let me look.
Yes, Emily Cook is there.
Oh, great. Thank you. Do you have a question?
Yes, I do. When Secretary Bellows was with us a couple of weeks ago, I asked a question about the breadth of the bill or the scope of the bill and whether it applied to all domestic corporations in the US or just to those which were chartered in Maine. And she said that she would need to check with people within her corporate division. So I don't know if Ms. Cook is positioned to answer that question.
Let me bring her in unless Peggy has an answer, but
right. Well, I've been working with Ms. Cook on this amendment, and I failed to identify that, yes, indeed, we actually limited this to a domestic publicly held corporation. A domestic corporation means it's incorporated in Maine. A foreign corporation could be incorporated in New Hampshire, and I know Ms. Cook will correct me if I'm wrong, but we consider it a foreign corporation if it's not incorporated in Maine. It doesn't mean it has to be in England or
okay.
Canada.
So this doesn't apply to General Motors, for example.
Correct.
And
okay, thank you.
Representative Moriarty, Emily Cook has joined us, and Ms. Cook, welcome to the Judiciary Committee. Did you want to answer Representative Moriarty's question?
Sure. Thank you, Senator Carney. I just would say that what Peggy said is right. Just usually the safest way to go.
Not always.
Actually, I have a question for you, Ms. Cook. How many publicly held domestic corporations are there to which this would apply?
My understanding is it's not too many, but I think if you look in the waiting room, Kathy Bodwin, who is the director of our corporations division, is, I believe, in there and might have a more specific number.
Thank you very much. Any other questions for Ms. Cook? No, go ahead, Ms. Poirier, Representative Poirier.
Thank you, Madam Chair. Just real quickly, I believe it was Representative Libby had asked Secretary Bellows for a preliminary fiscal note on this. Was that able to be compiled for us?
Yes, let me pull that up. So we put together a fiscal note for both the original bill and for the bill as amended. And I've sent it to Peggy so you can, maybe she could screen share my email.
Yes, sorry.
Sorry, I sent that after after we sent the amendment. I would note, so the amended version would not have any fiscal note.
So can everybody see that? I'm not sure how to increase the size of my email.
That's, I think the relevant thing is if there's no fiscal note.
Okay.
In the amended version, that's probably as much as we need at this point.
Okay, yes, the fiscal note on the original bill would have been over $200,000 each year.
Representative Poirier, did you have follow-up questions on that point?
I do not, thank you.
Any other questions for Ms. Cook? Thank you. I'm going to move you back to the attendee. Oh, go ahead, Representative Libby.
Thank you, Madam Chair. Thank you for being here, Ms. Cook. I guess my question is, I'm trying to figure out why was the fiscal note because of the work that it would entail to collect the fines, or what was that related to?
I believe
on the original.
Sure. So that's because the staff structure that we have now doesn't have the authority to collect fines. And if you collect fines, we need to have both investigations and enforcement, and that would entail new staff. And since those staff wouldn't be necessary in the amended bill, and we can just change the form in-house, that's why there's none on the amended bill.
Gotcha. Thank you.
I think we're all set with questions, Ms. Cook. I'm going to send you back to the attendee and just quickly ask Kathy Bodwin to answer the numbers question.
I think that if I could speak for a sec.
Actually, let me just, let's get this one piece of information, Representative Reckitt, and then we'll, welcome to the Judiciary Committee, Ms. Bodwin.
Welcome. Good afternoon.
Good afternoon. Can you, do you have a number of the number of domestic publicly held corporations that would be subject to this legislation if it were passed?
We currently do not. Currently, we do not collect that information. And so part of this would ask each of the corporations who are filing an annual report with us, the first question would be, are you publicly held? So that's where we're going to begin collecting that information.
Oh, so we don't even know whether they're publicly held or not.
So our office, currently, we do not know that.
Okay, thank you. Okay. I'm going to send you back through cyberspace, and Representative Reckitt, go ahead.
Well, I was just going to point out that the section 4B of the amendment says that they're going to report in 2024 how many publicly held corporations there are. So it's basically the same thing.
Okay, thank you. Representative Libby?
Thank you. I really am left wondering why we are still pursuing this bill. I was not a fan of having teeth in it and having fines in the first place. But this is now a bill that says you must do this, and there's no recourse if you don't. On top of that, were I ever appointed to a board, I would be horrified to think that it was because of my gender rather than my excellence. And I will be voting ought not to pass.
Is the committee ready for the vote on this legislation, on the ought to pass as amended motion? It looks like we are. I'm not seeing any hands raised. Representative Babbage?
Yes, I would like to ask Representative Reckett, obviously this has been, gender equality has been one of my great issues in my adult life. And, but I wondered if gender parity, if more neutral language would achieve your directive, or are there specific boards that you can think of where this language addresses, I believe, the need we have, but I'm wondering if a minimum of on a board of 5, that a minimum of 2 of each gender be a requirement is not a gender neutral way that we might want to go in state law. I don't know.
Well, I think if I could respond, I think that the intent of the bill, and I think what it does do, in fact, is provide the information in the context of an annual report from the Secretary of State, which would articulate, let's say, for instance, that there are 15 publicly held corporations in Maine. I have no idea how many there are. But if there were 15 and 10 of them said, yes, indeed, they had a woman on the board, and 5 said they didn't, it seems to me that I might look at that and say, well, gee, do I want to invest in one that doesn't? I don't know. It's sort of, it's a
transparency issue as well.
Transparency issue, frankly, because I think the fact that I have no clue how many women are on the board of Maine Medical Center or Northern Lights Hospital, even though I'm certain I could find that out if I dug around, it'd be a whole lot easier to figure it out if once a year we would know which of the main corporations, in fact, have women on the board. And as I think I mentioned in my testimony, all of the studies in the whole blessed universe on the topic of inclusiveness around gender say that the fact that a board has any women on it is a help, but it really needs to be more than just one. But if the reality is this is a very small board, then a one person can have a voice that can be heard and change the climate of the institution. And that's my intent.
Thank you. I appreciate it.
Thank you both. Senator Keim, I think you were next.
Yeah, thank you, Madam Chair. So I have a lot of issues with this. First of all, we don't create laws so that information is more available to us. I understand it's of interest to some people who's on the board and whether or not they would like to invest in that company, but that's public information already. So to create a law so that there's ease of information it doesn't seem to make sense. And I agree with Representative Libby that, if I were appointed to a board to be a token female, I find that very insulting. I think that females can make their way because they're strong and capable. And additionally, I think telling corporations that they have to get rid of somebody so that they can be replaced with a female is really overstepping our bounds. And why would we consider that every single public board must have this? I mean, we don't even know, this bill is being made without even knowing who we're talking about. So I have a problem for all those reasons. We don't know which corporations are in Maine that we're putting this on. And the information that Representative Reckett said she wanted is publicly available and rather easy to access. And and I find it insulting to my sex. Thank you.
Thank you. It sounds like committee members have made up their minds on this bill, and so unless anybody feels strongly otherwise, let's move on to our committee vote. Is the committee ready for the vote? Representative Babbage, your hand is still up. Did you wish to be recognized? Okay. I'm not seeing any other hands up. Ms. Panett, you can go ahead. This is the ought to pass as amended motion.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Thank you. Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Madam Chair, I have 13 members voting. Excuse me, I apologize. I have 8 members voting in the affirmative, 5 members voting in the negative, and 1 member is absent.
Thank you very much. And for those who voted in opposition to the motion, what is your report?
Ought not to pass.
Thank you very much. And so the ought to pass as amended vote carries 8-5 with 1 absent. And with that, we'll close the work session on LD 1200 and open the work session on LD 923, an act to stop the Guilt by Accusation Act. And Peggy, do you want to give us a kind of a top line bill analysis, please? Yep, you're muted.
I am sorry. So LD 923, an act to enact the Stop Guilt by Accusation Act, would require a media outlet. So I think we're talking mostly about a publication. If it's presented a story, if it's published a story about somebody who has been prosecuted or is under adjudication in a state tribunal, so we're usually thinking about courts, but it could be a license suspension, and that person is later is acquitted or is not required to pay like damages if somebody had sued them for a huge amount and the amount they're actually liable for is much smaller, they would be able to ask the media outlet to, by giving them a request, a written request within 10 days, to have them publish something in basically the same level of attention getting about the acquittal or the not as serious adjudication. And it would provide a private right of action for that person with a 1-year statute of limitations if they do not have that response to their request for, it's not really a retraction so much as an update. It doesn't apply to satirical or humorous publications, documentary works, and investigative reports. If the person is actually accused of a felony charge, this would not apply. This would not be a remedy for them.
Thank you very much. Committee members, are there any questions of Peggy? Not seeing any questions. Representative Harnett?
Thank you, Madam Chair. Quick question, Peggy. In your bill analysis, you discussed a Supreme Court case along the lines that states cannot tell the press what to do. Is that a fair characterization?
Yeah, I think that's a fair characterization that the Supreme Court, it's a, you know, a case from 1974 where it was kind of, it was a Florida state statute required newspapers to allow, to print the reply of a political candidate to anything that was in the paper. And the US Supreme Court said that the state should not be involved in those editorial decisions or telling a newspaper what they need to print or how much they need to cover.
Was that a violation of the First Amendment?
It is a First Amendment freedom of the press, yes.
Thank you.
Representative Evangelos?
I'm going to move not to pass. I always thought the bill was unconstitutional. So, thank you for that extra information. I'd make the motion not to pass.
Thank you, Representative Evangelos. Is there a second? Representative Sheehan, second. Representative Libby?
Thank you, Madam Chair. I just wanted to kind of point of order. We usually hear from the sponsor. Is the sponsor not present today?
The sponsor is present, and we can certainly hear from the sponsor. I will bring her in if you have questions or.
I don't. It just seems to be our usual. Certainly with the bills we've heard earlier today, we invited the sponsor in to speak and address our committee. So I thought that was standard procedure. If that is not, I apologize.
No, it's often is. The motion came up quickly. And so, but I think that Representative Sampson has just joined us. Welcome back to the Judiciary Committee, Representative Sampson. Did you, first of all, let's see if there are committee questions for you. Committee members, are there any questions for Representative Sampson? Representative Babbage, do you have a question?
I do not. Thank you.
Okay. Thank you. Representative Sampson, is there anything you wish to say to the committee?
Well, I just thank you for letting me in and giving me an opportunity. I would like to just, you know, as I mentioned in my testimony, I think this really speaks volumes to just the social justice of individuals who have been wrongly accused in a situation, and that the media, just as really responsibility to operate with integrity, they should be communicating the fact that somebody has been acquitted of a situation in the same manner that they essentially broadcast and vilified that individual. And so I would hope that you would consider the fact that we really have a disparity in the way the media has a tendency to strong arm these types of situations and minimize the damage that they do to individuals' lives. And it can be lifelong damage, and they hide behind the First Amendment. I think there's a higher standard here, and it's a moral obligation.
Thank you very much, Representative Sampson. Senator Keim?
Thank you, Madam Chair. Thank you for being with us, Representative Sampson. I missed the public hearing for this bill, but I agree, you know, some things get sensationalized across the first page of a newspaper, and then a retraction is, you know, in font 7 on page 11. So it is, fair reporting is difficult in those circumstances and leaves people scarred for life. I just wonder if you would respond, though, to the unconstitutional, you know, issue with this bill.
Well, I am not a constitutional attorney, but I have someone that is in the waiting room that could address that. who is dealing with these issues on a national level. And if you wanted to ask for him, Mr. Sevier.
That would be helpful to me. I would appreciate that. Thank you. Madam Chair, if that's possible.
Actually, it's not possible. We heard extensively from Mr. Sevier in the public hearing on this bill, and I'm sorry that you didn't have a chance to go back and watch the videotape of it. I'm happy to table this so that you can have an opportunity to go back, but you know, we're in a position where we have an extensive list of public hearings. We heard actually twice from Mr. Sevier in the public hearing, and so if folks would like to table the bill and go back and rewatch that, that's fine. But at this point, we're not going to entertain additional presentation by him. I think he was very extensive in his presentation. Representative Libby?
I just wanted to ask, are we not then in any of these work sessions this afternoon, we are not going to bring in anyone outside of the bill sponsor? Because I just want to make sure we're following the same standard for every bill. And it seems to me that we've been able to get questions answered in the previous work sessions this afternoon from folks that are not the bill sponsor. So I just need a little clarity on that so that we are following the same standard for every bill. Thank you.
Yeah, thank you for raising that. And I agree with you. We should have standards that help us get our work done. In this case, essentially, we had a very extensive public hearing that involved that particular member of the public speaking at the public hearing extensively. And then there was a request for him to come on a second time and speak extensively. All of that information has been available to every member of this committee. In other instances where we have very briefly, and I think you can probably have noticed today that I've only allowed people on very briefly to answer very specific pointed questions. And the question that Senator Keim asked was a question that was spoken to extensively by that particular individual at the public hearing. And again, I'm very happy we can definitely table this bill so that folks can go back and re-listen to that. I think that that's a much better use of committee time than it is to go through the whole public hearing presentation again. So with that, I'd like to move on. Representative Hagan, go ahead.
Thank you very much, Madam Chair. I just would like to say that I don't feel like things are equal. And I think that if Senator Keim has a request to do something really quickly before a vote happens, and to get that, I think that it should be honored. And I would oppose what you are doing.
Senator Keim, would you like us to table this so that you can go back and watch the information that Mr. Sevier provided?
Yes, I would move to table the bill.
Is there a second? Seconded by Representative Libby. And we will follow our usual process for voting on tabling motions. I'm going to ask for those who wish to table, and actually I'm going to clear the, move the bill sponsor off the panel so that we just have committee members on the panel. And I would ask that we're going to call first for those who wish to table to raise their electronic hands and leave them up until after we have recorded all of those votes. Then I'll ask folks to take their hands down and then call for those who want to vote in opposition. So at this point, everybody who's in favor of the motion to table, please raise your hands and leave them raised until we get a count.
Madam Chair?
Yes. Okay, so we have 6 in favor of the tabling motion. And now, Representative Babbage, I'm a little confused about your vote. You're voting in favor of, okay. So it looks like we have 7 who are in favor of tabling. And now please take your hands down, and those who are voting against the motion to table, please raise your hands. Okay, and I'm seeing also 7, but Representative Reckitt, I believe that you have raised your hand twice. So could you just clarify, please, for us whether you're voting to
Yes, I was trying to
table?
get my hand down and it, I mean, up and for the next vote. So I did not intend to vote for the tabling motion.
So your your vote is to not table.
Right.
Okay, and so it seems that the motion to table fails, 6-7. And with that, let's all remove our hands, lower our hands. Representative Moriarty, could you lower your hand, please? Thank you. All right, committee members, does anybody have, we've completed the vote. Does anybody have additional questions for the bill sponsor? I'm very happy to bring her back to the panel. Please raise your hand if you do. I'm not seeing any. Is the committee ready for the vote? Okay, we are ready. So the motion, by Representative Babbage, your hand is up. Did you have a question?
I do. Not a question, a statement, since this is the work session. I have a constituent that I think it would be interested in this, and I did want to, whoops, I'm sorry, explain for the public record that my issue would be the use of visual things after exoneration, but use of visuals that would indict people, just that were used earlier in the process. That's really not addressed in this bill satisfactorily for me, and the constitutional concerns overweigh all of this, and so I will be voting not to pass.
Thank you, Representative Babbage. Representative Hagan, go ahead.
I just have a quick one for Peggy. Thank you. Is that okay?
Yes, go ahead.
Question is, defamation in kind a form of protected speech?
I think defamation in kind is a term that this bill coins and defines. I don't think I think this is its first recognition. To say it's a kind of protected, I mean, I don't really know what that means.
Okay. Thank you.
Any other discussion on the bill? Senator Kime, go ahead.
Thank you, Madam Chair. I would request a corner caucus.
Thank you. That's fine. How much time would you like?
Just 5 minutes, I think.
Okay, great. So we'll reconvene at 4:30, everybody. Thank you. Looks like most committee members have returned. Folks, if you are at your desks, could you please activate your cameras? Looks like everybody is back. Representative Hagan, have you been able to rejoin us as well?
Yes, I have. Thank you.
Thank you.
Yeah, I shut my computer and then it just wipes me out. I keep forgetting, and sure enough, I shut it again.
We're glad you're here. Okay, I think that the committee is ready for the vote. Soupy, could you please call the roll?
I would be happy to.
Madam Chair, if I may,
Yes.
just to verify what is the vote before us?
Thank you for asking that question, Representative Thorne. So the motion was by Representative Evangelos, ought not to pass, and it was seconded by, I'm not finding my notes. Soupy, did you make a record of who seconded it?
Yes, Representative Sheehan seconded.
Okay, thank you.
You're welcome.
Thank you, Madam Chair.
You're welcome.
Ready?
Yes.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Thank you. Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Madam Chair, I have 8 members voting in the affirmative, 5 members voting in the negative, and 1 member is absent.
Thank you very much, Ms. Panett. So the ought not to vote pass carries 8-5 with 1 absent. And so with that, we'll close the work session on LD 923 and move on to our next work session on LD 1221, which is an act to implement the recommendations of the Right to Know Advisory Committee concerning public record exceptions. Oops, and I am so sorry. I goofed. Go ahead. Would those who voted against the motion please let Soupy know what your report is?
Ought to pass.
Thank you, and my apologies, everybody. And so with that, we'll open the work session on LD 1221. I'm not going to read the incredibly long bill title again, but Peggy, whenever you're ready, we're ready for you.
Thank you. So one of the duties of the Right to Know Advisory Committee is to review all the existing public records exceptions. And they use the same criteria you do when you look at a proposed public records exception, trying to weigh the public's interest in that information compared with whatever the interest is that the record not be public. So again, just kind of back to basics, every record that is in the hands of a governmental agency that has anything to do with what the government does is a public record unless there's something that says it's not. And so what the advisory committee looks at and what you look at are things that would not be public records. So it might say something is confidential, or it might say this is not a public record. So the advisory committee was looking at the existing public records exceptions in Titles 8 through 12 this past summer, and reviewed all of them. Well, there were a couple that they weren't done reviewing, so they not included in these recommendations. They thought all the rest of them were in good shape except for these two. And the first one is actually just kind of a clarification. It's in, I want to say it's the, it's the Attorney General's investigation, and the current law allows the person who is being subpoenaed basically to decide whether or not the information they're providing is public or private. And the advisory committee agreed that this should say that they're confidential until they've been investigated. But it may be disclosed by the Attorney General with the consent of the producing party, and also in court pleadings or other papers filed in the court. So it eventually becomes this is an investigation, and it ends up being public if it goes on to be a prosecution. And this is just keeping the language consistent with other Attorney General investigations. They investigate under oil profiteering, unfair trade practices, the different laws that direct the Attorney General's office to investigate and enforce. That's section 1. Section 2, this is actually a fairly recent addition about information. Well drilling companies were concerned when they had to be reporting information to, it's actually the part of Department of Agriculture, Conservation and Forestry now. They were reporting information about the wells they drilled, and there was a concern that that needed to be kept confidential. And so that was enacted a few years ago. They've decided, the department has decided that that is not necessary because it was at the request of the well drilling companies, and no well drilling companies have requested that that information be kept confidential. So they thought it made sense to just not include this confidentiality provision anymore. So those are the two sections that the advisory committee recommends changes to. One totally deletes the confidentiality provision. The other one clarifies it and makes it consistent with other laws dealing with Attorney General investigations and the subpoenaed information.
Thank you very much, Peggy. It looks like we have a question. Representative Moriarty, go ahead.
Thank you, Madam Chair. Peggy, the bill summary indicates that the only AG investigation that's affected by this change is an antitrust investigation. Is that correct? Okay,
right,
good.
that's what this is. And we made it consistent with, I believe it's the Unfair Trade Practices Act.
Right.
To make the language the same, no matter who, whatever purpose they're subpoenaing somebody.
Okay, good, thanks.
Thank you.
Representative Babbage?
I would move ought to pass, if that's okay to put it on the floor.
Okay, there's an ought to pass motion. Is there a second? Seconded by Representative Evangelos. Committee members, are there any more questions for Peggy? Is there any discussion of the legislation before we move on to a vote? I'm not seeing any discussions. The committee ready for a vote? Appears that we are, and thank you very much, Ms. Panett.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Thank you. Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will call the absentees. Representative Libby. Representative Libby is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent.
Thank you very much, Ms. Panett. So the motion ought to pass on 1221 passes 12-0 with 2 absences. With that, we'll close the work session on 1221 and open the work session on 1346. And again, Peggy, whenever you're ready, you can proceed with the bill analysis.
Great, thank you. This is also a recommendation of the Right to Know Advisory Committee. Not all of them. Judy Meyer, who testified at the public hearing, is not in favor of section 1 of the bill. So section 1 of the bill, actually section 2 of the bill, to amend the section in the Freedom of Access law that describes, that limits how much an agency, and when I say agency, that means state, local, any governmental agency, can charge to cover the actual costs of responding to a request. So the request might be the printing cost, but it also might be searching for, retrieving, compiling, reviewing the data that they've collected to make sure that they are not releasing confidential information, because that would probably be a violation of the law to release confidential information. So there's a process that might be very complex and lengthy if it's a big request for complicated information. If it's just a copy of the latest minutes of a board meeting, that would be very easy, and this shouldn't go into any additional costs. This is not including, this paragraph B does not apply to the copying costs. It applies to all those other efforts that an agency has to go through to respond to a public records request. So currently, what an agency can charge is they have to give the first hour free. They can't charge for that first hour of finding the record, identifying it, pulling it out of wherever it is. Could be, a 20-year-old record that they have to get out of a different location, or compiling it. We need all the records about this particular board and over the past year. So it might mean pulling it out of different files, whether they're electronic or physical files, compiling it, and then also going over it and redacting it and making sure that it isn't releasing confidential information. Somebody asks for all the emails between a public entity and a private corporation. And so that information, those emails might have to be reviewed to make sure no confidential information is being released. So the time that takes, the first hour under the current law, it is provided to the requester without any cost. After that, the agency can charge up to $15 an hour. So they have to document how much time they take, and then they can charge for that. What this bill does is it says that the free time, the time that you don't charge the requester, is 2 hours. And after that, it would be a charge of not more than $25 per hour. There's nothing that requires an agency to charge any fee. This would be the cap on the fee if they choose to charge a fee. The advisory committee reached the $25 number. I mean, they've been talking about this for years, about some of these requests that are voluminous and take a whole lot of time. There aren't a lot of them, but there are enough that some agencies, some municipal offices feel like it's pulling them away from their other responsibilities. So that's why this issue keeps coming up. The Maine Municipal Association had done a survey, and it is posted. The report is posted, and it was also on the Right to Know Advisory Committee's website. And they identified that the average pay for the person who's responding to these long-term projects was about $26 an hour. And they actually recommended no more than half an hour of the time be without charge, but they were recommending that the per hour charge would be $26. The advisory committee said $25 sounds like the right amount. Representative Harnett is the chair of the Right to Know Advisory Committee, so he might have more to add to that, but that's my understanding of it. Section 2 was added in because there was some testimony. I hadn't heard it from agencies, but from some other people who were asking for records, and then they were told that their fees had to go to the general fund. So an agency spends time, even if they charge $300, if big requests, they ended up charging $300, those fees end up going to the general fund. We tried to investigate that. We didn't find any statute that said those fees that an agency collects goes to the general fund for the state. The Maine Municipal Association said they're not concerned about Section 2. They don't feel like that affects them either way. And actually Chris Parr, who's a member of the Right to Know Advisory Committee, has been digging into this question a little more. Most of the bureaus of the Department of Public Safety, for example, their fees either go to the general fund or the highway fund, depending on the activities that are being covered. But he also said that the State Fire Marshal's office has a dedicated fund that their fees go into. So those don't go into the general fund. So this would affect some agencies. We're not sure how many it would affect, so we're not really sure. We've also talked to the fiscal office about where the idea that all these fees, when they're paid, have to go to the general fund, where that comes from. They weren't aware of that either. So I'm not sure how we will get a fiscal note on this, but we'll see. So that's Section 2. Section 2, Judy Meyer, the only person who I think maybe there were other people who testified against, the only member of the Right to Know Advisory Committee that opposed Section 1 does support Section 2. I think that's all I need to say right now. And that was too much, I'm sorry.
No, that was helpful. Representative Harnett, you chair the Right to Know Advisory Committee. Do you want to speak on
I do, and very briefly, as Peggy said, this is an issue the Right to Know Advisory Committee has been working on for years, well before my tenure as chair. This is a compromise position. Nobody got everything that they wanted. You see, Maine Municipal wanted the rates higher. There were some people that wanted the rates lower. There were some people that wanted it all for free, but the committee overwhelmingly endorsed this proposal. And I would point out that the Maine Municipal Association study that is referenced by Peggy found that the overwhelming number of FOA cases are resolved in under 3 hours. And under the old law, or the current law, a 3-hour charge would have been $30 because you only got 1 hour free, and it was $15 an hour for the next 2 hours. Now that charge will be $25. So it's actually a reduction for cases of 3 hours and less. And when you get to 4 hours, the increase is only, it would, at the current rate, it's $45. It would go up to $50. This is designed to get those outlier cases where municipalities and state agencies are spending an inordinate amount of time complying with these requests. It's not going to impact 90% of people that file requests. I would ask the committee, the Right to Know Advisory Committee does a lot of work. They take their responsibilities very seriously. This was a 12-to-1 vote. I respect the dissenter, but I would ask that you follow the lead of those people that volunteer to work on this committee. So,
Go ahead, Senator Keim.
Thank you. I also chaired the Right to Know Advisory Committee, and this topic was hotly debated even when I was on the committee. And I am inclined to agree with Judy Meyer in that the increase in fees is seeking to capture those companies or people that are sort of data mining. The thing is that the money that is going to be required of them, it doesn't matter. Like we could double or triple what we're going to charge them, and they're still going to request this and go after this information. And I think that inadvertently what it does is it keeps regular Maine folks who do have an interest in a large amount of information from their government from being able to access it. And I understand that it is a burden. I wouldn't say that it isn't. It is a burden. But I think it's a burden that we have to maintain because it's so important that people have this access. And so I will be voting in opposition to this bill, and I'll be voting in opposition to Section 2 as well. And I've thought about this one quite a bit. And the reason why is because right now, some agency, so Maine Municipal, first of all, who I would most want to see keep this money is keeping the money, like all the municipalities are. But the agencies, as far as I can see it, that are putting the money into the general fund, their employees are paid from the general fund. Like we pay them already. So I don't believe that we should be, if one agency happens to have greater amount of requests, and they're still using their same staff to make this happen, if they need extra staff, they should come to the legislature. We should go through the process of considering the extra work that this is and pay for extra staff if that's necessary, rather than just giving them the fees to keep, which is sort of a kitty that no one really keeps track of. So it's this extra little fund of money that really does come from Maine people and should go sift through the process. Like we should understand how much money, extra money is coming into these agencies and what they're doing with it. And they should have that oversight that happens when money gets sifted to the general fund and then back out to them. So I think we'll actually, as a legislature, have a better eye on the process if we are keeping this in the general fund and then being more realistic when agencies come to us and say, hey, we need an extra person because we need an extra half a person or whatever, because here's how much we're getting in requests. So I'm going to move ought not to pass on this bill for those reasons. And I will make one other comment. The Human Rights Commission does keep all their fees. I noticed that in their budget. As one of their line item budgets, and correct me if I'm wrong, Peggy, and we could go back and look, but they do keep their fees, as at least I read that in their budget. So I do have a little bit of concern, which I think is, probably a separate issue to deal with at another time, but I think there should be consistency in what we're doing with the fees. Thank you.
So before I recognize you, Representative Moriarty, we have an ought not to pass motion from Senator Keim. Is there a second on that motion? Seconded by Representative Libby. Okay, go ahead, Representative Moriarty.
Thank you, Madam Chair. Briefly on the finances, I looked at this primarily from a municipal point of view, and I don't think that the property taxpayers should bear the costs associated with a request that requires a good deal of time. And that's particularly true at a point at which our towns and cities are not receiving the full amount of revenue sharing to which they're entitled by statute. So I'll be voting in opposition to the pending motion.
Thank you, Representative Moriarty. Representative Babbage?
Thank you, Madam Chair. This one is actually hard for me. Obviously, I'm a veteran of the Right to Know Committee, and I think this compromise is actually a very good one. But I despise fees. I see this as a barrier between public officials and accountability. I do think we have a current situation, and I think this compromise does not alter that current situation. As a matter of fact, if it's less than 2 hours, it improves it for the requester. And if it's less than 4 hours, then it's basically parity. So because of that, I'm going to vote against the current motion. But I do want to say that there should be more transparency with regard to the money that comes in. Should be going publicly in annual reports or to the state, so that we do know the status of what is collected and so forth. Because I would hate for this to be. This should not be self-sufficient. That government is accountable to the people, and if the people want information, they should be able to get it regardless of their income. But so I worry that there's not enough accountability in the process. But I think this compromise is a good one, despite my holding my nose at fees in general when it comes to information about the government. Thank you.
Representative Evangelos?
Thank you, Madam Chair. Very quickly, Peggy, when was the last time this was raised? How long has the $15 been in effect?
I'm guessing that was in 2011, 2012, because it doesn't look like it's been amended since it was enacted.
Yeah. Okay. Minimum wage has gone from $7.25 to $12 in that period alone. So obviously there's wage inflation. Thank you for that information.
Representative Libby?
Thank you, Madam Chair. It seems like there's a lot we still don't know about this bill. I would love to know I would love to know the breakdown, and I don't think it's possible to have that right now, but the breakdown on, municipality by municipality, what they actually see in requests. And my biggest issue with this bill is, we as a committee are very concerned about the indigent, but there are a lot of folks who can't afford to pay, even let's say it's a 4-hour request that it takes. They can't afford to pay $50 to get information. And this is a huge barrier to transparency and accountability in our government. And so I will be voting ought not to pass. I don't want to see any impediment. I honestly would rather there not be any fees at all. I think it's government's obligation to be transparent and be accountable to its people. So that's where I stand, and I will vote ought not to pass.
Senator Keim?
Representative Babbage, I wanted to follow up on one of your comments. You mentioned the idea of the transparency where the monies are going, which is one of my issues as well. So I'm wondering if there's a way that you are considering amending this, because if we just let agencies keep the money, how do we square that with what they're already asking for in the general fund and we give them, and what they do with the money, because they don't necessarily go out and hire somebody just because they've gotten a large request, and the municipalities already keep it. So this is just the agencies that we're already paying. So just wondered if you had more thoughts around that, because it is something I'm concerned about.
May I, Madam Chair?
Yes, go ahead.
I think we're at the 11th hour And I would certainly support, proposing transparency in some way, maybe in a future decision. The only thing I will say, I'm against fees because they can mount up. I'm not against a very minimal fee for the request, and the reason I'm not against all fees is because there has to be discipline in the request. If there's no discipline in the request, then we really paralyze government officials in collecting data that may or may not be used or may not be targeted appropriately by the requester. So it's I worry about fees getting too high, but remember, the real evil here are the data miners and the people who will collect this money for commercial reasons and so forth, and they also can paralyze our local officials unless there's some sort of monetary cost. So I think where we are in May of when we're supposed to finish up our committee work in no time at all, I think I'll support the bill as presented. Thank you.
Go ahead, Senator Khan.
So yeah, I understand what you're saying, but I just have to bring up one other point, and that tends to be what we're doing with a lot of our bills right now. We're saying we're at the 11th hour, so we can't consider the policy decisions that we're making. And I find it to be very concerning with a number of different bills that, things come to us that should raise concerns, and the idea that if we just allow each agency to keep the fees, what are they doing with the fees? I think if we make that decision, we should also be talking about the transparency with what we expect with those fees, not just here you go, keep it, but where's the accountability in that? And where's the oversight in that? That's our job.
Is the committee ready for the vote? Seems like we are. So the pending motion is an ought not to pass motion by Senator Keim and seconded by Representative Libby. You may, Ms. Panett.
Senator Carney.
No.
Senator Carney votes no. Senator Sanborn.
No.
Senator Sanborn votes no. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
Oh.
No.
Representative Sheehan votes no. Representative Hagan. Representative Libby.
Can you please remind me what the motion is?
Yes.
Yeah, please.
Ought not to pass.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell. I'll recall the absentee, or I will call the absentees. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have.
Madam Chair, may I have a point of order?
Yeah, there are a couple of hands raised, Ms. Panett. Let me just check in with committee members. I'm going to go left to right. Representative Harnett, could you, your hand is up?
Thank you, Madam Chair. Only because it's been a long day and a series of long days, I want to make sure that I cast my vote properly. Do you have me as a no? Ms. Panett?
I have you as a yes.
That was incorrect. I am voting against the ought not to pass motion, so please record me as a no.
I will do that. Representative Harnett votes no.
Representative Reckitt?
I think I may have done the same thing. You could tell me what my vote is.
I have you, Representative Galgay-Reckitt, as voting yes.
It should be a no.
Representative Galgay-Reckitt votes no.
Representative Babbage?
I'm going to blame this on our House Chair, but yes, I would like to, at the same time, designate my vote as no if I did not do that the first time.
You were yes. You will be
Thank
a
you.
no. Representative Babbage votes no.
Committee, does anybody else have concerns about the accuracy of their vote? Go ahead, Representative Thorne.
Representative, excuse me, I lost my train of thought. Representative Hagan was recorded as absent.
Yes.
Okay. I thought he was on with us. That's why I questioned it.
Yeah.
Representative
I
Thorne,
didn't hear.
I've been told that I need to see the face and also hear them. So I only see his name.
Okay.
And just once more, Representative Reckitt and Representative Babbage, your hands are still up. And did you
sorry.
have another? Okay. All right. So I think we're all set. And Ms. Panett, if you could go ahead, please.
Yes, Madam Chair, I have 4 members voting in the affirmative, 8 members voting in the negative, and 2 members are absent.
Thank you very much. And for those who voted no, our report is ought to pass.
It is for me.
Representative Babbage's hand is still up. Do you have another question? No.
I do not.
Okay.
And so the vote on LD 1346 is 4 ought not to pass, 8 ought to pass, and 2 absent. And that will close the work session on 1346. And I wanted to check in particularly with Ms. Panett and Ms. Reich and ask if you need a break before we continue.
I'm fine.
I'm fine, but if anybody wants to take a break, I'm sure I'd take advantage of it.
Okay. Committee members, we have one more right to know advisory committee bill, and then we have a series of remote participation bills, which we're actually going to be able to consolidate, I think. And so I would just ask if committee members are able to keep working for a little bit longer, or whether people would like to take a break at this point.
Continue.
If you're interested in a break, either electronic or real hand, please. Looks like everybody's willing to keep moving forward. And so thank you everyone for weighing in on that. And Peggy, I think we're ready for the analysis on 1345. We'll open up the work session on LD 1345, which is an additional act to implement recommendations of the Right to Know Advisory Committee.
Thank you. So this bill, I think these were considered more non-controversial changes. So section 1 of the bill so current law says an agency or official may charge a reasonable fee to cover the cost of copying. And that's kind of left up to the agency or official what the reasonable fee is. And it turns out that some folks think $1 or $2 a page is a reasonable fee. And the advisory committee said, we think a reasonable fee to cover the cost of copying is no more than 10 cents per page if it's 8.5 by 11 inches black and white copy of a record. That limit is not supposed to be applied on a per page basis for records that are provided electronically. That language is not intended to mean you can't charge for an electronic copy. It just means it can't be based on a per page basis. And if that's not clear, then I think the advisory committee would support the change to that. So section 2 and section 3 are just setting up. This is the membership of the Right to Know Advisory Committee, and this would add one more person, and this would be a representative having legal or professional expertise in the field of data and personal privacy. And that person would be appointed by the governor. So I think that makes 17 people would be on the advisory committee. Sections 5, 6, and 7 are all about the freedom of access training that's required of state, county, and municipal officials now. It originally started out as just elected officials. It's been expanded to appointed as well. And so that change in subsection 1 is kind of just catching up, because sometimes appointed people don't have to take an oath of office, but they need to assume, when they assume their duties, they need to have that training done within the 120th day. So that's just kind of clarifying when that 120 days is starting with people who aren't necessarily taking an oath, but fall into all these categories of who is required to take the training. Section 6 amends paragraph F, which covers municipal officials or municipal officers. It clarifies that we're talking about municipal clerks here. And the advisory committee, these recommendations actually came from the public records, public access ombudsman, Brenda Kelty, as well. And she was seeing that these are folks that really need to be trained because they're the ones who are responding to requests. So the municipal or county managers or administrators, assessors, code enforcement officers, and the deputies for those positions, as well as planning board members. So these are, I think I misspoke. These are all municipal people. This is not county people. A lot of these people are already doing training. And this would just make sure that the statute requires them to have the training. Section 7 is about school administrative units, the officials there, and it clarifies what officials mean. It specifically says superintendents, assistant superintendents, and school board members. So those are the training requirements. I think we talked about training. It says to meet this requirement, you have to do a thorough review of actually the website that the state maintains. Brenda Kelty maintains it. And we assume that that would be up to about 90 minutes to really absorb all that. The legislature provides freedom of access training. Maine Municipal Association provides training for their members as well. So sections 8 and 9 are adding criteria for when, or criterion, for when the advisory committee looks at existing public records exceptions and try to figure out if it makes sense to keep those on the books. Section 9 is when this committee reviews a proposed public records exception and decides whether or not it makes sense to go forward with limiting access to that information that's covered. So it's kind of two sides of the same coin. And that criterion is whether public access to the record, we're talking about the record that's going to be shielded, ensures or would ensure that members of the public are able to make informed health and safety decisions. So that might be anything about hazardous substances, or could be vaccine information, or could be anything that would help somebody make a decision about health or safety. So that's what this bill does. And I think all of these recommendations were actually made by the advisory committee in 2019 as well, and they did not get put into place.
Thank you very much. Senator Keim, go ahead with your question or comment.
Thank you. Peggy, could you just go over the Section 8 again? Tell me how that's a change to current law and what the language around that section in law says.
So section
8.
Yeah.
Yeah.
Right. So that's amending. We have a subchapter called Public Records Exceptions and Accessibility. So many years ago, before the Right to Know Advisory Committee came into existence, there were a couple of study committees that said, we really need to get a handle on the confidentiality provisions that are in the statute. We did a search and we came up with over 200 specific statutes that say something is confidential or not a public record. And the advisory committee said, we need to look at every single one of those and see if it really is a valid balance of whoever wants that information kept confidential versus the public interest in having that information out there. And so this was a study committee that the makeup was pretty close to what's the Right to Know Advisory Committee. They came up with the criteria in statute, and those criteria, and this will sound very familiar because Representative Harnett makes you walk through this every time you're doing a public records, a proposed public records exception. And if you want me, I can read through them all.
No.
Okay, but the balancing is looking at the person's privacy interest versus the public interest. Is there a business interest? Is this proprietary information? Is it a trade secret? Versus what's the public interest in that? Maybe there is sometimes the public interest overrides that business interest. Does it put a business at a competitive disadvantage? Does it involve a public body that's in negotiations?
So let me just clarify then. So what this is saying is that it needs to be available for this reason, right? The information needs to be available for this reason, and it's in a list of other reasons that things need to be available. That information needs to be public.
Right. It's not so much that it needs to be public or it needs to be kept confidential. It's what's the question that needs
A consideration. Gotcha.
What do you consider in deciding whether or not this information needs to be protected from the public? Or what information should you consider to show what the public interest is in having it always public, even though somebody has some kind of privacy interest or a proprietary interest.
Thank you so much. That's very helpful. And I would move ought to pass.
Thank you, Senator Keim. Is there a second? Seconded by Representative Babbage. Committee members, are there any additional questions for Peggy or any discussion on the bill? Excuse me, on the motion? I am not seeing any. And Senator Keim, thank you for asking that helpful clarifying question. Looks like we're ready for the vote. So this is an ought to pass motion by Senator Keim, seconded by Representative Babbage. We're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Thank you. Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
I'm sorry, I didn't hear. Representative Sheehan.
Yes.
Thank you. Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Newell. Representative Newell is absent. Madam Chair, I have 13 members voting in the affirmative, 0 in the negative, and 1 member is absent.
Thank you very much, Ms. Panett. So the ought to pass motion passes, and we'll close the work session on LD 1345 and move on to our next work session, and that is on LD 32. And I just want to let committee members know that in addition, so LD 32 is the first of a number of remote participation bills, and Peggy will take us through not just 32, but she's prepared actually a really helpful chart, and maybe we'll have a bit of a global discussion on these bills. Senator Keim, go ahead.
Thank you, Madam Chair. Just a question about the work order for the rest of the day. So I think LD 32, and then there's 1, 2, 3, 4 bills included in that global overview of remote participation, if I'm not mistaken. And that is going to be an in-depth, lengthy discussion, at least for myself, because I am very concerned about remote participation. And so I'm wondering, first of all, if we're going to take those up next, I definitely need a break before that. And if we are going to have time to go through all of those this evening, or not, but I'm wondering if we should take up 331 and 864 ahead of that, and if it's your intention to get through all these bills today.
You're so right to point out that it is a big challenge to get through all of these work sessions. My suggestion would be that we do the remote participation bills, because I actually think that it'll be easier to do those, and they're all kind of a unit, and then perhaps we can postpone our work sessions on 331 and 864, because that takes us a kind of a different direction. And I feel like if we can do LD 32 and those other, I think that makes a lot of sense, and probably is about all we can take on today.
Okay, before we take those up, I would appreciate a break. I don't know how the rest of the committee feels.
Okay, we can definitely take a break. How much time would you like?
I think 15 minutes would be good.
Okay. All right, so let's 5:40 then, everyone. Thank you.
Hey, Chris. Chris. I think
Yes, sir.
Hey, Chris, remember I used to hate those corner caucuses and breaks? Now I change up, go out and feed the cow and clean the stall.
Well, you've got time to do it, unfortunately.
I did it at the last corner caucus.
Jeff, what's your cow's name?
Sheba.
Nice.
She's a champion. I mean,
Oh.
she's a really nice person.
Yeah, nice.
I raised one head a year for like 35 years. And then 10 years ago, she was 3 days old when I bought her, and she's like a human being. So then we named her, so it was game over. She's 10 years old now.
Wow.
I've met
Senator
Sheba.
Carney?
She's
Yes.
very-
May I ask a question? Representative Dodge is in the attendee space, and are you intending to table the last 2 bills?
And I don't think we necessarily need to table them. We just won't get to them.
Okay.
And we'll reschedule them. I think that Senator Keim raised a really good point. If we can, at some point, we're all going to run out of steam. So we can, let's just say we're not going to reach the last 2 today.
Okay, well, you have this, actually, I noticed, Representative McCreight is there too, so.
I just responded to Representative McCrae's email.
Okay, great.
And I'll just say this to those in the attendee space. We're not going to be able to reach 331 and 8:64 today. We're just running out of time tonight. So just so folks are aware of that. Thanks. And
Senator McCartney,
yes.
I had an emergency with that cow last week. You know that, and that's the first time that's happened in 3 years, and it's frightening, you know, to see it. I live on a busy small state highway, and anyways, it ended well.
Yeah, I'm glad it did. I saw that series of emails. I was concerned as well.
Couldn't believe it. I just couldn't believe it.
Yeah.
The only reason that I was able to prevent any trouble was that I was so tired from the session, I stayed home the next day and did my work from here at home. And otherwise, she would have been out for 5 or 6 hours. It could have been catastrophic.
Oh, that's so lucky.
Yeah.
Yeah. It's funny how things like that work out.
Yeah. Anyways, probably want to take your break. Sorry.
No, that's good. It's nice to chat. I am going to take a quick little break before we come back at 5:40 though. I'll see you in a couple minutes.
Chris and Lois, you're both unmuted. I don't know if you care, but you might want to put yourselves on mute.
That was awfully nice piano.
I know, I didn't know whether to keep it playing or not. It was lovely, but it's always good to have your audio muted when we're not in a meeting. But it was beautiful. You're right.
It was like a lullaby.
Senator Carney?
Yes.
I only have enough land for one cow, so it's been 10 years since I did the other deal. That's it.
Yeah. Have you ever had more than one?
Yeah, 1 year I went up to the auction in Skowhegan and I brought 3 little ones home and I raised them together.
Oh.
But she was one of them, one of the 3.
Nice.
So she's not like a cow. She's like a dog or a person. So anyways, just wanted to clarify that point.
Yeah. No, I get
to
that.
see a picture of her.
Yeah, I do too. Looks like we're just about back. Let's wait another moment till 5:45. And then Senator Kine, right after you logged off, some folks inquired about, just to confirm that we really weren't going to reach 331 and 864. And I did indicate that we weren't, just so that you are aware of that. Is everybody ready to start back up again, committee members?
Yes.
All right. Thanks, everybody, for sticking it out tonight and returning for our final set of bills. And Peggy, when you are ready to talk with us about the remote participation bills, I think we're all set.
Okay, yeah, I don't know. I have been staffing the Right to Know Advisory Committee off and on for years and years and years, so I can talk about this endlessly. So stop me when I go on too long.
No need.
So the issue of remote participation has been discussed in the Right to Know Advisory Committee for quite a while. Senator Kime was on the committee. Representative Babbage was on the committee when they talked about it. I think since Representative Harnett has been on it, they have not spent a lot of time talking about it because they're kind of talked out and they realize it's something that the legislature has to figure out. It doesn't matter what the Right to Know is recommending at this point because there are some other issues that the legislature has to sort through. But basically, the Freedom of Access Act does not talk about, except for what passed for the pandemic, does not talk about remote participation. And there was an old AG letter that said a board was not permitted to vote over the phone because that wasn't providing public access. They were talking to each other. They weren't talking, the public had no access to that meeting and they couldn't do that. And that was really the only official guidance that the Attorney General's office had given in writing about whether or not a public body, so a board, a commission, was allowed to have one of their members vote when they were not physically present and they were calling in, or they were, you know, Skyping or Zooming or whatever. And the guidance from the Attorney General's office has basically been, you can't do that because that just does not comply with the Freedom of Access law. Everything has to be open. The public has to be able to see your deliberations and all your votes. And the Freedom of Access law does not really talk about public participation. And so when these bills start bringing up participation, that's an issue that's not necessarily covered by the Freedom of Access Act, because participation is talking about engagement with the government, and that's not really the same as having access to all the meetings and all the records of the government. It's a little bit different concept. And of course, all these entities have interactions with the public. And so it does make sense to talk about that in that context, but that's really why the Freedom of Access law has not talked about public participation. And the advisory committee has really focused on remote participation of members of the body. If an entity wants to have public participation in a remote manner, that's up to them, but it's not really covered by the umbrella of the Freedom of Access Act. So over the course of several years, the advisory committee had developed drafts and looked at different elements about what a good remote participation policy should include. And I'm calling those elements. And it doesn't mean that it actually has to authorize things, but a policy should address those things. So what's the definition of remote participation? What does that mean? Who does it apply to? Representative Babbage has LD 688, and his committee amendment, his proposed amendment says it's going to focus just on elected public bodies. So that's a choice you make as to who, if you're going to pass something, who it's going to apply to. When does it apply? What's currently in the statute, 403A, applies only during the state of emergency, and that whole section is repealed 30 days after the state of emergency ends. And that was really kind of a compromise. The language that's there is sort of drawn from all the work the Right to Know Advisory Committee did, and then added on to address the public participation piece. If you're going to let anybody have remote participation, are you going to require them to adopt a written policy before they do that? And what's the process for adopting that written policy? Representative Babbage's amendment says the constituents need to actually vote to approve that. If it's a school board, the population needs to agree to let the school board have their members participate remotely. And then any kind of special notice requirements. Any meeting of a public body needs to meet the notice requirements of the Freedom of Access law. Whether you're meeting remotely or not, you have to meet those notice requirements. If you're going to have public participation, or if you're allowing members to meet from a remote location, is there anything in the notice that has to be there? Originally, the Right to Know Advisory Committee said a quorum had to be physically present, and had to be physically present at the place where the notice said they were going to be. So that's one of the things the advisory committee had thought was important at the very beginning. And then quorum requirements. Representative Babbage's amendment, for example, says if you have a 3-member body, I'm sorry, I don't remember exactly what it is, 3 or more, at least 2 of them have to be there. If it's bigger than that, but there are quorum requirements for them to be physically present. And votes, if the body's going to take votes, I think everybody agrees they need to be, everybody needs to know who's voting. You can't just raise your hands. For big deals, you have to do a roll call vote. And then the next step is public participation. So really the first discussion of public participation was in section 403A that was adopted for the pandemic, which was interesting because it kind of pulled it in by the back door and then said, if you're going to do public participation, here's how, here's kind of the requirements you have to do. There are some other elements that the advisory committee really focused on executive sessions for quite a while and decided it would be inappropriate to do executive sessions with a member who is not physically present. Representative Babbage's amendment addresses that. Identifying anybody else who's in the room with the person who is participating remotely. Making sure that any documents and materials that are distributed in the physical setting are also made available contemporaneously with the person who is working remotely. The advisory committee originally said no adjudicatory proceedings could happen without everybody being present, or the person who wasn't physically present couldn't vote on an adjudicatory proceeding. And then what are the consequences for failing to comply with this? What if you do have members that are remote and voting and you're not complying with whatever's in the statute? Does that mean the activities of that entity are not valid? So those were my elements that I thought, or that the advisory committee had developed over time, that it makes sense to look at. And I think rather than taking each of these bills individually, it makes sense to me, and you can totally disagree, of course, it's your committee. It makes sense to me to say, this is, if we're going to do remote participation, if we're going to authorize this under the Freedom of Access Act, here are the things we need to think about and how we want to approach it. And hopefully you can reach agreement. I think the train has probably left the station with regard to at least sometimes remote participation being available to governmental bodies. And the additional question, which I don't think the Right to Know Advisory Committee has given you any guidance on, is how does the public participate? Actually, I take that back a little bit. In the latest report, the advisory committee did say, here are some best practices you need to take into account. And one of those things is what was raised by Senator Stewart's amendment, which is the accessibility to people who might have a disability to the meetings, the proceedings that are going on. And then the next layer of that is for the public to be able to participate. And you need to make sure that the ability for the public to participate is there across the board. So I'm not sure what's the best way to start. I kind of think of remote participation as figuring out what that means, and then moving on from there. But hopefully this helps you have a discussion about this, because I think this is a discussion topic. I don't think this is necessarily a yes or no, but it's, if you think you want the statute to authorize this, because I think the statute does need to authorize it for it to happen, then how do you do that?
Thank you. I see a whole bunch of hands up, and I'm first wondering if there are specific questions for you, Peggy. So let me just check in before we kind of launch into that bigger discussion. Representative Babbage, did you have a question specifically for Peggy?
Yes. Am I on? Yes. Well, yes, and a clarification. Great summary. And in the one 28th, Senator Keim and I did a deep dive in this, but we also inherited it. It was old news by the time that we got it. So Peggy's familiar with the long history of all of this. Although we're very specific in trying to, and actually the rest of the Right to Know Committee was exasperated that they were going over this again with us in detail, which they did. I just want to say, so we have issues to determine, like quorum and so forth. I just wanted to say, in the amendment that I had from that bill that came out of the 128th, if the public body had 3 or fewer members, it would be a quorum of 1 at the location. I mean, physical presence at the location where they had been noticed that there might be public there, and then the final thing, I think with all of the previous right to know recommendations too, they wanted to make remote available, but they didn't want it to be used in a litigious manner because it had as a final thing, failure to comply with the subsection does not invalidate an action of the body. Meaning that if they need to meet remotely in order to accomplish something, that what they're achieving to accomplish is not in jeopardy. There might be other consequences, but it wouldn't be that they wouldn't have been able to act as a result of it. So I please understand the reason that my amendment is sort of predates some of the other proposals, which are much simpler. But please understand that remote participation was seen as illegal, and yet it was being practiced in island communities that didn't want to have to take a ferry in order to get to a meeting for an hour and a half and then return and go through that difficulty. So understanding that people were using remote and that technically, according to the letter of the Attorney General, which is the closest thing to the law that we had at the time, it was prohibited. Then the Right to Know Committee said it's the Wild West out there. We should provide some guidance. So knowing that people really wanted accountability and for people to show up at meetings where they could be confronted by the public, because we had an awful lot of agencies with out-of-state members who would mail it in from elsewhere, and people thought that was technically an abuse of their position to never show up in Maine to be part of the agency. So, and in the island communities, the reality is that also because they need people to serve on boards, but sometimes those people on the boards are living out of state for a good portion of the year. So it's a complex issue, but the proposal was to navigate an area where we could have remote participation, but not encourage it and not take away accountability to the people. It was permissive. Now, I think COVID has changed the attitude about all that, but we've got to make a decision as to how permissive is it going to be, because my fear in this process, even though I'm pro-remote, is that if I'm a public official, I would love to meet privately without the public observing me. I'm not saying that as a statement but I'm just saying for ease and efficiency, if we can get by without accountability, of course bodies are going to do that. I'm a member of a condo association.
Representative Babbage, I'm just going to ask you if you can wrap up, just because we've got a whole bunch of other people who want to weigh in.
That as a condo board member, if they act among themselves without public scrutiny, that's not what a public official should be. So that's why my amendment dealt with public officials, not appointed boards, but with elected officials. Thank you.
Thank you. That's great. And let's, I think Senator Keim, you're next. Did you want to either ask questions of Peggy or weigh in? I know you're familiar with this issue as well.
Yeah. So first, Peggy, where do I find the amendment to LD 32?
The amendment to LD 32 is attached to Senator Stewart's testimony, which is posted, and I can screen share it if you want.
No, that's all right. I can print it. Yeah, I will look at that. And then, so just to piggyback on everything that Representative Babbage was saying, I definitely, we did talk about this ad nauseum years back when it was considered illegal and a really bad way of conducting public business. And so my my leanings are much towards the protections that Representative Babbage has presented in his bill, and to not allow remote participation to be wide open. I don't think it's in the best interest of the people for us to just open it wide up. So I'll leave it at that for now, but I'm definitely leaning towards trying to put protections in place so that people know what's going on, that it's transparent, and that they have access. So there's a lot of elements in Representative Babbage's bill that I feel strongly we need to incorporate.
Senator Sanborn?
Thank you, Senator Carney. So I'm going to just articulate, I think, what is somewhat the opposite leaning and the opposite inclination. Just that I think, and I appreciate that I wasn't on the Judiciary Committee in the old days when this was a different conversation, and one that was not informed by 14 months of experience. Whatever you may think of Zoom legislature, and we can kind of set that aside, because I actually want to talk about what this means for participation in municipal boards in particular, and municipal town city meetings. City council meetings in Portland have become incredibly more transparent and incredibly more well attended and more available for public input and comment. As someone who has been in person to a number of city council meetings over my life, but who always really dreads it because you have to sit through hours of discussion on topics that are not pertinent to what you're there to listen to. You can't be at your house. You can't be out feeding your cow like Representative Evangelos is during Zoom legislature when we take breaks, or when you know that your topic isn't being discussed yet. So as a member of the public, and thinking about the accessibility, the accountability, and the ability to give input and just watch what's going on in real time, the availability of live streaming and of technologies like Zoom that allow live participation with video and audio throughout the state has been a game changer. And I think it means that all of the original sort of sense of dread that the Right to Know Committee might have been operating with, and the Judiciary Committee might have been operating with 2, 3, 5 years ago with regard to public participation, and I'm speaking just to that public participation piece at the moment, it needs to be reconsidered. We need to learn from the experiences that we have had over the last 14 months. And I think that it's one of the great gifts that we're going to come out of this pandemic with, is a better understanding of the fact that we can have better accountability for our public officials if we force them to stream their meetings and allow for in-person or allow for a remote participation, rather than making us all get childcare or miss dinner, miss lunch and dinner, miss work, not be able to go to bed because you're waiting for something to get heard in City Hall, and you have to be physically present in City Hall in order to participate. So I feel really strongly about that. And I really hope that we don't include the provision that requires this to go out to referendum in every single municipality or constituency around the state. I think that would be a waste of time. And I hope we don't do that.
Representative Libby?
Thank you, Madam Chair. I have significant concerns around transparency, and I appreciate that some folks experience, and mine, I've had good access to some meetings, others not so much, but I have heard from a number of folks, one just yesterday who has not been able to access school board meetings for the last 2 months and can't get an answer as to why. And this has not been an issue with this one person, but with multiple people. So I applaud the municipalities that are doing it well, but I'm very concerned about making sure that this does not give a free pass, that, you know, if folks can't access a meeting, that things can just proceed in that manner. Maine citizens should be able to have access to every, you know, municipality meeting. You know, when they're not in executive session, Maine people should have access. So I'm very concerned about technological glitches if there's not an in-person and remote option. I'm very concerned about that aspect of it. And I remain concerned even seeing the progress on these bills. I appreciate the need for remote participation in an emergency, certainly, but I don't want to see municipalities switch over in a non-emergent time to just doing remote, as that does leave some folks out. I was told by a fellow legislator that they were unable to access our meeting, and they had wanted to testify on a bill. They were not a sponsor, but they were wanting to testify and couldn't get into our meeting. So I just would encourage caution and a lot of thoughtfulness as we go into this, because I do not want Maine people disenfranchised.
Committee members, do others wish to weigh in? Go ahead, Representative Babbage. Actually, Representative
I would like
Babbage-
to ask a question if I could.
Okay, go ahead.
I guess one of the things that I'd like to ask, I think every bill has had adoption of a written policy with after a hearing. I believe that's true. But the policy isn't what's being heard. What's being heard is input from the public, and then they adopt a policy. When it becomes time to have a meeting and there's notification, which is always true of a public meeting, for those of you that are for expanded remote participation, should there be a requirement that somebody attends in person at a place designated? Or can the entire meeting be remote at everybody's home? I mean, that's a basic question is there still going to be, after COVID, after a civil emergency, a public place where there will be a meeting for the public to go and somebody be there on the board? Or are we going to go in a direction to allow full remote control? I mean, full remote, not remote control, but full remote participation as we are doing these meetings.
Thanks, Representative Babbage. That was a good question and well framed. Go ahead, Representative Evangelos.
Madam Chair, just a comment. Cheap shot noted, we can't even talk, off session about a cow without it being entered into a criticism by a senator. So not appropriate.
Senator Sanborn, did you want to respond?
Not at all a criticism. It was actually it was not at all a criticism, Representative Evangelos. It was actually meant to be a feature and not a bug of what we are doing here, which is to say that you can use your downtime when you are not needed or when we're on break. You can use it to do useful things, like take care of your kids or take care of your cow or take care of eating dinner. That was absolutely what I meant. And so my apologies, sir, if that was not taken in that way. It was not a dig or anything at all. It was actually meant entirely to show that we have lives and we need to be able to use remote technology in order to make those lives work more efficiently and better. And that allows us to participate better. So I apologize if that wasn't understood, Representative, but that was absolutely what I meant. I meant it in a very positive way.
Representative Moriarty? Representative Moriarty, I think you're still muted.
Still was, sorry. It's clear this is an extraordinarily complicated issue, and I wonder if we might give some thought to reaching agreement on some basic principles, and then from them derive more detailed procedures and expectations. My starting principle is that in-person meetings ought to be the expectation, but not necessarily the rule, and that the governing body of each city and town has the authority to determine for itself when and whether to meet remotely, and if so, on what terms. I do think that if the body chooses to meet remotely, then it has to, as the amendment to LD 32 indicates, there has to be the availability for public observation and participation. Mayor Snyder told us that that has worked wonderfully for Portland, the largest city in the state. I don't know how they do it on Zoom with such a large population in attendance, but they apparently have done that, and the MMA reported that statewide it has worked out very, very well. So we know that it can be done. The technology is beyond me, but again, my starting point is that bodies ought to continue to meet in person, and that ought to be everyone's expectation, but they may have the authority to decide otherwise.
Thank you, Representative Moriarty. Representative Poirier?
Thank you, Madam Chair. And just piggybacking on Representative Moriarty's comment, there are some smaller towns in Maine that don't necessarily have the capabilities that larger towns do as far as broadband access and that sort of thing as well that we need to consider. And the aging population in Maine as well. There are some folks that like to participate in town government. And I can tell you from personal experience, I have some friends that are 88 and 90 years old. They don't use the internet, but they do participate in their town meetings. Pre-COVID, they would go to every town meeting, every town event that was there. They were very active, but since COVID, they haven't been able to do that. And it's really taken away from their community involvement. So if it was an option for a community to just do remote, you're taking away from a big population of people. So I think it would be very important to still have a basic understanding that you're still in non-emergency times, still have that meeting, but if you're looking to increase your involvement, have that option of having remote participation in addition to. I'm on SAD 54 school board, and we do that now. We have in-person availability. People can come into our gym and participate in our meeting there. We're all there more than 6 feet apart. But we also have the option of people both on the board that aren't comfortable coming in yet because of COVID, or if people in the public want to participate via Zoom, they can do that as well. So you can do them both successfully. And I think that's more of a model that we should look at versus giving an option to just do one or the other, because you would be excluding what could be potentially a large group of people, especially when you're looking at an aging population.
Thank you, Representative Poirier. I'm just going to keep calling on people, but if somebody who hasn't voiced their opinion raises their hand, I'm going to jump over those who have already spoken to the person whose voice will be new, just to let everybody know. Go ahead, Senator Keim.
Thank you. I think agreeing on certain elements is important if we can. And one of the things that I appreciate, I think Representative Babbage and Moriarty and pretty much everyone is saying is, or at least I'm saying, is that I is what I'm hearing is that we have a location for people to go. And I think that part is important so that we have some sort of hybrid model that if, you know, if it's a board of 3 and the one person has to be in attendance at a location, I think that's really helpful because that gives a spot for the people who can't participate remotely to go. And I do appreciate that, you know, if it's a bigger municipality or a more tech savvy body, whatever body we're talking about, because that's another consideration we're going to have to take up. The idea that they're broadcasting is great. You know, I would love to say everyone has to broadcast every public meeting on to something at this point, right? Because the availability is there and it increases transparency. So I don't think that it's one or the other. I think we can definitely just, you know, the broadcasting part is great. And I agree, we have to have some sort of remote participation, but I think it's important to have a place that people can go. And I like the idea of including that as a stipulation.
I'm just going to interject a question because I appreciate the desire to have a place, and I'm just curious as to how that would play out in a snowstorm, or if a bridge washed out and the town hall couldn't be accessed, or, you know, would there always be a place requirement, a physical setting for the meeting, or would you want there to be like an opt out in emergency situations? Representative Poirier?
Just in that sort of situation, like a snowstorm, I can tell you with my community's town meetings or school board meetings, generally it's postponed. That's never been a big deal to postpone a meeting. And people are able to reschedule. So I don't think that is a huge consideration. I mean, if you're talking about a flood and a bridge is washed out and it's going to be weeks and weeks and weeks, that maybe that's considered an emergency and that could be treated a little bit differently. But I think when you're talking a snowstorm, that's something everybody in Maine's pretty accustomed to, and things are rescheduled for things like that all the time.
Okay. Let's see, Representative Harnett, you're a new hand to the conversation. Go ahead.
Thank you. And I find myself agreeing with parts of what everybody is saying. I mean, I think number one, we have learned that the technology can work when it's working, but I'm sensitive to Representative Libby's concerns that there are parts of Maine where it's not working, and that can deprive people of their access to government. I spent a lot of time talking to my municipal officials because I used to be one, and looking at the study that was done by MMA and the positive responses from municipalities around the state, even those that did not want remote participation, but have found out that it does increase public participation. So yeah, I think we have to take advantage of all of the technology that is possible and available to use. In addition, though, what I'm hearing tonight that I really didn't think of that much is that, you know, it's not one size fits all. There are people that need a place. They want to go to a thing. They want to go to City Hall and have that fixed location to attend that meeting. And I don't know what that looks like when there's maybe one select board member sitting there, and I don't know if it's going to be a large screen TV with everybody else. But I do think we need to make government accessible in ways that work for everybody. But again, I'm a big believer in using the remote technology, but I'm being convinced more and more listening tonight that we can't rely exclusively on that. There are some people that can't get it. There are some people that don't like it. And there are some people that don't feel like they are participating in their government when they go to a meeting that way. So I do think we have to look beyond a one size fits all. It's going to be different in every community, but You just have to make sure you're not shutting a single person out of participating in their government. So, thank you.
Representative Harnett, can I just ask you a follow-up question? 'Cause some of the bills before us do require municipalities to kind of make that more, or bodies, I should say, to make that more individualized assessment of what works for their communities by adopting a policy. Do you feel like there should be kind of limits on that policy such that a body could adopt its own policy, but the policy would have to have some kind of physical locus of a meeting in non-emergency circumstances?
I guess I do, and I think that goes back to Representative Moriarty's observation when he said in-person meetings should be the expectation. Because I do believe, and again, I'm not demeaning the technology because I think it's done wonderful things and increased participation in lots of places, but you have to reach, you have to make the opportunity available to every member of the community. And I suspect that in all communities, there are people that like to be at a place, and I would not want to shut them out of that opportunity. So maybe, yes, municipalities and individual bodies can develop their own policy, but we need to set some floors into what must be in those policies. So yes, I would be open to that. Does that respond to your question?
It does. Yeah, thank you. I just wanted to probe that a little further. Representative Reckitt and then Representative Thorne. Oh, Lois, we're not able to hear you.
Like Representative Hartnett, I've been interested and engaged by this discussion and have heard some things that particularly I thought were particularly important. Representative Poirier's presentation of the school board issues in her town, I found particularly telling. But I also I'm in the city next to Portland, and our city council has been meeting remotely for a long time here now. And I have participated several times, which I never would have if I had to get back from God knows where or off a Zoom call in time to do it. So for me and what I've observed by the numbers of people participating, I think we're having a similar experience to Portland's, only on a smaller scale. But I'm worried about the island communities and a policy that would require somebody to be someplace that's a fixed location. If we're talking about a government entity that covers multiple islands, I think that's not a realistic piece. So I think there's going to have to be some entities that have to have a strange exception. And I would think we have to at least talk to the island communities about what might work in terms of policy. So, but I'm in agreement, we should require that people have a policy. And I think there should be a floor. I just don't know where that floor is.
Thank you. Representative Thorne?
Thank you, Madam Chair. I appreciate everyone's open discussion. And sometimes in talking these things out, things come up, and my hand's been up and down about 3 times tonight. But everybody's been coming close, but quite hasn't hit on the unintended consequences of this. And there's unintended consequences, I think, both ways. And then that is that, one, a committee may say only remote participation and cut it off to public, actual in-person participation, which would be a way to abuse it. And then the other one would be, as Representative Galgay-Reckitt said, having people participate that wouldn't ordinarily participate in an in-person venue, i.e. an island, somebody that doesn't live on the island, somebody that's not on the island, but they can Zoom into the meeting and participate and be an overbearing presence. So those are a couple of the unintended consequences I think we need to watch out for. That was all I wanted to say.
Thank you, Representative Thorne. Yeah, and I would add on to what you and Representative Rickett just said is I think a lot about parents. When my kids were, gosh, even through high school, our evenings were so busy that it was just, you know, I could have participated in a remote meeting, but I wasn't able to go to any kind of a school board or town council meeting, you know, during the school week in the evenings. I'm losing track of who's next, but go ahead, Senator Sanborn.
Thank you, Senator Carney. I just wanted to say that I also, so I think there are a number of different elements that we're discussing simultaneously. And I know Peggy wanted to kind of try and help us untangle those. I would love us to try and help untangle those. And let me introduce another element that I don't think we've even begun to untangle yet, which is that not all public meetings or meetings that fall under the public right to know law are ones at which public participation is part of the meeting. And so I'll give you an example. I ran a task force that was set up by a committee of the legislature several summers ago, and on healthcare. And we decided to have subcommittee meetings. There was just no way we were going to accomplish any of our work if we couldn't do those by conference call. It was just 4 of us. We were in different parts of the state. We needed to meet, you know, twice a week for several weeks in order to get through some work. Those are all public meetings. They have to be noticed. So we noticed our conference line. We took the gamble that was perhaps illegal, but we noticed our conference line. We sent that out to the interested parties list. We said, if you want to listen in, you can, but you won't be able to participate because this is not a meeting at which public participation is part, but it's a public meeting. It's open to the public. You can observe what we're doing. We're going to do it on the telephone. And we did that. It's probably not legal, perhaps, to have had those meetings. And we want to make sure, I think, that we can get good work done by policymakers and that we don't let the public right to know that a meeting is happening and know the substance of that meeting interfere with our ability to actually get the work done, provided that there's technology available, which we know there is now because we're all on Zoom and we know that people can be listening and can be watching, or we can be streaming it through to YouTube if they're not participating. So I want to make sure we're separating out those meetings where public participation is part of the meeting from those meetings, often much smaller or more informal meetings where they're still considered public meetings because we have a robust public meetings law in Maine. And I want to make sure that we're not being overbroad here. We have this robust public meetings law, but it's solely so the public can know. It's a right to know. And the technology that we have available now is so much better than just posting a note that says, we're going to be in this conference room. You can come awkwardly sit in the corner if you want. This is real right to know what we're doing on YouTube right now. So I really encourage us to make sure that's an element of the conversation that we are having as well. I also want to point out that there are some non-elected official sort of meetings that may get swept into this discussion as well. And I just want to make sure that, you know, when we're thinking about other types of volunteer service that people may do, that we're not imposing requirements that they drive and that they meet in person in places where they may not be able to do so, whether it's because of an island situation or whatever else. Again, where do we draw those lines about what types of meetings we're talking about, what types of bodies we're talking about? Because I think we can actually do much better to have a single state. We have this big Maine. We often talk about the 2 Maines. If we want to have a statewide board and a statewide discussion, it's going to be more efficacious to have those discussions in many circumstances on policy matters if we do so virtually rather than asking folks to drive to Portland or Aroostook County to meet together in person. Thanks.
Thank you, Senator Sanborn. Representative Babbage, I think you were up next.
Okay, thanks so much. I find myself in the unenviable position of not having any allies 3.5 years ago when I was rooting for remote participation, and now just wanting to have some safeguards for remote and still feeling in the minority. But I did want to, I think there are 7 or 8 things here. Are we talking elected versus appointed volunteer / volunteer? Are they the same, or should there be different standards? Do we agree on notice and public hearing and an adopted written policy? By the way, an adopted written policy can be mandated now, and it's not a state mandate, in my opinion, because it's permissive. Right now, remote is prohibited. So we would be permitting them to go remote if they chose to do so and adopt a written policy. But and if they're elected officials, do their constituents get a chance to weigh in on the policy? I mean, it's an educational piece, if nothing else. Remote in executive session, physical presence at the location, quorum. Those are the things that I'm thinking about. With regard to what Representative Moriarty said, I appreciate the in-person expectation. He said a governing body could decide for itself. That scares me a little bit, in that if it's an elected body, them deciding to go remote unilaterally without any kind of constituent approval worries me. And secondly, LD 32 was a streamlined bill. I thought it was good by the sponsor, but he said, but again, elected versus appointed perhaps, but he said, if the body should allow the public to participate. That sent shudders up my spine. Could an elected body only permissively allow the public to participate? That in that wording seems to allow that. So those are the flags that I wanted to share.
Thank you very much. Representative Reckitt and then Representative Moriarty.
I'll try to be brief. I just realized that there's a topic we have not talked about, and that's the impact of remote accessibility on those of us who are in some way or other disabled. Most of you have watched me tool around the Civic Center with my quasi walker, but what most of you don't know is I have MS, and it interferes with my ability to walk, and it interferes with my functioning when it's really hot out, or if it's really cold out, or it's late and I'm tired or whatever. And so the reason I've been able to participate in council meetings is because I haven't had to go out at night, drive myself in the dark to City Hall. And so I felt like I could comfortably participate. I'm certain I am not the only one in the universe of people who might want to go to meetings that has some kind of issue. I just don't walk well anymore, and it makes it difficult. I could get around fine, but then I'd have to have somebody with me to haul things around so that I could make, and as it is, I hit one of the security people to bring my walker in from the car, so it's a really, I think it's an important piece. And particularly today when we were listening to the folks talking about people with disabilities who are deaf, there's a whole broad range of people with difficulties. And I don't know how you deal with that either, frankly. I mean, in my case, it's a simple thing, but in the case of somebody who has a sensory disability, then it's going to be difficult, and you're going to have to decide whether or not your city is going to provide interpreters or whatever to let other people participate. And the practice in the organizations I've been around is that they ask people if they need that kind of assistance. Well, that puts you in sort of mark a cane on you in a way, and you feel like you're causing the town to spend money on you, to do something. I haven't had that experience, but I'm projecting that some people might feel intimidated because they couldn't participate as effectively as others. So I think it's we just have to keep that piece in mind. I think that people have to make some kind of piece of their policy be informed by the fact that not everybody is 100% let's go kind of people.
Yeah.
Thank you.
Thank you, Representative Rickett. So committee members, we've been talking for almost an hour, and I know it's late and we have an early morning tomorrow. I think that we should, we've generated a lot of food for thought. I kind of think that we should have a couple of final people weighing in who haven't weighed in yet. And then perhaps we should adjourn and think about this a little bit more and put it on our work session schedule for a couple of days from now. And perhaps there's some work that we can do in the interim. I think we've identified I think probably most of the issues that we need to address. I'm sort of in my mind coming up with a clearer idea, but let me just call on Representative Sheehan and Representative Evangelos. And then if folks are comfortable with kind of wrapping up for the evening, I kind of feel like that's where we should head. Go ahead, Representative Sheehan.
Thanks, Madam Chair. And thank you, Lois. That was something I was thinking a lot about, as I've heard from quite a few constituents that they have benefited from remote participation. But one of the things that I've been thinking about is just to sort of complicate the elected board versus volunteer board. There are boards that are neither elected nor volunteer, like the Public Utilities Commission. And I just think that accountability is really important.
Thank you, Representative Sheehan and Representative Evangelos.
Thank you, Madam Chair. Along the lines that you suggested, which I agree with, I just want to tell you why I feel that way. I think Peggy said it best. The train has left the station and the events on the ground have moved faster than our ability to create policy around it. And, we don't know what's going to happen. We are all assuming that we're going to go back in January, but I don't think it's going to happen. And COVID could go on for 5 years. So we need to develop policies that, take that kind of eventuality into consideration. So I agree with you. That's the reason why I'm not ready to move on any of this. I just think that we haven't even envisioned where we might be going. Hope it doesn't happen, but whatever policy we develop has to take that into consideration, and in all due consideration that I still want to meet in person when we can, small towns and the like. Thank you for that.
Thank you. Anybody else want to make some final statements before we wrap up for the evening? Go ahead, Representative Moriarty.
Okay, final statement, just to take home with you. Think in terms of our building a framework of a structure, but not completing the building.
Yeah.
Not completing the interior. We have a very strong tradition of local control. We don't want to micromanage the 450 plus municipalities in the state of Maine. As Representative Poirier indicated, there are some that just really cannot feasibly undertake electronic participation, and I respect that. So we shouldn't impose that on people, on communities. So think of our job as constructing a framework primarily for municipalities. And I would suggest that if the executive director hasn't begun to tackle this issue already, that decisions regarding the operation of the legislature perhaps should originate with the executive director's office.
Thank you, Representative Moriarty, for that. That's a good visual for how we should think about this. Now, I guess, any other final thoughts?
I would like to say something.
Really quick, Representative Babbage?
That's usually the predicate that
I
precedes.
know. You've had a lot, you've had the floor a lot.
I will just say, I think municipal participation is our charge to deal with here. The legislature has never permitted remote. We still don't. We've never met and passed a bill remotely. So, and the PUC was the subject of a lot of discussion in the Right to Know Committee when I served on it.
Representative Babbage, I'm going to
I
ask
just
you
want to
to-
say, though, those state agencies have grandfathered policies that open up a can of worms should we also deal with state agencies in addition to the executive, the legislature. So it seems to me that what we're really talking about is local government. And that's what I think we should focus on.
Thank you so much. And I'm going to turn to my co-chair here, Representative Harnett, and we are going to pause our conversation here. Do we need a motion to table? I believe that we technically opened the work session on LD 32. We are going to take it back up later. I don't know that we need to conclude with a tabling motion. What is your feeling about that?
When in doubt, make a motion.
All right, go for it.
I move that we table the discussion on all of the work sessions that are open right now. I guess we're in LD 32 is where we started. So I move to table.
And there's a second by Representative Evangelos. Committee members, let's do our same raising electronic hands if you're in favor of the motion to table.
Madam Chair, I'd like to thank the analyst for this amazing work that she has done here with us.
Well, 13.
13. Thank you. So the
I can't, actually, it's going to have to be 12 because Senator Kine has to be on camera.
Okay.
Sorry.
That's okay. So the tabling motion passes unanimously among those present and on camera. And so committee members, I would just ask that you, if you can write down your thoughts thinking about the framework and where we go from here so that when we resume, we can kind of pick up where we've left off. And I would also just ask us all to express gratitude to Peggy and Soupy for working so late tonight and also for all the excellent work on the remote meeting. It's a difficult issue and you've helped us tremendously. Thank you. And with that, good night, everyone. Thanks for all your hard work.
Good night now.
Good night.
Thanks to
Thank
all of you.
See you soon.
See you real soon.
Yes.
Keep smiling.
I'm going to a remote meeting. Bye.
Bye.